Great pleasure and honor to welcome you all this morning, this afternoon, wherever you are located right now. Very happy to be here, obviously chairing this event, this workshop. My name is Eckhard Ernst. I'm with the research department of the International Labour Organization. I wanted to just quickly open up before I give the floor to my distinguished panelists here and panelists in the online, the kind of the background to this technical workshop. So as you might know, the ILO has been working on issues around the digital economies for several years now. We have issued major reports on platform economy, on artificial intelligence, and as part of our effort to the Centenary Declaration, we also issued several background papers on this important issue and how this affects, according to our analysis, the world of work. So we are reaching a stage now where we want to reflect a bit more on the regulatory developments that are happening right now across the world, specifically on artificial intelligence, but maybe more broadly also on the data economy. And the idea is really today to kind of bring together expertise around the world to exchange information, to exchange insights on how these regulatory developments are likely to unfold, what are the dynamics behind these, what are the push and pull factors, if you want, and obviously, most importantly, from our perspective, what do we expect these developments to mean for the world of work? So we conducted, together with my colleague here, Professor Phoebe Moore from the University of Essex, and her research associates, we conducted a series of interviews, and we wanted to present to you the first outcome of these interviews, but we want to also see, together with our experts here online and in person in Geneva, how we need to kind of maybe rethink some of the conclusions that we have, and how can we kind of develop these ideas and these insights that we have gathered so far further into a broader research agenda. I think that's really what's behind it. It's a technical workshop, just to insist on this point. It's the fact-finding, ideas gathering workshop, and we hope obviously in a few weeks' time from now that we will be able to share in a research report with all of you the insights of this elaborate exchange that we have started now, I think, since the beginning of the year. And then from that onwards, we will have a further discussion both with our partners inside the organization, inside our constituents, but also broadly with the research community worldwide. And so I wanted to invite all of you also to really actively participate today. It's a long day. We have very intense discussions, hopefully, and I would like to invite all of you to kind of participate, whether you're in the room here or online. I know it's challenging to do this hybrid, and I know a lot of people will jump in and out because you have other obligations and other commitments during the day. But while you're here with us, please do exchange, do engage, and share your insights and ideas with us, so that we can actually make sure that we leverage all your intelligence for our own research. And with that, I wanted to hand it over to Phoebe, who will give a bit more technical introductory remarks before we then have our first panelist to share his ideas. So thank you very much for all of you, and looking forward to a very productive and interesting day.
Testing. How's that? Okay, it's all right. If I am here, is it all right? Or it's not loud enough? It's okay. Okay, thank you. Thank you very much, Eckhard. And thank you to my amazing team who you will be hearing from today. And thank you very much to our speakers, most of whom we've involved already in the project in the context of interviewing experts for better and deeper understanding of the issues that we're facing, and we've outlined as part of our research agenda. So the reason we're doing this is I think we're convinced actually that there's a growing rationale to actually document and to compare countries' approaches to regulating the use of artificial intelligence and other technologies. And we're convinced that we should start looking at the approaches to developing artificial intelligence and related innovations via investment and via various orientations to business. And we also think it makes sense to look at the resulting governance and the societal responses, where civil society, stakeholders, and beneficiaries are involved and impacted. Now, there's no single regulatory instrument in existence yet, which deals with technology, nor data, nor labor, individually speaking. And so as a result, we think we need to look at what might be in a position to address the kinds of risks that emerge with digitalization and artificial intelligence as it is applied in the workplace. So we thought it makes sense to start with, in fact, artificial intelligence policy, whether in the hard or in the soft law domain. Bearing in mind, we have a draft Artificial Intelligence Act in the European Union. Now, this is the only one in existence, which has potential implications globally at the hard law level. But in the context of this being the only instrument, as it were, there are a lot of other kinds of responses internationally. So we're approaching this to look at emerging economies, advanced economies as well, and also developing nations. So we're interested in making a holistic set of commentaries where we can identify variations to approaches in the integration of starting with artificial intelligence, starting with the technology itself. We think it's important to do that because it is not just AI, but there's a range of technologies being trialed and rolled out, not only in where we understood in call centers, factories, warehouses, and in different kinds of industries and sectors, in transportation, for example, where we've seen it, but also in offices, hospitals, schools, and of course now increasingly home working environments, which is the new normal in a lot of occupations and a lot of industries. So technologies themselves, of course, do include narrow artificial intelligence, but also we see emotion analysis via sociometric solutions. We see text mining for sentiment analysis. We see cardiology imaging becoming partially automated. We see chatbots, of course. We see cobots, and in human resources in terms of people analytics. We see machine learning and advanced statistical modeling for decision making. So these things are very common. This is happening simultaneously to the rise in various approaches, again, to regulation, to governance, and also to intended development of various technologies in the jurisdictions that we've covered for this preliminary proposal. Now, there's a significant research arena also emerging simultaneous to the rise of these kinds of policies and to the increase in these kinds of technologies, which is a research agenda on algorithmic management. Now, this looks at many workplaces and many kinds of technologies. So what we're doing here with this in mind is our proposal for an ILO Policy Observatory on work in the digital economy. So this is a proposal to set up a one-stop shop that can deal with the kinds of regulation that is emerging, to deal with, as it emerges, the kinds of responses by civil society and from stakeholders and beneficiaries in terms of what may occur in terms of industrial relations, what may occur in terms of types of industrial strategies that emerge, as well as the development initiatives in these various jurisdictions. So this is India, Brazil, China, the USA, Canada, and EU so far. Where we're up to is we've got country reports and of course a jurisdiction report in terms of the EU. And what we're doing so far is to provide an overview of the regulation, as I said, to identify the diversity of approaches and to think about what the differences in governance outcomes may look like in terms of decent work, and then reflections upon this for the world of work. Now, technologies in workplaces are not only used for the kinds of electronic performance monitoring, the things you see in headline news, but also, of course, are used for specifically occupational safety and health preventions as well at various levels, and wellness initiatives too. The reason I mentioned this is in part because this is part of the last book that I published, Quantified Self and Precarity Work Technology and What Counts. So this provides an overview of the various kinds of technologies. And what we're doing now is updating this to say what is occurring in terms of regulation and what are the implications for the world of work. Okay, so I've made a couple more slides and I won't take too much of your time, but to give you an idea of how we're setting up this potential project. Again, I've given you these areas of orientation, regulation, development, and governance, and then clearly in terms of the world of work. So what are the various approaches taken for regulation? And some of those will be discussed today very explicitly, of course, in the context of the different case studies that we are presenting. And with experts, we will get insights into what is occurring so far on the ground, and then we'll be able to think through the implications thereby. Now, as I said, we're starting with artificial intelligence, but we would like to start looking at other areas which will have implications, given, as I said before, there's no single regulatory instrument that can deal with all of the implications for the world of work so far. So in that context, we are interested in looking at data, privacy, of course, labor, and different areas of occupational safety and health. Now, this might occur in terms of what looks like in terms of potential global instruments, but at the moment, we're looking at what actually empirically is happening, and we'd like to keep up to date with that as this interesting set of developments unfold. Now, in terms of development, this is looking at what are the stated objectives for artificial intelligence in the variety of jurisdictions. And there are different arenas that are understood as having potentially more protections within society. We'll hear more about this today throughout the context, throughout the course of hearing about the different approaches in the different jurisdictions. But we're most interested in the objectives, which will have implications for, again, the world of work. In terms of governance, what are the emerging cases in each jurisdiction? What do they reveal about the interpretation of which areas of society merit, again, protection, for example, vis-a-vis data subjects? And these might be legal cases, these might be also other, and then looking at the governance section in the following bit. So this is whereby we're looking at a little bit more, and also, sorry, the regulation and governance arenas. So what this will look like in terms of what kinds of responsibilities are being placed in terms of who's responsible. For example, for keeping an eye on the technology. In the AI Act, we have the ex ante and the ex post, where we're meant to be looking at what the preliminary usage intentions are for a certain technology. And then, of course, later, what actually happens with the technology may or not be identical. So these things really matter. And this is why we have a kind of a historical we have a potential for an ongoing analysis, which has implications for what occurs in each pivotal moment historically and into the future. Okay, so those are our areas of interest. We've got methods here so far where, of course, we've told you we're looking specifically at policies as they're emerging. And as I said, there are different, there's some kind of the race to regulate, which comes out of Oxford Law Faculty as an idea. The race to regulate AI is with us. So we see, again, different jurisdictions increasingly attempting to do this from a kind of either a product dimension or looking more at the societal implications. And then in terms of the secondary literature, we're looking, of course, at the academic literature coming out of that, algorithmic management and other areas, as well as doing policy analysis. And of course, the semi-structured interviews, which we've already begun to carry out, which give us, again, insights at the local level. Okay, I'm not going to say too much more, but to give you an idea of what our ideas for the outputs from this project. So the regulation tracker. So this, if you look, for example, there are examples of this coming out of the International Labour Organization, where, for example, we've got trade law, labor provisions within trade, which is one website, which, if you're interested in seeing kind of the types of visualizations that we're going to try to be offering. And this regulation tracker is an instrument whereby we'd like to keep up to date very specifically with what texts are becoming either circulated for commentary or are being published as white papers. Again, this can be in the soft or the hard law domain, whereby there might be some engagement with the social partners. There might be some engagement with other, in terms of social dialogue. There might be other parts of interest in engaging different stakeholders to create intended policy, but there also may be policy that's being rolled out immediately as well. So we'd like to have a tracker that actually carries out various categories. And we've decided to use the decent work and, of course, the fundamental principles around decent work within the International Labour Organization's sets of regulatory mechanisms and perspectives and standpoints in order to identify where policy has implications for what decent work will look like. And I'll show you that in a second. And we'd also like to have research portals for each jurisdiction. And within this website, we would like to have portals whereby each jurisdiction, so there will be different academics working on the ground, looking at the rising issues around technology, digitalization in the world of work. So we'd like to keep this as a repository storage for that. And we'd also like to work with the local offices, potentially the local regional offices, to identify if there's specific expertise or interest in also the local universities where publications are being authored. So that's the research portals where we have preparatory case studies, which of course we're writing now. And we'd like a series of ongoing reports, as well as policy briefs and academic papers. And then the final thing is a heat map and a network analysis, which we'd like to have an interactive dimension to it, with information nodes potentially for each of the member states and their interrelations across policy fields, and then where briefs will be emerging from that. Okay. So of course, the tracking for decent work. So if you think about output one, again, if you think of this as a policy tracker, what this will mean is that promoting jobs and enterprise, guaranteeing rights at work, extending social protection, promoting social dialogue and occupational safety and health. Now, you might not have thought immediately that you'll find a technology regulation that may have some either provision or potential obstacle to these arenas. But in fact, we are saying that there are. And so we'd like to identify what those are, and we'd like to very carefully compare them and look at that with over time. We'd like to look at that with a dimension that helps us to understand what will happen in the post arena as well. So we can really start to think through the different parts of the world, the approaches to artificial intelligence regulation, governance and development, and to put some highlights right now on the potentials for and the implications for decent work, which gives us some very nice insights into what could be done in that arena as well. So thank you very much for all being here. I would like to open the floor. We have some time if we want to have some more comments from any of you or from the audience online. So thank you. Okay. So introduce the team. I can do it. Okay, I will introduce our team. So I will start to my right. Mariana Valente is here presenting on Brazil, and we'll introduce you in more depth later. You're part of the commission that is authoring right now artificial intelligence regulation in Brazil. Yes, in the Senate committee, right? Yes, and we'll introduce you more shortly. And we also have here Robert Donoghue, who is finishing her PhD at Bath University at the moment and working with us at the University of Essex and also in the International Labour Organization as one of our researchers. And we have Peter Bloom, Professor Peter Bloom, who is working at the University of Essex in the management and marketing. You're the head of managing and marketing in the Essex Business School. And we are lucky to have also Dr. Jamie Woodcock, who is also on our team here at the International Labour Organization in the research department. And he is working at the University of Essex, also in management and marketing in the Essex Business School. And Eckhard Ernst, Dr. Eckhard Ernst, who is working at the research department as the head for macroeconomics and labor policy and jobs. So, yeah. Okay. And you know that I am already Professor Phoebe Moore, working here at the International Labour Organization, of course, with the team. And I am based at the University of Essex. If there are questions or anything else that we want to pursue during, we have a bit of time, we can also take a small break before we begin with our next speaker. What do you like to do? Take a little break. Oh, open the floor first for any questions and then we'll take a short break. Any questions or things we would like to? Okay. Absolutely. What do we need to do for? Where do I find her question? Okay.
May I ask something?
Yes. Hi. Hello.
Hello. Yeah, hi. This is Professor Avinash from India.
Hello.
Am I audible?
We can hear you, yes.
Okay, thank you very much. So my name is Professor Avinash and I am a professor of law and director of Manipal Law School, Bengaluru, India. And my research is basically about the law and regulation of artificial intelligence and the data privacy issues. And in my law school, we are also running a center on the current issues relating to labor laws. So first of all, I must congratulate you and your team to initiate this exciting and much needed project, especially countries like in India, where more than 50 million people are engaged in tech-focused jobs, especially these niche areas. And in the absence of any clear regulation and rules and policies and framework, this large chunk of laborers, or we can say the people, they are entering into a slavery type of labor system where there is no social security, and the existing Indian labor laws and regulations are not giving them any relief. So things have changed very quickly in last 7 to 10 years. However, our legal and regulatory system failed to address the requirement of protecting these people. So I think that's a very much needed concept and the project. And from India, we would be very happy to contribute that how things are happening in India. And maybe that can be a good reference point for other developing countries also. Thank you.
Thank you very much, Professor Dadish. I hope I'm saying your name correctly.
Yes, you're right.
Okay. We really appreciate what you're pointing out, and I think you've given us some food for thought in the context of what we will be doing today. And we really appreciate your bringing this to the table. So the lack of social protections, the population density, and what we'd really like to talk to you more about this. We actually have a speaker who will be speaking to us on the India case in, I believe, at 10:15. At 10:15, we would really like to have you there to introduce some of these points as well. And you're going exactly along the right lines for where we'd like to look at, again, what are some of the obstacles for decent work and so on, and what kinds of responses in existence we can think about it. And we're very happy that you are you going to be able to come at 10:15?
Yes, definitely.
Great stuff. Okay, thank you. We'd like to invite you to bring those points up, particularly in the context of the struggles being faced. And I think also what you're referring to in terms of technical work, there are a variety of call centers, contact centers, and other kinds of technological requirements in the workplace now to do with digitalization and algorithmic management. We're very interested in hearing more from you. Great stuff.
Thank you.
Yep. Are there other points or questions? We'll take another question for sure. Thank you very much. Again, this panel is also, we're also here to take feedback from all of you to understand what kinds of things would be useful also for our project. And actually, so some other colleagues from our work in the digital economy group are here with us today too. So this is Uma and Janine, and we are at the moment discussing various things that might be needed in this type of domain. And there's been a discussion around definitions and so on. I think we're thinking through what terms are necessary in order to pursue this kind of research agenda. And I think this will help us to go back to the table and think what kinds of things would be useful and necessary. So also, if we could invite you to stay here throughout the day, and maybe you could give us a list of the types of terms that for you would be useful to think through, and the kinds of how we could provide something like that in the context of ongoing pursuits with this kind of proposal, as well as other projects within the wider group. Thank you very much for that. Yep. I think we'll end now and start with the next presentation. Thank you very much for being here. Thanks again. Great.
Hi, I will be introducing our invited speaker on China, Mr. Wu Han. He's a partner at King and Wood Mallesons in Beijing, China. He specializes in cybersecurity and data compliance and antitrust and competition law. He has extensive experience in providing cybersecurity and data compliance advice to multinational companies' offices in China in terms of China's compliance requirements. Mr. Wu has also published many articles in domestic and foreign professional journals, such as Journal of Cyber Affairs, China Law Review, and Competition Policy International. And he also participated in the drafting of competition policy and digital market. He authored a report for Global Legal Insights titled AI, Machine Learning, and Big Data Laws and Regulations in 2022. So we very much look forward to your presentation, Mr. Han, on the state of AI and algorithmic regulation in China.
Thank you, Robert. Can you hear me? Testing. Can you hear me? Hello? Robert, can you hear me? Hello? 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 Okay. Trying to, well, adjust my tools. Now is it better? Great, great. Thank you, Robert, for introduction. Well, thanks for Professor Phoebe Moore's introduction. This seems to be a very exciting project. Well, I have to admit that yes, indeed, the new technology is now changing our way of life, and there are a lot of concepts like non-fungible tokens, blockchain, and the meta universe, and all of these new concepts are combined by the new technologies. And artificial intelligence seems to be a good angle to to explore the different impacts in this new digital society. I think the artificial AI does combine the fundamental factors of new society structure, the data, algorithm, computing power, and even the knowledge of a grapher. So in China, AI is no longer a mere concept, but rather an appreciable technology that supports our daily life in a different perspective, like the facial recognition, in e-payment, and smart home application systems, and even in the neighbor scenarios where we understand that a few MNCs, I won't say a lot, but a few of the MNCs now are using so-called DLP, data leakage protection systems, to monitor the employees' performance, which is exciting but also suspicious. So the AI industry in China has benefited from various market advantages, such as amount of data available for machine learning, and also huge demands for market applications and strong policy support. So the Chinese academic of science recognized that 8 key AI technologies that have achieved breakthroughs and identified specific areas of applications, including computer vision, natural language processing, transmedia analysis and reasoning, intelligent adaptive and learning, collective intelligence, intelligent chips, and brain-computer interface. So the Chinese government recognized AI as an important component of national strategy and plans to establish an AI regulatory system. That's the plan. Oh, okay, sorry. Can you hear me now? Is it better? The AI is one of the 7 key areas of digital industrialization in the 14th five-year plan, and intelligent transformation will also be the focus of state-owned enterprise in the next 3 years. While aiming to strengthen the role of AI in supporting and leading economic and social development, the Ministry of Science and Technology released 7 official letters which demonstrate the state-level support for provincial governments to build their own national new generation AI innovation and development pilot zone. So since the 2020, the COVID-19 outbreak has also, as you know, revealed the unprecedented opportunity for the AI and big data industry. To respond to the necessary aids for prevalent pandemic control policies in China, algorithms are used in more fields, including smart courts and smart medical devices, and are also used more in our life. The DLP is one example. So due to the unprecedented needs for AI in the big data industry and immense data demands for machine learning, the lawfulness and the legitimacy of data has become the key legal issue arising from adoption of AI and the big machine learning. For example, as you know that we do have the personal information protection law in China, this law being effective in 2021, November the 1st. The personal information handler conducts automatic decision making by using personal information. If he should ensure the transparency of the decision making and the fairness of the results, and should not give unreasonable differential treatment to individuals in terms of trading price and other trading conditions. The PIPO also require the personal information handlers to conduct so-called PIIA, similar with the DPIA requirements under the GDPR. It requires the case handler to record the processing information as they are using personal information to conduct automatic decision making. The National Information Security Standardization Technology Committee, what we call the committee, released a notice on guidance for the prevention of AI ethical security risk to provide instructions to prevent AI ethical security reasons, regulating algorithm-generated recommendations for Internet information services. The guidance safeguards the national security and the public interest and boosts the sound and orderly development of Internet information services. So if we deep dive into the details of the AI regulation, the first issue we need to discuss is the ownership and protection of AI. So at the present, the companies in China mainly trying to protect their AI products by applying for software copyrights or a patent to claim the ownership of an AI algorithm and protect it from unlawful infringement. So according to the regulations on the computer software protection, this regulation is actually, govern and regulate the copyright protection for computer software in China. The AI algorithm, which in essential is a mathematical method that is developed and achieved through the use of a computer programming language, is definitely copyrightable and could be registered. But in practice, it's definitely more complicated than we imagined. The companies can go a step further and apply for a patent for their software invention to protect the design. But in practice, it's just difficult to explore whether the AI should be registered, because whether there is any inventory results from all those products. Actually, in the Supreme Court in China, sorry, not Supreme Court, the State Intelligence Property Officer released an announcement on amending the guidance for patent examination, while it tried to clarify the rules for examining patent applications in new business forms and fields, including AI. On October the 21st, the Supreme Court of China released its report, which recognized the challenges the judicial system is currently facing in new fields, including how to protect the AI. The report pointed out that a large number of new kind of disputes involving core internet technologies, genetic technologies, information and communications, integrated circuits, AI, and the platform economy industry emerges that is increasing, which creates more difficulties for the courts to identify complicated technical facts and applicable laws. But they're still trying very hard, trying to encourage the innovation of in AI, and trying to distinguish the difference of copy and innovation. One of the most important case recently is Shenzhen Tencent Computer System versus Shanghai Yingyun Technology Company. So in short, the plaintiff claimed that the plaintiff published an article on its website called Tencent Securities. The article stated in the end that this article was automatically written by Tencent robot Dreamwriter. So as the article was produced, the plaintiff used the software Dreamwriter to collect and analyze the test structure and stock market financial articles. And based on needs of different types of stockholders, readers, the Dreamwriter formed the article structure according to plaintiff's unique expression wishes. And then the Dreamwriter used the collected stock market data to complete the writing, published article just 2 minutes after receiving the data. So afterward, defendants published an article with the exactly same title and the content on its website, House of Online Know, and even with the same footnote that this article was automatically written by Tencent robot Dreamwriter. Well, this judgment is quite controversial, but the judgment made by Shenzhen Nanshan District People's Court held that the news is actually written by the Dreamwriter, the AI written assistant software of the plaintiff. Well, this actually article was under the protection of copyright. So the defendant infringed the copyright of plaintiff by copying the news. The result is very interesting because the court looked into the DreamWorks work procedures, like what this DreamWorks working procedures includes collecting and analyzing the data, writing after the trigger conditions are met, smart proofreadings, automatic distributing the articles to plaintiffs' platforms. In all these procedures, the input of data types and the processing of data formats, the setting of trigger conditions, and the selection of article frame templates, the setting of the corpus, and the training of the AI models are all selected, arranged by relevant personnel of Dreamwriter development team. So there is definitely human work. So the court found that the arrangement and the selection of data inputs, trigger condition settings, as well as the templates and the style selection procedure from the development team were actually intellectual activities and were directly related to related to the specific expression of the article. So in that case, it was only the result of the computer software running the established rules, algorithm, and templates. But the Dreamwriter's automatic operation is not for no reason or self-consciousness. The way that this software runs automatically reflects the choice of plaintiff's development team. So from an analysis of the generating process of this article, its impression is determined by the individual arrangements and the selection of the relevant personnel of plaintiff's development team. The expression is not one and only, but is original to a certain extent. This is the first time a Chinese court has heard a copyright dispute involving AI-created works, and also the first time it confirms the copyrights. However, with the rapid development of AI, it poses definitely greater challenges to Chinese copyright law and other laws. So currently, the outcome of such kind of IP cases involve AI are still be decided on a case-by-case basis. So in addition to the ownership and protection of the AI issues, we may have to deep dive to other perspectives like the big data issues. So for each of the AI systems, we will need the data to train our algorithms, to feed our systems. So how to protect, or who owns the data, how to protect data is one of the key issues in this AI regulatory system. So we do have the data security law in July 2021. We also have these measures for data security management seeking for public interest draft, as a supporting regulation clarifies specific issues in the field of data security management. And we also have these very controversial, measures called measures on security assessment of the cross-border data transfer of personal information. Well, all these measures provides different regulations on how, when you need all those data, if you're going to transfer the data to outside China, you may have to pass, if you reach certain threshold, you may have to pass the security assessments governed by the Chinese government. The National Information Security Standardization Technical Committee has also issued a series of recommended national standards regarding the big data services and systems. Since 2021, the government has enacted relevant data regulations in conjunction with the actual developments of their respective regions, with 12 representative provisions and cities such as Shanghai and Shenzhen. So, and also if we talk about AI regulation, we should talk about the personal information protection for sure, and also the automatic decision-making procedure. We do have 3 statutes setting forth the general principles of the personal information protection: the Civil Code, the PIPL, the Personal Information Protection Law, and the Cybersecurity Law. And we also, in addition to all those laws, we also have this recommended national standards of personal information specification. It provides more detailed requirements on how to use the data when we're trying to adopt our AI system, or even use the AI to provide automatic decision-making solutions. But the Personal Information Protection Law, released in August 2021, proposed to extend the legal basis of processing personal information as a comparator to the Civil Code under the Cybersecurity Law. The purpose is to adapt the complexities of economy and social activities. So in addition to the personal information protection, we should, as you know, that the information content management is another important topic. So we should also look into the AI algorithm in this field as well. The provisions on the network information content regulation is actually issued by CAC in China. It provides different requirements for providing content and even the content models, manual interventions, and user choice when the network information content provider publish any information by adopting personalized algorithms. The regulations on the administrative of algorithm recommendation for Internet Information Services was released to provide special management regulations on algorithm recommendation technology. The regulation puts forward specific and detailed requirements for algorithm recommendation services from the perspective of algorithm file lists and information content, and clarify the scope of algorithm recommendation technology. The regulatory principles and the rules of algorithm recommendation services, as well as the specific classifications, findings, security assessments, and other regulatory means. The specification of security assessment for machine learning algorithm is still dropped for comments. Well, it has several provisions for ethical and institutional measures, filling some gaps in national standards in the field of face recognition and biometric information from a technical measure perspective. We can see that in China, China issued the different, their plans on stressing the comprehensive governance of the Internet Information Service algorithm, proposing to use that 3 years to gradually establish a comprehensive governance pattern of algorithm security with a sound governance mechanism. As for the AI development plan, we do have a very comprehensive plan, which could be very ambitious. We have formed a specific plan for establishing a comprehensive legal regime of AI. So under the State Council of New Generation AI Development Plan, the state government intend to initiate the step lawful and ethical policy system of AI regulation by 2025. In October the 2019, the China National Information Technology Standardization Committee announced its plan to establish the AI technology subcommittee to encourage in providing national standards regarding the AI technology, risk management, products, applications, and others, which further demonstrates the government's determination in AI regulation. In October 2019, the Big Data Security Standards Special Task Force released the white paper of AI security standardization to propose an AI security standard system covering topics of foundational standards, data and algorithm models, technical technology and systems, management and services, assessments and products and applications. In addition, in August 2020, the committee again combined with the China, the CAC, and 3 other state ministries. They joined to release the guidance on establishing the new generation of national AI standardization system, aiming to setting up a preliminary national AI standardization system by 2023. Well, it tends to cover the national and the industrial standards in 8 fields, including foundational and genetic standards, fundamental technologies and products, basic software and hardware platforms, critical general technology standards, technical standards for critical areas, products and service standards, industry application standards, and security and ethical standards. So there are also many new released rules and regulations during these 2 years in several areas such as automatic driving, consumer protections, and finance. Well, I mean, I'm not in a very good position to introduce all those topics, but if we can talk in private, I can share more insights with you. So that's just my general introduction of the AI governance in China. Well, it seems that my equipment do have some problems. You may not hear me, soundly, but maybe, some other time, if my tools are ready, then I can provide more details. Thank you.
Thank you, Mr. Han, for your presentation. It was very enlightening and covered a wide breadth of topics. I guess now I'll just open up the floor for the remaining time allotted to you to see if there are any questions. I know I have a couple, but maybe somebody else would like to ask something. Okay. Oh, yeah, go ahead.
Yeah, it was a bit difficult to hear, but I think I tried to get a very good gist about what's been happening in China. I was just wondering whether a bit more detail could be provided about the national standards that was being discussed and how that is used for data and the AI systems. I thought that was quite important given the complexity that Wu Chan was talking about in the economy and the kind of activities that there are. So a bit more detail around the national standard would be very helpful. Thank you.
Sure, thanks for your question. Well, first, we do have a comprehensive legal system for data protection. We do have the data security law, the personal information protection law, and all those supporting rules. As for the AI regulation, the national standard will play a very important role. However, we're now at current stage, we're not in a position to provide a very comprehensive national standard for how to innovate the AI or how to regulate the AI. Instead, we provide we tried a lot to provide recommended national standards to address the ethical issues. Like before, during the innovation of AI, do we have to pass the ethical, ethical test? Do you have this AI ethical committee who will be responsible to solve the data protection issues, to test the AI's ethical issues? So those recommended national standards will help the stakeholders to organize internally to have this organization to regulate the innovation process of AI, and also help them to establish an internal system to understand what kind of factors should be evaluated during the assessment of AI. But so far, we don't have a very standards national, and we don't have a national standards provides more detailed ethical test factors. We do have this white paper, which provides actually the Cambridge Medicine was participated in this procedure, and we in this white paper, if you can see the white paper, you can see that we provide a table indicating different factors should be evaluated when you're trying to innovate a new AI system.
Great, thank you. I believe Professor Bloom has a question.
Can you hear me?
Yeah, I can hear you.
Oh, thank you. Oh, it sounds very loud. My question is how this also then relates, and I guess this goes on the other side of the kind of question about standards, about the kind of broader ecosystem of work that's going on right now in China, because China right now is in a very, very specific place with its rare earth mining regulations. And that has a huge influence because of the fact that the user demand for AI that is driving in many ways the rare earth. And right now, the regulations, as you may know, at least the draft that was put out in 2021 by the MIIT, was very much around quota sales and not disrupting markets. But there has been a large move by Chinese labor unions and by also unions around the world to kind of, can we actually create decent work for this? So I'm wondering in this sense, when we're talking about kind of these proposals for standardizing and protection, how much they're kind of linking towards the kind of decent work movements that are happening and the kind of beginning standards, because the Chinese government has said, particularly at the regional level, that they are wanting to look more at the question of work and workers, people who are actually producing the actual resources that are necessary for AI in this respect.
Mm-hmm. Well, thank you, Peter. That's a great question. So from my understanding is that the government, it will be very difficult for the government to provide a very specific guidance on how to protect the AI, because they are not very familiar what's going on in the market. They should be familiar. But as you know, that some of the AI systems are the core resource or the competing resource of the companies. They will feel reluctant to disclose the AI system to the government. So that's why the CAC, one of the powerful authority in China, they provide a regulation asking the so-called internet information services providers to register their important algorithm in the national system. So they will understand what's going on in the market, what kind of algorithm has been used in distributing different internet informations. They do have a certain threshold, right? So by knowing that what kind of algorithm the AI system has been adopted in the market, then they can deep dive to see, okay, you do have like 3 different core algorithms. I'm not asking for the code of these algorithms, but have you considered the data issues? When you're trying to use those data to train your algorithm, have you already obtained consent from the employees, from your customers? Do you know that you use this algorithm to profile them, to create a new profile and distribute various different content to them? And also, and most importantly, how, internally, do you have any organization, testing all those algorithms just in case there was any bias in distributing information? So I think that's the rationale of the authority. They just don't know what's going on in the market. So that's why what they can do is providing regulations on asking the market players register core algorithms. On the other hand, providing national standards, provide general principles for the market players to understand the bottom line of the AI for the AI regulatory requirements.
Thank you very much.
I believe, Edgar, did you have a question?
Yeah, thank you very much for your very interesting presentation. I had one question with respect to what you said in the beginning, and I'm not sure whether I fully understood. Maybe you can clarify regarding this litigation case about to whom belongs the copyright of whatever AI produces. And you mentioned specifically in terms of text processing. Now, as you know, text processing, automatic text generation has become really the hotspot of AI development in the last few years. And the latest developments looks like that some tools like GPT-3 or others kind of develop text that are almost indistinguishable from human generated text. Now, my question to you is, are there any discussions what that would imply if you give the copyrights to the software in terms of sharing royalties, for instance, from journalistic text or any other text that are partly generated by AI, for in particular for those people who actually provide these to draft these documents. I mean, if you think about a researcher producing a new book and part of the book has been written by a software, if that means that the royalties of the book would go partly or totally to the software developer, then obviously the incentives for providing or doing new research or writing new text would be totally dissipated. So I was wondering whether there's any discussion in China with respect to that particular decision. Thank you. We don't hear you.
We lost Mr. Han, so I guess the rest of his time is until 9:15. So I guess we'll just wait a few minutes and see if he can get back into the Zoom. If not, our next speaker is at 9:15 or 10:15.
I'm sorry that my network was just blocked for unknown reasons. I'm not sure whether I have already had the complete question.
I can repeat my question if you allow. So my question was in relation to one of the remarks you made about this decision by the Supreme Court of giving copyright of text generated by an algorithm to the software rather than to the person who inputted the prompt into the software. And my question was, if you think about journalists or any kind of person who generates text, and all of us, at least here, we kind of regularly produce text. Increasingly, part of this text will be produced automatically, and if that means that the software will own part of what we are writing, that would kind of obviously significantly affect our incentive to produce text. So, question is there any discussion in China about this?
Yes, thank you. That's a great question. Actually, has been, as I mentioned, the important case I quoted is quite controversial. Now, I do have the same concern that if the original data is actually generated by a third party, and the AI system is actually using the data to generate a new article, and if it can claim the copyright on this article, then it will definitely help to disencourage all those original content generators. However, from other angle of this issue, that you can see that in this course, they're trying to examine whether there's any intelligent inputs from the system inventor, right? So in addition to the data itself, whether the selection of data, the distribution system or rationale of data should be protected. So I think I won't say that it is a perfect case, but it definitely encourages to explore different balanced or more balanced way to provide or even provide copyrights to the inventor, or maybe in future to share the benefits, share the profits with the original data generator. I think maybe in future, although the inventor can claim the copyrights, but the context, if they generate any profits, should be shared with the original data contributor. I think that's just my personal idea. But yes, that's a good question. It has been discussed, but so far we haven't reached a very conclusion yet.
Any more questions from the floor, from Zoom? Oh, there is a question in the Q&A. Do you mind reading it out? I'm sorry, I just don't have it in front of me.
So we have one question in the Q&A, and maybe Mr. Han, you can answer that. How would an attribution of rights, including all persons that were sources of data used in the development of the AI, be implemented?
This is an even more difficult question, actually. Well, maybe we can invent an AI to help us to evaluate the contribution of the data. So, but still, that's a good question. Well, in China, we have been discussed the ownership of data as in other jurisdictions. According to the CAC, we now recognize that we will not talk about the ownership of data. Instead, we'll talk about the different rights, like who should be entitled to use the data, who should be entitled to process the data, who should be entitled to profit from the data products. I think that's at least that will help us to initiate a discussion of how to distribute the profit of data.
Okay, great. Any more questions? One question I had was, when we're looking at something like the Internet Information Service algorithmic recommendation management provisions from 2022, as you read through, you notice in a lot of the articles is new duties for algorithmic providers in relation to their users. Things like enhancing autonomous choice or consent requirements or opt-in, opt-out mechanisms. Can you speculate on whether that will impact workers on digital platforms, or is this more targeted at consumers? Is there any idea about what the implications of this would be in something like platform labor?
Sure. Well, thank you, Robert. And definitely, it has significant impact on the digital platforms, because now they need to first understand what kind of algorithm they're using in practice and systemize all those algorithms to see whether they have triggered a threshold. Well, according to the new regulation, only the algorithm that will be used to distribute internet information should fall in the scope of this new regulation. But it implies that maybe in future, anyone while using the algorithm that will be, which may jeopardize the data subject's interest, should at least have this internal interpretation indicating that how they have already bear in mind the customer interest in using or even innovating the new algorithms. From the labor scenarios, I think as I mentioned, well, some of the companies are now using the different AI algorithms to provide evaluation systems by using automatic decision makings, by using the different performance data. So in that case, I think maybe, well, I'm not saying that it is still in the early stage where the government will ask all the companies to provide the rationale of these algorithms and how the companies protect all those customer rights, employees' rights by adopting such algorithms. But still, in future, I would say that it is possible that the Chinese authority may adopt the same rationale like I just introduced. First, let me provide a threshold, and then asking you to register the core algorithm or automatic decision-making systems in front of the government, and then it is the company's obligation to convince the authority that this AI system will not jeopardize the employees' rights, or they have already notify transparently to the individuals, to the employees, and they understand the general rationale of the system, and they have provided so-called recovery solutions just in case this system will result in any bias or discriminations in practice. I think that's just my personal opinion. Yeah.
Another question? Oh, excellent. Thank you. That was a very helpful answer. And I think we are coming up on the end of our time, and we will be going to the next speaker in a couple minutes here. So again, we want to thank you, Mr. Han, for taking the time to speak with us and share your expertise. It's a very engaging presentation. And yes, I guess I will pass it back over to Professor Moore.
Thank you. Thank you very much. So we have 2 minutes until our next speaker, and we have Apar here. Okay, I'll quickly also explain the format for the day, which is of course on the website and which I think you've all had a chance to look at. So again, we have speakers who've already been involved in our project through interviewing and through discussions with us about thinking through what the implications again are for the kinds of regulatory mechanisms or governance approaches so far and what's emerging in those areas. And so we thank you very much to our speaker who's spoken to us about the China case. And we'll be looking at the different jurisdictions, those being China. Obviously, we have also a time zone rationale for the lineup. I think you probably interpreted this. We also have next on our on the agenda, we have Apar Gupta, who will be speaking to us about the case in India. And then we have Mariana Valente, who is with us today as well, speaking about the case in Brazil. And then we'll have a chance for the project team to, in a way, respond to some of the points that have been brought up by the various speakers, and also to speak about the cases that we've been working on ourselves. So this will be a chance for us to say specifically where world of work questions might be arising, and then also to give some of our own insights in the work that we've done so far. So we've got of course, after the first three speakers, we've got responses to China and of course, Brazil and India, as well as a chance for the project team to speak about our own work in looking at these three areas around governance, regulation, and development. And then in the second part of the day, we'll have the speaker, Blair Attard-Frost, speaking about Canada. And then, well, thank you very much for putting that up, Alessandro. And then Alex Engler speaking about AI in the context of the USA. And then Aude Cefaliello, who will be speaking about the European Union case. And some of the points coming out of their own insights, their own research arenas, as well as what's happened in the social, political, and economic dimensions in the jurisdictions in question. So is Apar now in the room with us? Oh, okay. And then, of course, we have our keynote speaker, who's Professor Peter Bloom here, who will be talking about the future around AI and regulation, protection, promotion, and possibility. And I think this is a really great summary in a way, and also future thinking around what it means when we have such a supposed technology that potentially has the power to transcend our own intelligence, which of course brings up a lot of philosophical questions and a lot of social questions that I think we can engage with. Because I think what's interesting about our project is that we're trying to, obviously we're in the technical phase now, we're trying to pull together empirical materials, we're trying to understand, because we are able to look comparatively at the different areas and what different jurisdictions, what governments are doing, and what they're in a way informing populations, and also globally having that engagement discussion around what is happening locally, but also, you know, the role for the stakeholders, for the beneficiaries. So what that means is we're very interested in speaking to people who are experiencing the potentially the early phases for either implications or applications for what the regulations around technologies means. So that might mean that you've got companies who are now having to go through a whole new phase of conformity assessments or different kinds of mechanisms for approval for release into the market. But you have also other kinds of questions that have already existed in the jurisdictions previously. And we're finding already that there's some really interesting differences. For example, in the USA context, you've got quite strong law around discrimination and also disability. So what we're finding is that, in fact, you know, that there are discussions being held now around what it means when new kinds of technologies and digitalization products and services are released potentially into the market, and what the implications are for people in either already existing vulnerable communities, and what kinds of protections can be overlapping, as it were. So those are the kinds of things we're finding in the USA case. We're finding, of course, so we're finding in India, and I don't want to preempt too much about what will be said, but of course, there are really strong issues around what it means when you have multinational corporations, and in the kind of GAFAM context, you have very, very strong big tech, and you know, in the marketplace where there is engagement, there's discussion. They have to ask what kinds of lines of force are observable and need to be sort of like looked at. because of course technologies in the workplace have different implications for technologies in public sector services, have different implications for what it means to have, like, for example, your potential for surveillance and in different kinds of online e-commerce platforms. So there are different ways that people experience technologies in their environments. And so we're interested in taking that as if we think through what artificial intelligence regulation looks like, as I say, empirically now, then world of work questions and how they are already emerging, and what the differences are between what maybe it may have existed earlier phases, and then longitudinally what will happen over time in the regulatory space. I think we have Apar with us. Do we not? Oh, Robert, do you want to go ahead? I thought you had something. Okay.
I sent her a message,
Apar?
but she's not here.
It's yep. Yes. Yes, we could do that. I don't know how much time we are. Oh, we're 5 minutes into the time, and Apar is not with us yet. I think we can do that. Yes, absolutely. Yes, I think we can just do. Okay. I'm slightly concerned about the time. I think it's 3.5 hours earlier.
Yeah,
later, isn't it? Later, 3.5 hours later, isn't it? He was?
Hours later,
Right.
but it's fine. If you
Exactly.
flip it,
I think it's
yeah.
okay. I think it's okay. Okay, so what we'll do is send a message to Apar and go ahead and hear our esteemed speaker, Mariana. So over to you. Are you chairing?
I'll share slides.
Okay, I'll be chairing. Okay, great. Great. Thank you very much, Mariana. And so I would like to introduce you and thank you again for agreeing to be part of this initiative at these early phases. Mariana Valente is an assistant professor at the University of St. Gallen Law School, and you teach on regulation in the digital economy. You are a member of the Brazilian Senate Legal Experts Commission, who's drafting a law to regulate AI in Brazil. And we're very happy to have you with us. So please, over to you.
Thank you so much, Professor Phoebe Moore. I'm really happy to be here with you today. As Phoebe was saying, I am one of the members of this expert commission that the Brazilian Senate put together to discuss an AI law. We're going to produce a draft law soon to be presented into the Senate, but I'll speak of that process in a little bit. Let me just present the plan of the presentation that I want to do today. So I'll speak a little bit of context, deployment, and legal framework in Brazil before we write an artificial intelligence regulation law. Then I'm going to discuss a bill that was proposed and approved last year in the House of Representatives, which was the bill that actually set off the process of there being a legal experts commission to discuss an artificial intelligence law and discuss the commission itself. I'll bring some issues about regulating AI and labor issues in Brazil, and then discuss what the next steps for us are. So just setting the context. Before I go into the legal framework, I think it's important to present how AI has been used in Brazil lately. What are the most prominent examples and which kind of problems they have been raising for people observing these systems. Of course, it's harder to describe how they're being adopted by the private sector, but the organization Transparency International in 2020, they developed a study in which they were able to map 44 tools being used by the Brazilian government, and 28 of them were, let's say, of higher risk because they were making decisions autonomously. And I'll bring some examples to show to you the kind of decisions that they have been making and to kind of connect to the absence of a legal framework and how that can be worrisome. And the other 16 of the deployments of artificial intelligence systems by the Brazilian government, only on the federal level, they were there just to support human decisions. And then it's not that there are no regulatory issues involving such systems, but then of course we're speaking of systems of lower or lesser risk because they're not making decisions by themselves. They really need someone to intervene and to supervise and to really operate the system. And then we have some examples. So for example, the BEM-TV is an example. It's a system that's being used by labor justice in Brazil. And it's a system that's actually doing triage of lawsuits to automatically identify deadlines, for example, or important information, present that to the people who are operating the system. Transparency International was concerned about the system and making a few questions to the justice to realize if there would be possibilities to correct, for example, an error that such a system could make that could affect the citizens' right to justice. There are a few other examples that they brought forth as concerning. So, for example, PalasNet is a system that's being used by the federal police to register information of secret phases of criminal investigations, and it uses facial and image recognition, constructs criminal profiles, and was trained with a criminal records database. And Transparency International was also pointing out that depending on how that database is constructed, it will carry with it, of course, many of the discriminations that already exist in the Brazilian criminal justice system. So, for example, if it understands that citizens of a certain profile, they are more likely to commit crimes or to commit crimes again, that might have consequences for people of populations that are already targeted by a very unequal criminal enforcement system. And another example was the use of a system by a university in the south of Brazil that's predicting student evasion using academic databases. And it was not clear what this data was being used for. But of course, if this system uses, for example, information on evasion in the past, it could learn by patterns of, for example, young women evading university because of pregnancy, and that could cause them consequences if that system is used to somehow provide more chances to some rather than others. And the third example is an example of a chatbot, and many people will often refer to chatbots as systems that are normally not so concerning because it's just a communication system, but it was doing triage during COVID-19 in a hospital, university hospital in the north of Brazil. And of course, they were developing the system to support them in a time when it was really hard for people to just go to other places. But at the same time, because of how a large part of the Brazilian population has problems writing, that could lead to false conclusions, and there weren't really any possibilities for a person who received a certain conclusion from this chatbot to appeal somehow to this decision that was made on whether a treatment was necessary, or to make more questions, or to clarify something, or to correct something, or just to have a human interaction, right? And another example that I'd like to bring from a deployment of artificial intelligence in Brazil, and I think that's like a larger deployment and perhaps more concerning, it's one that has been studied by this organization that's called Derechos Digitales. It's an organization based in Chile, and they investigated the system, Sistema Nacional de Empleo, the national employment system. The federal government in Brazil entered a cooperation agreement with Microsoft so that Microsoft would help with its technology on profiling unemployed people to build different profiles of their chance of being reinserted into the labor market. And the system would match those profiles with vacancies as a way to improve efficiency. And the idea behind it also is that if a certain profile is recognized as someone with a low chance of reinsertion into the labor market, public policies will be directed towards this person. However, Derechos Digitales was trying to get more information about the system, sending FOIA requests, and they didn't really get a lot of information which is where all the concern comes from in terms of transparency and accountability. It was really hard to understand how the system was tested. The Digitalis didn't get any information about which databases were being used to build those profiles. So of course, other biases could be being used to build the kind of profile of a person who would fit for a certain position. And then they're making a very long discussion about how that could mean actually a loss of opportunities for certain people. But the most important thing, I think, is that these systems are being developed and deployed in a context where there's no regulation. So there isn't really specific regulation requiring, for example, that the federal government releases more information about which kinds of databases are being used, or that the user of such a system has information about why this decision is being made about him or her, and whether they could change this information somehow, and even the details of the cooperation agreement and the testing and all impact assessments, everything that's involved with accountable technologies was not really required of this case because there's currently no requirement for accountability and transparency involving these kind of technologies. What's the framework we have so far? So we have a few laws that apply to the context of artificial intelligence. There's this very important piece of legislation that's the Marco Civil da Internet, or Internet Civil Framework, that regulates mostly internet platforms, and it provides for some general privacy provisions. We also have a general data protection law, and that's a law from 2018 that actually came into force last year. And it provides for extensive data protection, but it provides for a restricted right to explanation. So if you know the GDPR, you probably know that there's this provision that anyone can ask for a revision, for an explanation, a revision of a decision that was algorithmically made about them using their personal data. And that was also provided in the first version of the Brazilian law, but after the negotiations, what is there now is that users, citizens, people, data subjects, they can require an explanation. They can require that they can require an appeal of the decision, but if the decision was algorithmically made, they can only require an algorithmically made new decision. So there's no right to a human supervision of decisions, and that's quite troublesome when we're speaking of artificial intelligence technologies and how they can affect rights. We also have a strong, very extensive consumer protection legislation, and it provides for many measures for product safety against reasonable risks. It also provides for transparency requirements, and it establishes that if causality is established between the harm and inaction of anyone in the supply chain, liability is strict. That is, there will always be liability. And there's a decentralized enforcement system in consumer protection law in Brazil. And that has been used for software in some occasions, and it is a framework that can be used for artificial intelligence as well, but of course it's not particularly framed for these specific technologies. And then we have some other pieces of regulation. So for example, the judiciary adopted a resolution that's very interesting actually and very rights protective to regulate the adoption of artificial intelligence by the judiciary system. And then when it comes to labor and technologies and artificial intelligence, of course, there's much that we could say, but a few things that that I highlighted here are that the federal constitution protects citizens against automation. It has this very general provision of protection against automation. There are a few laws against hiring and salary discrimination. And in the consolidation of labor laws, there's this provision that technological management leads to subordination. It's not just human management that leads to subordination. But the problems there, when we look at the framework, people who have been studying the connections between labor law and artificial intelligence have been saying that the problems there are that when we're speaking of black boxes, invisibility of problems because of this whole new technological environment, auditing or even enforcement of these provisions against artificial intelligence system providers, they face many of the problems that are related to the previous things that I was speaking of, right? Which are very specific to how these technologies operate. And then we have many issues that are not regulated. So for example, quality and representativeness of databases used for training, that's not regulated anywhere. There's some provisions in the data protection law, but not really as obligations for someone who's developing an artificial intelligence system. There are no requirements for impact assessments. There's no information, there's no requirement for people to be informed about when they are in contact with AI systems. There are no requirements for accountability, meaning transparency or explainability, as I was saying. There are no requirements for external auditing of such technologies, and there is no specific right to contest and appeal of algorithmic decisions. So all of those systems that I was mentioning, they're operating without that those rights exist. Of course, interpretation could derive some of those rights from the data protection law, from the consumer protection law, but I don't think it's possible to say, looking at the current jurisprudence, that this has extensively been made. So there isn't really a proper framework for artificial intelligence systems in Brazil. What exists is a strategy that was approved in 2021 by the federal government. And it's a strategy that does address some issues involving ethical principles that should guide responsible use of AI, but it's mostly directed to removing barriers to innovation, improving collaboration to develop artificial intelligence. So very much on the side of promoting innovation. And then, of course, it has some provisions on ethical principles and provisions for how to regulate such issues. But it doesn't really, it's just a strategy, right? It doesn't really create obligations or the such. And the audit office or the general accounting office in Brazil has produced a report about the strategy that criticized it harshly for failing to answer trivial questions and for not being very specific, for being too general on most of the issues that it was addressing. And then we get to the process that I'm participating in. So I told you that last year, this bill that was proposed in 2020, bill number 21, it was proposed in the House of Representatives. It got approved in September 2021. And although it had been proposed in 2020, the period during which it was discussed was really short. So it took many people by surprise, because most of the people who are discussing this issue were not, most were aware that there was a discussion in Congress, but not that it was moving so fast and that it would be approved so fast as well. And the characteristics of this bill, and I'm going to speak of it more in detail now, are basically that it's very minimalist. So it establishes principles, it doesn't establish obligations or very few obligations. And I'll speak of some of the characteristics of this bill then. And just to make sure that you're following me, it was approved in the House, then it got to the Senate, and now there's this commission to discuss this bill. So this is not being discussed in the Senate right now. This is just the bill that was approved at the House. So it establishes some principles, and of course, some obligations could be derived from such principles, but there are no specific obligations for specific stakeholders there. So for example, there's this principle of a beneficial purpose, that is that AI has to pursue beneficial outcomes to humanity by artificial intelligence systems, focus on the human being, non-discrimination. There's a principle referring to transparency, and then it establishes something similar to a right of people to be informed in a clear, accessible, and accurate manner about the use of artificial intelligence solutions. But I think the important parts of the law that really characterize its model of the bill are the following ones. So this idea of a secondary innovation that's in the bottom there. So what the article says is that when regulating the application of artificial intelligence, the rules will be adopted only when they're absolutely necessary. So that's more or less the spirit that the state shouldn't be intervening too much, which is what I'm calling a minimalist approach. And the second characteristic, which I find very important about this law, is what has been called a decentralized model. This is also a guideline for regulating, and this number 2 here refers to sectoral activity. So the idea there is that regulation will go through the sectors themselves. So for example, the telco sector will regulate itself through the telecommunications agency, or the health agency in Brazil will provide regulations for AI systems that have to do with health, and labor authorities will also regulate artificial intelligence systems referring to labor. So the whole idea there is that there is no, let's say, detailed central regulation, and the model that's behind this is basically that this would stall innovation, and it would be a problem for people who are trying to innovate with technologies in Brazil. And I'll speak of these opportunities of participation later, but we conducted public hearings, and many people who defended this decentralized model, one of the things they were saying was that if there is a centralized model and, for example, the judiciary is going to enforce this law, that could be a problem because judges don't necessarily understand the sectors or the specific necessities of the sectors. So it would be really important that the sectors are responsible themselves for regulating those systems within their realm of action. On the other hand, this has been really criticized, because that also means that there wouldn't be a centralized set of rights that refers to everyone regarding algorithms. And then, of course, these sectors, they regulate themselves very differently. There are different power dynamics in each of these sectors, and that could mean less protection depending on the sector that we're speaking of, and of course, less coordination in things that are not maybe so sector specific, right? Many of the systems, they will, of course, involve many different sectors. And in the end, if you're thinking of a user-centric or a citizen-centric legislation, then a citizen doesn't belong to a sector, right? So this was the counter critic that came up. Another thing that's really important about the legislation that was proposed is the rule for liability. So it establishes a general rule for liability that's a conditional liability based on fault, meaning that agents that act in the chain of development and operation, they will only be held liable if there's evidence that they acted based on fault. And then there's an exception for consumer relations because, as I said, there's an extensive consumer legislation, and in the consumer legislation, the rule is strict liability. And this also caused a lot of discussions in the public hearings that we organized. Many of the participants criticized this model because of how it might leave people unprotected, because of how it's very hard to prove the chain of guilt when we're speaking of such technologies. And on the other hand, other experts have been saying that precisely because artificial intelligence produces unexpected results, strict liability wouldn't be a desired model. But this is one of the things that's under discussion very much by this commission right now. And this is where we're at. So the bill passed in the House last year, around, it was in September 2021. And when it got to the Senate, some senators felt that there was a need for more discussion, that this was a very complex subject. And although it was a very minimalist approach, that approving this law could have very important effects for the deployment of artificial intelligence in the future, and probably there wouldn't be another regulation anytime soon. So they decided to create a commission of legal experts to discuss this bill and to propose changes or a new text. And this is the commission that I'm part of. We're 18 members, and we have been since April discussing this bill deeply. And we also provided for some opportunities of participation. So there were public hearings in which we tried to have people invited from different sectors. There was an international seminar with mostly researchers, international researchers, to discuss aspects of the bill that was approved and of a bill that could be approved later in time. And there was also an opportunity for anyone to send documents to the commission, and we received over 50 contributions from individual people and organizations and corporate associations. And currently what we're doing is that we're discussing all these contributions and the results from the public hearings. And then we were divided into groups to discuss broad axes of the law and doing research and guidelines for what the Brazilian bill on artificial intelligence could be. And later this year in December, we're going to present a draft bill itself. Of course, you understand that there's not much that I can say about what's being decided. A lot is being discussed, but nothing has been decided permanently yet within this commission. But I can tell you of some of the concerns that we've been addressing. And one of the concerns is how to regulate artificial intelligence in a country that's so unequal, like Brazil. This is just a picture showing, it's a scene in São Paulo that's become very famous because of how it shows these contrasts. And we've been discussing very much how it is, what are the specific issues that an artificial intelligence regulation in Brazil should provide for, right? Considering access of people to technologies, considering the immense differences that there are within the country. So one of the examples that I was providing to you was that some sort of exclusion could be produced because a large number of people in Brazil are illiterate, or they can't express themselves very well in written language. So this is something that's very specific to the country. How do you address those things instead of just looking at the AI Act in Europe and just bringing the ideas that were developed elsewhere, right? What's specific about this country? And of course, geopolitical matters. We're very aware that it's different to regulate artificial intelligence in Brazil as it is in Europe, in the European Union, in terms of enforcement power as well, and in terms of where these companies that are developing these systems are located. So most of the technologies that are being employed in Brazil are not produced in Brazil, and that's something that's also part of the concern. And then, of course, we're speaking of 5,570 municipalities in the country. It's a huge country. And one of the things we're discussing right now, for example, are rules for the public sector. And then maybe I can tell this anecdote. I came up with this very complex system of auditing of technologies developed by the public sector. And someone said, wait, like we have really small municipalities developing technologies. It's just going to be impossible if we create a super complex auditing process. At the same time, you have to guarantee rights, right? How do you do that in a country with such complexity that you can't really create obligations that are impossible to meet, right? So when we're speaking especially of enforcement and supervision, you have to think of all those things, and that's definitely not easy to solve. I'll just look at how much time I have. And then I bring some of the issues that I was collecting about labor and AI to think of how either the bill that I presented would speak to those issues, or the things we're discussing within the commission right now would speak to those issues, and which ones I think are not covered. So of course, there are many problems involving workers' rights and artificial intelligence, but we're speaking, of course, of hate formation, of algorithmic management, problems in recruiting and hiring, workplace surveillance, and predictions being made about such workers. Of course, there are many other problems, but let's just stick to those to think of that a little bit. How does general AI regulation address some of those issues that we all know that are out there, right? And I was just referring here to Rafael Grumman's research on many of these problems, how they're developing in Brazil, what he's been calling platform scams that workers encounter. And he did research, for example, on Amazon Turkers. He's been collaborating with researchers who are working with Uber workers. And what I wanted to highlight here is that, of course, we have this particular problem of workers whose only contact with who's employing them is a platform. And then, of course, technology and artificial intelligence has a specific meaning there, right? There are some important discussions going on in Brazil right now. So there were a few decisions by lower labor courts asking for preliminary judicial investigation of algorithms. In some cases that that workers were demanding that they be considered employees. And at least in 2 cases, court demanded that these companies provide their algorithms so that the court could do the investigation and understand what kind of management was being deployed by these algorithms. And then when these decisions reached the Superior Court actually suspended them, affirming that perhaps this would need more discussion, because the companies were, of course, they were presenting the argument that this would violate their trade secrets, that these were very secret information about how their business operated, and there isn't a legal basis for requesting this investigation. But of course, the judge has powers to request evidence that's not specifically provided for in the law. But there was this big discussion on whether this was something that the judiciary could request. And the decision was not that the judiciary cannot request this, but that it cannot for now, while these issues are so underdeveloped and they're not really guidelines for requesting such an information. We do have the labor public prosecutors discussing digital technologies and discrimination. They have a work group discussing digital technologies and discrimination, and they have developed a guidebook. And that just speaks to how this is not something that's not under discussion. It is. It receives a lot of discussion. It is under discussion by the authorities in Brazil. And there have been a few cases. So this was one of them. That made it to the media. This refers to cases of workers who are Uber drivers and who are also Black, and who have been reporting that they have been suspended from the platform or gotten really low evaluations, and that the only reason that they can suspect why this is happening is racism, and some of them report cases of racism, and they haven't been able to really appeal to any of these decisions that's being made about them. And this is something that this intercept investigation was going into. And then the last thing that I'd like to address is this, right? And we're looking at these problems. Which are solutions that a centralized AI regulation could bring to some of them? And thinking of what's under discussion around the world and what's under discussion in the Commission, I feel that some of these issues could be improved by provisions coming from a general AI regulation. So for example, provisions on transparency could really help workers, explainability and right to object or appeal, impact assessments of technologies used, requirements regarding use of data sets so that they have high quality, a representative or different populations, so they're not producing bias, accountability measures, rules regarding auditing and of course trade secrets, and also this discussion around zones of prohibition for the adoption of artificial intelligence could also speak to some of the issues in the discussion here. So for example, the AI Act prohibited the technology that's called social scoring, and other legislations around the world are prohibiting that too. That's something we're discussing at the Commission right now. So of course, producing scoring, any kind of scoring that brings information from different aspects of life of the person, things that they can't control. That's something that could also be used, of course, against workers in this context. And then we're also speaking of prohibition of manipulative systems or systems that act against health or security. And all of that, of course, in these contexts, especially of platformized labor, could be, of course, of use. When we're speaking of risk-based regulation, that's the model that the AI Act in the European Union is following. One of the solutions that have been found is to bring any AI systems that are used in the area of employment, especially employer management, access to employment, that they're considered high risk. And that means that many protections and provisions are applied to these systems, and that could give a specific protections to workers, but that's the protection that's given to all the high risk systems, right? So it's not something specific for workers. And then, of course, this idea of having ex ante regulation and ex post liability, not just speaking of liability, but also of precautionary measures. And also just to present some of the issues that we haven't decided on yet, but we're already discussing. We're discussing how to bring those precautionary measures from consumer law that are reasonably strong in Brazil. And also there's a discussion on who should be regulated, because there are many decisions that could be made there. So we're speaking, for example, of suppliers of systems, of operators of systems, sometimes also referred to as users, which I find a bit confusing because that could be also the final user, but also developers, right? And when you look, for example, at the AI Act, the model that they chose was to regulate just suppliers and operators, not the developers. And this is something that we're discussing right now, if it makes sense, thinking of protections, of really protecting human-centric technology, what makes sense and what can be enforced, actually, right? That's also one of the other discussions. And then we come to the discussion of enforcement, which I hinted to already. The whole discussion is whether there should be a central authority to enforce the provisions of such law, or if a special unit with an existing authority could be created, or if we would be speaking of a decentralized enforcement, right? So we'd be speaking of courts, for example, consumer associations, public prosecutors. So that's something, and also the idea that the agencies could regulate themselves. And that another discussion, there's also what to do with self-regulation, right? If there should be bodies that are accredited for doing self-regulation. So this is part of the discussion that we're doing right now. And then, of course, there's some issues that in such a general law that doesn't address specific sectors that perhaps are left out. So workplace surveillance specifics, these issues of forensics, information, other discussions that are happening right now, those are mentioned in that strategy that the federal government published, are inequalities in the STEM sector. So, for example, discrimination coming from inequalities in the science, technology, engineering, mathematics, right, sector. Which are also believed to lead to discrimination because of how very homogeneous teams normally don't think of as much of needs of other groups, of vulnerable groups in specifics, and capacity building, of course. So these are things that a general law in usual, it can address, but it will address in a very general fashion, right? So I think that also speaks to perhaps the need for sectorial regulation, but this is all very much in the open, just ideas. And I'll close by telling you what the next steps are. So tomorrow, actually, there's going to be a public presentation of the structure that the Commission has been developing to be the skeleton, let's say, of a draft bill that's going to be presented in December. And when we present this draft bill, it actually goes to the Senate, and there it's going to be discussed by the senators. And there are going to be new opportunities for participation. Usually the Congress will hold public hearings, meetings, and several different opportunities for people and organizations to participate. So this is just a phase, right? This is a phase in which we're doing research and developing something, and then it really goes to the political discussion. And when it goes to the political discussion, of course, different stakeholders in society are going to participate and have a saying on how an AI law is going to look like. I have to say that there was even the discussion on whether we needed an AI law in Brazil that was all-encompassing or something shorter. But one thing that we concluded in the Commission is that this discussion is in the past. We already have this process going on. We had something approved in the House, so we had to do our best with the opportunity that we had, right? And if it is, of course, very challenging to regulate a moving target, and considering all of the issues that I was bringing. When a text is approved at the Senate, it goes back to the House. If it is considerably changed from that bill that I presented to you, then the House has to vote it again. So there's still a very long process that's going to happen. This is not going to be approved this year for sure, probably not next year. It could be, but probably not next year. Probably this is a process that's taking more time than this, and I'm participating of just a little part of it. Open to your questions. Thank you for the opportunity to speak.
Thank you. Thank you very much, Mariana. I appreciate that very much. So a quick announcement just now. We are going to be rescheduling a little bit for today. So what we're going to do right now is have a short break, and then right after that, we'll reconvene where Robert and Jamie will lead on the discussion and questions for your talk, as well as a kind of a space for them to talk about some of their findings from the case studies that they've been working on. So that's what we'll be doing first. We're going to hopefully be able to put that up on the website as well. And I'll make a kind of a document that can be viewable. So that's between 11 o'clock and 11:45. So we're turning that over to our project team for that discussion. And during that period, also for questions and answers, of course, from the audience. From 11:45 to 12:30, we will now have the keynote lecture from Professor Peter Bloom. We'll be still taking the lunch between 12:30 and 14, and continuing the day with our Canada speaker, USA, and then we'll have our India speaker, and then the EU. And something to quickly say to you as well, Mariana, I'm really happy that you've already started to look at the kinds of comparisons that we can start to make. And something that I'll present on later actually is the risk-based approach that the European Union is taking, and thinking through what are the implications of that kind of approach, and then making kinds of comparisons to other jurisdictions. So I really appreciate you doing that as well. So if we can reconvene in about 5 minutes, then we will do the questions in 5 minutes time, as led by Jamie and Robert. We'll put the schedule on the screen literally now. And then if you could come back in 5 minutes, then we're going to do this all in one chunk. Is that okay? Yep. Okay. we've got to do this so that we have the proper time before lunch. So 5 minutes and then we'll reconvene and do the session that would have happened slightly later in the day in 5 minutes. Okay. Yep, that's when we'll do that as well. That's when we'll do that as well. Sorry, that just to make it clear, the presentation questions for the Brazil presentation for Mariana Valente will happen in 5 minutes alongside Robert and Jamie's discussion for the talks so far today. Yep, is that okay? Yep, okay. And Jamie, who will provide some space for Q&A and then speak about some of their insights from the case studies they're working on as well. So I turn it over to you.
Professor Moore said, we're just going to make sure that there's time for questions for Professor Valente on her presentation. So we'll open up the floor for that. So if anyone has any questions about that.
First of all, thanks for a really great presentation. It was really interesting. I had a question a little bit about trade union involvement. So all the literature talks about, participatory design and the importance of having workers and workers' voices involved in the design of AI, particularly in that sort of AI that affects the workplace. So I'm wondering about, one, if there is any sort of trade union involvement in this committee that you're on, or also what is the involvement or at least the position of trade unions in Brazil with respect to this topic?
Yeah, I'm sorry to say that there's not much. We didn't receive any contributions from this sector, and they also didn't participate in the public hearings or the seminars. And this is actually something that was discussed more recently, that this is something that's missing, that I hope the Commission will be able to address in other ways, like calling for meetings and stuff. But to be completely transparent, no, there hasn't been either calls for participation yet or direct involvement from trade unions with the Commission. I can say that they're not discussing this in other spaces. I think they probably are, but not directly with the Commission.
Hi, thank you, Mariana, for this wonderful presentation. I have a similar question about the employers. Like, how do you see their reaction to this in terms of, I mean, there's a lot of regulation aspect, but how do you think they're going to react, or they have already have a word for this whole regulation?
To this regulation in specific?
Yeah, in terms of transparency and data and everything, I mean.
Yeah, we've been seeing conversation going on and organization of employees, especially platformized labor. There are some strong movements going on, and I know that they're discussing algorithmic management, for example, but again, I haven't seen that in relation to the Commission or this bill specifically. But there's a big movement that is not unionized yet, I think, of delivery drivers in Brazil. And they have bry organizing big protests and demanding for things, but usually against the employer itself. And I haven't seen them in discussions of AI regulation. But again, maybe they are, and I don't know.
Yes. Oh, sorry, Mariana. Oh, that's not very good. My question kind of follows on, and I think particularly Janine's question. And I'm going to do something very bad. I'm going to try to pronounce something in Portuguese, and it's going to be wrong. And then I'm going to do a very bad translation of it. But a lot of the work that's going on now, particularly with employees in the digitalized sphere, is actually trying to get them in a more regulated space, right? However, Brazil has a tradition here of actually having what I think can be kind of translated as like a work card system anyway, particularly in the agricultural sector, which isn't digitalized, but is serving as a kind of basis for this. So it's kind of like, you know, tracking everyone's, oh, sorry, this is really bad. Yeah. Oh, maybe.
This one.
Oh, is that why? Thank you very much. It's the second time today that Janine's helped. But why I asked this is that while this is actually meant to be helpful for workers, what's actually seen with these kind of, and again, I'm going to do with the Quadrilla di Chapolo, this has actually been used, and trade unions have come on this, including also various employer groups, to work and to regulate the movement of workers, to track them, to monitor them. So I'm kind of wondering, you know, as you're working through these regulations, that some of the more traditional demands that might be had by platform workers, which is we want more transparency, we want more social security, we want more rights. When this has actually been in a non-digitalized way in Brazil, this hasn't necessarily created a more, in practice, decent work for workers. So how do we balance that, do you think? And do you think that is a risk?
I'll try to answer and see if I understood your question.
Sure.
fully.
If not, I apologize. And
I think you're saying that there have been demands in the past and they didn't really change the
So,
situation of workers up to now.
what I mean is that there's a non-digitalized information system
Yeah.
for workers in their
Mhm.
work cards, right? And this is
It's
essentially,
like a booklet.
it's just a
Yes.
booklet and it does it.
Yes.
And this is actually meant to help workers, right? Decent workers. But what it's actually been used by management to control their movement, to discipline them as a performance management tool.
Okay, I get it.
So now that we're moving towards these demands in the digital space, particularly for precarious workers, right? Particularly for Uber drivers who do want something very similar, but in a kind of digitalized sense, how do we avoid that same risk that this information is actually going to be used in order to, you know, essentially discipline workers and not actually support their rights?
I think you're referring to situations in which the employer just doesn't give the booklet back to the employee, for example. Yeah.
Or threatens to write bad reviews in it, these types of things.
Yeah, I think your question actually refers to a broader thing, which perhaps is important to present here, which is that, of course, you know that, but there has been a deregulation of work in Brazil lately, and it hasn't been a small one. And this was one of the fights, one of the battles lost in the past years. And there's been this movement of really incentivizing informal work. And I think all this discussion plays into that, right? How to organize in a situation in which all you've been getting the last years is actually deregulation, not more regulation, right? So when it comes to a public sphere, that's more or less convinced that you need less rights in order for the economy to thrive. How do you bring those arguments forth, right? And then the second part of our question is whether the digital data and environment is going to be used to control more as it's been with the physical. I think the answer is yes. And at the same time, when we're speaking of platform workers, we're speaking of people who are even more disposable for the employer, I guess, because of this huge contingent of people who are unemployed right now in the country, or just doing informal work either way. And I think that makes the situation even harder. So when I was mentioning that there are some social movements that are making a lot of noise, I was referring to, I didn't want to say the word in Portuguese, but since you inaugurated this, I will. I was referring, for example, to Entregadores Antifascistas. That's a very important group. It's just one of the groups, but it's the most well-known of them, who has been driving thousands and thousands of motorcycle drivers, delivery drivers to the streets, like stopping the city, because really, if you've been to a city like São Paulo, you'll see that motorcycles are just everywhere, and really the delivery service is really something that's used very broadly by everyone because it's so cheap. So when they decide to stop, they've been really making a lot of noise, and I think one of the movements that in the past 2 years made most noise in the country was that of the entregadores antifascistas. They were really able to like call the attention to their issues, and then the public prosecutors, the labor public prosecutors really started to try to reach deals with the employers, require them to do more. So I guess something could be born from there, right? And I know that in this research, we were also in contact with public prosecutors in Brazil, and I know that they're very active. And I think also something could come from there, but it's hard to think of protective legislation passing right now. I wouldn't be very hopeful considering the latest scenario, the political scenario in the country.
Oh, thank you. And I just would like also to say, because I know it's busy, but everyone should check out the research center that she's part of, Internet Lab, which I think has really been a model for actually doing incredible type of work on this. And I think the recent thing, particularly around micro-targeting of politics and also indigenous knowledge creation, I would like everyone, if you have a chance, just go to Internet Lab. It's very good, Mariana.
Thank you. I didn't speak of that, but that's the think tank that I'm one of the directors of in Brazil. Thank you.
So we do have a question from these in the chat, so I'll go ahead and read that. Regarding government national identity management databases that use AI and share citizens' IDs to enroll them onto social assistance programs, how do you think that AI regulation will obstruct or balance out any effects for achieving transparency in social protection schemes? On the other hand, datafication of social protection programs using AI leads to data injustices. So AI regulation should be in place.
No, thank you. That's a really good question. And that's actually a subject that's, it's one of my favorites. I've been doing research on the Bolsa Família program. That's the welfare program that wasn't in place until last year in Brazil. It was the largest welfare program in the world, and really looking at datafication practices. Just because it's the largest in the country, but it also speaks to issues of all the social protection programs. And there's so many issues there that an AI regulation, in my opinion, could address. So we're really speaking of algorithmic decision-making on things that are really life-changing, life or death to many people, right? We're speaking of a social benefit that addresses people below the poverty line, and getting a wrong no, a wrong exclusion really means like not getting access to the basics of life. So this is something that's really, really important. And it's interesting that when the program was conceived in the 90s, beginning of the 2000s, these issues really weren't part of the concerns of the teams, the very like multidisciplinary teams that were thinking of all the aspects of the program. Because probably technology was also not developed as it is today, and the possibility of crossing the databases of social protection programs with other databases and creating new vulnerabilities wasn't part of the issue. So I think when we're thinking of these programs, we have both data protection questions and algorithmic decision-making questions that an AI law could address. So for example, creating specific requirements for governments to really test these programs, have a compliance program to be retesting these programs, having an appeals system that's effective, and that's effective also for people who don't have access to technologies. Because when we're speaking of vulnerable people, that's also one thing, right? You can't create a system that just functions if someone can access it on their cell phone, right? If you're speaking of people who don't have cell phones or access to the internet. So like really thinking of effective measures to appeal algorithmic decision-making is something that I think is essential for any AI regulation, especially when it comes to public sector decisions, right? Because of the extra responsibility that the state has regarding their citizens. So yes, I think there's a role I can't say yet that this bill is going to address that, or it's going to address that properly, right? There's still a lot to happen, but I think an AI like that can be very protective of such rights and things related to social protection.
Okay, great. Any other questions? Okay, so we will move on now to presenting our case studies. Professor Woodcock and I worked on a case study for, I worked on one for China. He's working on one for Brazil. So we'll go ahead and just kind of respond to what we've heard from our expert speakers and then add some other information that we've come across. So I will go ahead and present first. So Mr. Han did a nice job going through some of the technical aspects of regulation in China. So mine will be much more of an overview. And Professor Moore earlier on talked about our interest in looking at development, regulation, and governance as kind of three broad categories. So that's what I will be kind of reviewing generally. So when we look at development in relation to AI in China, we see a very long-term strategic approach that's being taken. You can see this in the publication of key documents over a series of years now. One of the turning points seems to be the publication of China Plus in 2015, which was establishing a set of guidelines for integrating the internet into all elements of economy and society. And the document expresses the importance of this, of cultivating a diverse technological ecosystem and the role AI will play in the future. We see subsequent important documents emphasizing this, the Made in China 2025. The Central Committee of the CCP published a 5-year plan in 2016, identifying AI as one of the 6 critical areas for developing the country's emerging industries. The State Council has also issued statements on the importance of this. So what we can see is that the Chinese government has conveyed a strong interest in promoting AI development, ensuring its international competitiveness in this economic sector. And what's important to note is that the Chinese government, or in particular the CCP, is not interested in taking a minimalist approach, as we may see with a lot of other countries like Brazil or the US, and even in some aspects the EU. The party is very interested in being involved in the development of these technologies and understanding their implications. As Mr. Han emphasized, the government is even starting to establish procedures where companies have to come before representatives of the state and explain what their technologies do. So you can see just in some quantitative aspects how much China is emphasizing development. You can see when we look at AI journal publications, percent of world total, China is out front by far. The European Union comes in second and the United States in third. And one way to think about this is in the context of the AI race. There's a lot of belief that whoever arrives at this kind of technology first will yield the greatest benefit. So there's a lot of importance in that. You can see it also in journal citations. China, again, leads the pack, leads the EU and the United States. Same story for AI conference publications. And then Mr. Han talked about a lot of the aspects of corporate ownership. We see China's taking this seriously as well with the percent of AI patent filings. Now, when it comes to granted AI patents, the United States is still by far in the lead, but China is are ostensibly trying to close that gap. When we look in terms of like exact dollars, it's hard to say how much of money the government is actually funding into AI research and development. The reason is that information from Chinese documents and sometimes reports in the Chinese media can be poorly defined or in terms of timing, sources, and purpose. And so it's difficult to make like robust, credible comparisons between, say, how much the US and the EU is funding research and development and China. But we can get a sense of it when you look at things like who are some of the strongest companies working on AI. You can see that a lot of their funding does come from the Chinese government. And we shouldn't also discount the amount of private investment that is flowing into China. Annual venture capital investments, while it's kind of tapered off recently, because there is some uncertainty about the direction the Xi administration will take on some of these issues, there is robust private financing. China is really trying to build up the availability of data and resource repositories, which is crucial for the development of AI technologies. And they're really trying to build this entrepreneurial culture. And it's, if we can analogize to the space race, China sees itself as behind, and that gives it a little bit, leads to an entrepreneurial spirit of we're the underdog and we have to catch up. And finally, there's really strong interest in antitrust enforcement in China and building a healthy digital ecosystem. They don't want just a couple of companies to dominate the entire scene. And we can see serious movement in this regard when, as of late, based on the meetings arranged between the government and the CEOs and executives of these top tech firms. So in terms of regulation, one thing to keep in mind is that China is a party state. So sometimes it can be difficult to understand the origins of Chinese regulation because it generally emerges inside party structures first and then gets passed off to the state. Sometimes people will say that the bodies like the National People's Congress are essentially just rubber stamping policies developed by the party. So it can be challenging to follow the exact line of regulation. If you're not familiar with the structure of the Chinese government and the party, this is just kind of a general overview, but the General Secretary of the CCP is also the president of the state, that's Xi Jinping. And then you have power seems to kind of start up top and move downward through the Politburo, which is the key officials, and then down to the Central Committee, and then down to the National Party Congress. And we can just. So in terms of regulation, there's many players in China. One of the keys players is the Cyber Administration of China, something that Mr. Han emphasized. This is a leading agency. And what's interesting about the CAC is that it's relatively new in the sense that it's an offshoot of of these leading groups that General Secretary Xi created. And so he created a number of different leading agencies that are kind of outside the official party structure. And these different agencies look at different dimensions of society, and the CAC is housed within one of them, and it's the Central Internet Regulator and Censor and Oversight. So you can see that there's a strong interest in the top party leadership having strong control over what happens with these new technologies. You also have the China Academy of Information and Communications Technology. This is kind of the brain trust. This is where a lot of the policy may get worked out. It can function kind of like a think tank to develop ideas about what direction regulations should take. This comes from the Carnegie Endowment. You can see that there are different organizations that have different kind of regulatory focuses. And but again, we would emphasize that the CAC is the one that really has teeth to it and is really leading the way. In terms of notable policies, we have the Internet Information Service Algorithmic Recommendation Management Provisions. Became effective in 2022. This was something I was asking Mr. Han about, which is, will these articles or provisions in this legislation, which regulates what algorithms can do, will this impact platform workers who work on systems governed by algorithms? And as he mentioned, there's a little bit of uncertainty about what exactly will happen. But as he indicated, there probably will be implications for workers, things that may get worked out in the courts, because this bill, the ISARM, if we can abbreviate, it institutes a lot of different kinds of user rights. It emphasizes the protection of user rights, things like user notifications, procedures for obtaining consent, options for opting in and out of monitoring and surveillance, and control over personal data. This may be a piece of legislation that workers can appeal to when they're trying to challenge injustices on that flow from algorithmic management. We also have the Personal Information Protection Law, PIPL. As you may know, this was generally trying to kind of mimic Europe's GDPR, as it's so called. And this legislation sets out the guidelines and basic principles on personal information protection. And this law introduces some protections against profiling and extends new rights for users or data subjects to customize how their data is used and how data is processed. This was one thing Mr. Han emphasized, which is talking about like data moving across borders, how data is stored, who has access to the data. A lot of these questions are, or a lot of these issues are attempted to be worked out through PIPL. And these protections could be ostensibly levied by workers to combat certain kinds of surveillance in the workplace by challenging or contesting the actions of data processors. How far, like how robust that will help improve or augment user rights. Again, it's a little bit unclear because like the previous bill, this one is relatively recent, and we may have to wait to see some challenges in courts to see how this is applied. We also have the ethical norms for the new generation artificial intelligence. This is not a law per se. This is just a set of provisions or ethical guidelines that should be followed or adhered to in the creation and use of AI. In the bill, it says that AI systems must promote human-machine harmony, improve people's livelihood, protect the legitimate rights and interests of all relevant stakeholders. There's a lot of strong moralizing language, similar in the way that the Brazil case was emphasizing basic first principles. But what does it actually mean when we get to policy? It's not quite clear. But this emphasis on harmony, probably a word we don't see very often in legislation, is key to the Chinese context, which is instead of these issues being worked out through class struggle or class warfare or in industrial relations, the CCP wants to create would prefer to have a digital ecosystem that leads to a general harmony for all relevant people involved, and the CCP sees themselves as the person for managing that. So again, I'm just going to emphasize a lot of this. There's a specter of ambiguity surrounding what these things mean. Like much AI legislation out there, these bills are largely written with consumers in mind, more so than workers. We'll have to, again, see how these things get played out over time. One of the experts we spoke to, Matt Margosian, emphasized that courts will play a critical role in dealing with this because, again, similar to Brazil, there's a lot of different jurisdictions within China, autonomous regions, regional governments receive these directives from the central government, but then there's some they may get applied in a little bit different ways in different jurisdictions. So we're still kind of waiting on the results for that. Okay, so in terms of the implications for the world of work, the ambiguity to conclude is primarily based around the fact that workers are not really directly mentioned in these provisions and laws, and that the impact of these laws may have to be settled in part through the judicial system. Also, there's closed door negotiations currently taking place between the CCP and the top technology firms. This is oh, okay. Yeah, this is my last slide. Sometimes the actual mechanism of regulation here is the government just telling the companies you need to change or there will be consequences, and then changes happen. Yeah, so that would be the key overview for the world of work. So I will now let my colleague, Professor Woodcock, speak on the Brazil case study.
Thank you, and very kind to call me a professor when I am just a doctor. I'm going to leave the floor for Professor Bloom, as I think the Brazilian case study has been covered so well already.
And to also give it a chance to say, you will be presenting in the final slot as well, because we had a site schedule change just to make sure everyone kind of is aware of how we're going to do it. So we'll have a couple of presentations toward the end as well during the world of work implications from the team. So you'll hear from Jamie then, as well as myself. And now we're very fortunate to have with us Professor Peter Bloom, and I will be introducing you. So Professor Peter Bloom is Professor of Management at the University of Essex, and your research critically explores radical possibilities of technology for redefining and transforming contemporary work in society, focusing on a better understanding for the human rights and the human aspects of organizational existence, and potentially for constructing more empowering cultural paradigms for organizing the economy and politics. So alternative futures. So you're looking a lot at the moment also with the cooperatives for the social economy, and a lot of really interesting, groundbreaking research in this field. And we're really, really fortunate to have you with us today. And I will turn over the floor to you. Thank you so much again for being with us, Peter.
Thank you very much. And I think maybe now we can dispense with the titles of doctors and professors. We're all working together here. So no, I really appreciate it. So I want to give a prelude or an apology at the beginning that I think what we've seen with such fantastic in-depth empirical research, this is not going to be at that level of empirical depth. And that's because I wanted to give a kind of more summative, but also a more, if I can, kind of forward-thinking understanding of where we are with AI regulation, particularly as it relates to the world of work, which I think is a really underexplored area and really requires both more information, more cross-national information, but also a deeper understanding of some of the logics and assumptions that are driving this agenda and who's shaping it. I want to thank, thanks for being invited to this. I think it's very exciting, and it's my first time at the ILO, but certainly not the first time that I've engaged with the ILO. So it's an honor to be here. So I think, and I want to thank Alessandro because he's going to be doing my slides. So if we can go to the second slide, Alessandro, thank you. So what I want to talk about today is, first of all, what I'm going to call types of AI regulations that are kind of existing and emergent. And I think these are going to be very broad-based, but we have seen them already with some of the case studies. And I think it's important to begin this kind of initial typology. These are not mutually exclusive, and we're going to kind of show how they interlock with each other. Then I want to talk a little bit about the political economy of regulation in this respect. Maybe the reason for that is I want to talk a little bit about some of the principles, power, and priorities that are currently existing around this, and the ways in which these are kind of in a very serious way, both becoming standardized, and if you want to think about this in more critical terms, hegemonic, but also very adaptable and fungible to specific context. Then I want to look at the subject of AI regulation, and I think this is really important, and this has been talked about a little bit, but looking specifically at workers and oftentimes how they're being ignored or elided, then looking at what we can call prosumers, and then kind of looking at quote unquote citizens at work. And this is especially important in the sense that a lot of the questions of how this relates to employers and employees is being in many ways influenced by the role of other types of regulations that are impacting citizens. And finally, I want to look at what I think are some new possibilities for AI regulation that we can begin thinking about and kind of show what they might reflect a little bit about the current AI, the current landscape of AI regulation, and what might be some possibilities for the future. So feel free to fall asleep at any time, but I hope that this is interesting. If we want to go to the next slide. So just a bit of background. I mean, a little bit of the work that I have done in this area around AI has, first of all, looked at the relationship between humans and technology, particularly AI, at work within a range of different settings. And I've introduced the kind of concept of transhuman relations here, which kind of supersedes now existing human resource regimes for ones that actually in many ways encompass and are shaped by new forms of digital and technologies. So, you know, if you ever want a cure for insomnia, you can look at my book, Identity, Institutions, and Governance in an AI World. More recently, I've worked very specifically on the surveillance regime, but from a slightly different perspective of asking who is being monitored and who is not. And I think this is incredibly important because actually, while a lot of the work on surveillance capitalism, so to speak, has focused on the surveillance of employees, we've actually seen in the last 20 years, the monitoring and accountability frameworks for employers has decreased significantly. So I'm wanted to really understand, why is it that employees are being monitored more and employers are being monitored less? And I think maybe there might be some organic or intuitive answers to that. But, you know, I think the research also related some really interesting points about how this is being developed, the surveillance technology, who it's being developed for, and the ways in which it can or cannot be repurposed for different types of accountability regimes. And that's something that I'm going to actually touch on in this, because I think as we look at some of the risk paradigms for this, it becomes very interesting in that respect. And finally, some work that I have coming out in terms of what I call the dangers of smart ideologies, which has looked at, and sorry, this might get a bit technical, but it looks at the ways in which the focus of bias within AI has largely focused on traditional notions of kind of demographic bias, which is very important. But what it hasn't looked at is how really unstructured data mining, which is what AI largely is about, actually reproduces very deep dominant assumptions and discourses. So an example is in the UK. If you really looked at this, you would be able to see that the leveling up policy, which is now becoming a major mechanism for this type of skills development around work, is largely based on a pretty suspect suspicion or assumption that is unquestioned that economic development is linked to entrepreneurship, right? So that's kind of the background of what I've been working on. Gosh, I feel like people wouldn't have seen Wheel of Fortune here, but I feel like, so first I want to do reflecting on the types of AI regulation. So if we look at this, and then if we go to the next slide. So I think one of the first things that is understandable is that this has somewhat come out of a tradition of data protection and really a logic of securitization in many different ways. And you can see a kind of one type that is very much based on protection. And we'll get to this later, but it's also very kind of consumer driven, even when it's not directly related to consumers. And it's very interesting. I know Phoebe has done incredible work on this as well, about really understanding also that intersection between what happens when consumers become transplanted as users, and then who is the data subject. And we'll talk about that. But it is very interesting in the sense that this has really been about consumption and use. And a lot of the work that has been done around AI governance so far has largely been, if not copy and pasted, to a certain extent drawn out of a framework of consumer protection, even though users are somewhat different and need to be treated differently than what you might see as traditional 20th century consumers. But the GDPR is very interesting in the EU on this. And for instance, in Brazil, they have something very similar that they're trying to do that has been, really a kind of framework for this. But it's largely, in this one sense, it's about privacy protection, and it's about, proper use. And in a way, it has an almost minimalist effect in terms of like, you should own, or I would say that way I frame it is almost an essentialist. Things like you should only use it if you essentially need it. Now, there are broader discussions about who makes those decisions and how bureaucratic or non-bureaucratic it is. And certainly, like in a place like China, if you would put in something like that, that would be very top-down and very enforcement-driven. In a place like Brazil, where it's much more decentralized, that would be much more, well, we'll do what we want, and then if they sue us, we'll make a precedent decision on it. But what you're looking at here is very much around kind of privacy protection. What you're also beginning to see in a more proactive sense is against biased decision-making. Now, who defines what is biased, how it's defined is also very interesting, and we can talk about that in terms of some of the political economy aspects of this. But it is an increasing awareness that certain decision-making is biased. And some of this has come out in very kind of traditional AR settings. So it's almost like you don't need new regulations for this. So it's when you've been looking at the use of AI for interviewing, right, within a workplace, that has come out and said, well, we don't necessarily need regulations, but we need to include AI when we're using automated systems for filtering and things to make sure that these decisions for who we shortlist and interview are not biased. Now, one of the aspects about this that I wanted to say, and I very specifically put this on here, and Phoebe and I have spoken about this, is there's also a kind of prioritization around kind of harm reduction that is not exactly mapped out into certain risk-based approaches, okay? So in a sense, it's really unclear who's being harmed, how people are being harmed, and who defines what harm is. But yet at the same time, these are necessarily being, if not linked to, then at least associated with ideas of a risk-based approach. So then AI becomes very much within this kind of risk register, as we'll see with the EU, which is about, and essentially, what is risky about AI? How is it risky? And the kind of politics of this then is one that is still up for contention. But it is very much a framework of let's define risk and let's link that to some extent into harm. Now, again, this is why I think something like an observatory is very interesting, because these, to use a very philosophical phrase, I mean, these are, at this point, empty signifiers in a lot of ways. And it's very interesting that I would say, and this is maybe something we could talk about during questions or dinner, or, I mean, I find it interesting, but then I find a lot of things interesting that I know are not, that risk, that traditionally actually harm has been defined much earlier than risk, but AI is very new and that risk has been defined before harm. So actually what is defined as harm hasn't necessarily been fully defined, even within quite, I would say, prescriptive regimes like the EU, but risk has much more. And that's something that, I'm going to use hand gestures here, I guess, but is a kind of switch. And we can look at why that is the case. And I would imagine some of that is the nature of it, some of that is path dependent in terms of institutional logics, and some of that is potentially more discursive or ideological. So then if you want to look at the second type here, That's just an example of if you want to see the risk register, which I know is going to be talked about later. If you want to look at the second type here, is promotion. Now, these are not mutually exclusive, but I think it's really interesting here that there's also a demand to promote AI. And one, this is about increasing competitive advantage. And I think this is something that hasn't necessarily been talked about a lot, but I think, Eckert, it's been good that, you've tried to bring this to the forefront. We really have to talk about AI as part of a labor market, right? And part of a broader market. And certainly within certain countries like the United States and the UK, and it was interesting, recently I sat and presented in Westminster around responsible AI. And the real question that they had was the market for AI and how we be competitive. Like that was the driving aspect of that. And, when, for instance, I was being, again, very boring and saying, well, there's not one AI market, there's markets. And we had, and, one of them as well as a labor market, there was a little bit of a glazed eyes of saying, well, how do we remain competitive in these markets? But that is largely what they're doing. It's a facilitation. And to a certain extent, this is about enhancing economic value, such as efficiency and productivity, but also within a kind of competitive framework, right? So in the US, for instance, there is a wide range of ways in which they're trying to strategically expand AI. And I think it's really important here to mention something about AI. And if this is, again, boring, I apologize. I think that things can get confused in a broader sense. Private companies do not do serious AI research, okay? So any discovery around AI has nothing to do with capitalism. Private. That is all our taxpayer money, okay? But the testing of AI, its ability to be impactful, is completely done by a pretty increasingly low paid and precarious workforce. So it's like us as governments, we pay taxes to essentially, either through public-private partnerships or through direct research investment, make the actual, to make the AI discoveries, like everything that it's doing, like human trait analysis, which is now being used by corporations, that was completely made by South Korea and the United States governments, right? But it doesn't work unless you actually test it in the field. Right. So this is also something that's very interesting, because when we're talking about this regulation as a part of promotion, there's a very strong understanding that this requires a lot of capital. Right. I mean, there's a lot of money that has to go into research and development of this. And then there's a lot of money that has to go into the testing of this. And who does what? I mean, the government doesn't want to do the testing, and the private companies don't want to do the long-term investment into discovery. And how this works is full of tensions, or as we say in academia, it's like full of productive tensions. But the kind of, the front-facing part of this is that it's very much focused on the positive impact that it can have on users. So if we go to the next slide. So this would be kind of examples of this. And one of those that I did put up there is in the UK. I wanted just to show you that this is something that requires a lot of different investment strategies. Okay. Oh, sorry. Is it very small? It's a then and one of the reasons that I wanted to show that is that on the one hand, you can see all the different ways it can be used, but on the other hand, you can see the ways in which it has to have sets of regulations that are part of different regulatory regimes, because it requires a whole range of people to research this, both in terms of its discovery and innovation, right? So for instance, if you take like both in Europe and the United States and the United Kingdom, a lot of this is being done at universities, which are on the one hand run as if they're private corporations, but ultimately are funded supposedly within the public sector. So they have competing kind of regulations. So, and we could talk about that a bit more if you're interested, but this is then the example in terms of when you're looking at AI regulation, about trying to understand the fact that because it requires so many different levels of capitalization and then testing, that you're actually dealing with already existing sets of often contradictory or tension-filled regulatory regimes. And, one of the ways, like, for instance, that in the UK they've gotten around is that they have a big knowledge transfer partnership system. So then when academics work, so they pay academics essentially to work in organizations. So then they don't have to have necessarily some of the same regulations or same things that would be if they were actually doing it directly through a university. Okay. So if we want to go to the next slide. So this, I think, brings us to some of the political economy of AI regulation at work. So I think, there's always a range of different priorities. Ones that I want to really stress here, and I don't want to, over egg it, so to speak, because within these are very loaded terms as well. But one is ensuring decent work. And I think that's really important because who defines what is decent, obviously, who sees this world of work, but there is an increasing demand that when you're looking at this and you're looking at AI, that you're actually putting in place some measures for workers, okay? And we'll get to this in a moment, but I really do want to stress this when we're here. AI does automate things, but it requires a massive human workforce, okay? I'll give you an example just from the ones that we're using here in Brazil, okay? So people have heard things like Bolsonaro has used Facebook to promote things, right? Well, the question is that isn't asked within a lot of the media, and probably because it's not very interesting to people but me, I guess, is, well, if 2 million people are using Facebook more in Rio de Janeiro, right? Who's doing this? Because this isn't just in a made-up cloud. You have to have data processing, which is actually done in Venezuela. So they have to have an actual trade agreement that's a little under the table with that. And this is one of the reasons that the far-right government in Honduras now wants to make stronger things with Brazil, because they think they can do it, for instance, in a better way. Then you have to have, for instance, data labelers, right? You have to actually have people go in and label this data, right? Then you have to actually, somewhat under the table, promote the informal economy of selling people burner phones in these areas. So, I mean, there's a whole ecosystem of work that is involved. So when we're talking about ensuring decent work, we're not just talking about Uber drivers here. We're actually talking about really upwards of almost, I mean, it's very hard to calculate, but we're talking hundreds of millions of people increasingly over the next 10, 15 years who at some level are going to be involved in having to work near with AI. And then fostering new labor markets, because these are new labor markets. And I think that's really important to recognize that this is something in terms of the fact that like these labor markets are continually evolving and continually emerging. And in a certain sense, how do we understand this from a political economy sense, right? So, I mean, I'll give one quick example of this, if I can. One of the biggest labor markets that's happening now is actually content moderation. So you actually need people like to go through Facebook or go through any platform in Twitter, and actually it's a human who says whether something is allowable or not. Now, this is a big labor market because there's a lot of people that are getting employed by this, but who's actually employing them? How is this being employed? Who's doing this? This is a big question, right? So this is just one example of, a really big industry that has largely resulted because people would like more responsible social media. So if we go to the next slide. So I want to look at some different human regulators of AI at work. So in very broad sense, I think that you, on the one hand, you have policymakers. And one thing that hasn't been talked about here maybe so much, but I think it comes to some of the public hearing aspects, but is citizen trust. And it is actually getting trust in AI and kind of creating types of regulations that reflect that. And this would also then kind of trickle down or be things into workers' trust. And some of this is around like, can you use sentient analysis? Do I give you permission to use that data for that? One thing that's also really important here is aligning regulatory regimes. And that's also because, in very particular, I'll talk about this in a moment, AI is extremely non-environmentally friendly. That's a way to put it. So there's a sense of who gets precedent. And for instance, there's been some kind of, interesting things about, like, at the EU level, there's been some talk, can we use AI to support the Green New Deal, right? But then at the same time, it's like, well, it's almost counterproductive, because the more you use AI to support the Green New Deal, the more you're actually creating the very things that we need the Green New Deal for. Definitely employers, and I think this is really important because they are a key part of this, and that's enhancing economic value, maximizing new markets, and maintaining industrial advantage. And in different places, this can be something that is much more individualized at a firm level in terms, or sector level in terms of lobbying. And then in other places, this can be much more in terms of employer lobbying groups. And then employee groups. And I think this goes to a kind of point that Janine mentioned about, there is an ensuring decent work, there's minimizing managerial power, and there's protecting labor rights. Who and how they're involved is quite variable. And it's something that we can talk about in terms of the data subject part, but some of this that could be around actual bringing trade unions to the table has been somewhat engaged in terms of more like, well, no, we'll have citizen engagement. And that's not the same thing as worker engagement, right? So if we go, sorry, to the next slide on this. Sorry about that, Alessandro. As you can see, I have my own human workforce that I'm exploiting. So one of the principles is, what type of economy is AI being regulated for? And there's a wide range that we can talk about this, but there is an assumption that we are talking about a kind of very market-oriented society and a profit-based society. However, again, I think a couple things to talk about with this. There's real questions of revenue, because AI cannot be funded by private capital, and that has been seen. So then there becomes a question of who is funding this and for whose purpose. Then there's a lot of questions as well about, there's a lot of different ways that this can be used, and particularly for a range of different development models. So one example of this is that in the recent pandemic, when there was real issues of supply chain for food, there was a lot of discussion of why can't we use input-output data to do kind of more democratically planned economies within communities that were having food shortages. And that's something that AI can certainly do. It just hasn't been utilized for that purpose. But that would require entirely different regulatory regimes, because then you're actually getting people's data from supermarkets, which isn't actually, it's not entirely sure people's consumer choices in that kind of sense, how protected or not they're protected, etc. One thing I would say around this that I think is quite worthwhile here is that when you begin talking about things like, well, what is it essential for, or how can it be things, is that a lot of the actual usages of AI and technology are things that are kind of discovered afterwards or ex ante, right? And a danger is that when you start putting in place things like you can only use it for this, you are in certain things, if you will, consigning, it from not being used for things that are unnecessary, but you're also in a position of not allowing it to be repurposed for other ends that may be decided by regulators, right? A really kind of interesting example of this is that, I know I always say this to my students, Uber and Deliveroo are not ultimately transportation companies or delivery companies. They're data companies. Uber makes no money off getting people from here to there. They make money because of the fact that people forget to turn off their geolocators in their phone, and they can use that data to sell. Now, that's a very important point, because when actually you then start thinking about, well, if we have all that data, what are other ways we could use it potentially, you know, to, for instance, I mean, one really interesting example was, they wanted to be able to use some of this data to actually help mothers know where it was best for them to breastfeed and where places weren't. And also to make it easier and more accessible for them. But that was very hard to do because it was already consigned that you can't use this data for non-economic purposes, right? So this becomes very interesting when you start signposting what it can and can't be used for, even when it's done for a point of protection. And this goes into power. Whose voices and interests are most influential in being heard? Who's at the table? Why are they at the table? And what is allowed and not allowed to be said? I can say that in the UK case, in the US case, which I'm kind of more intimately familiar, so to speak, I don't know if intimately is the best word, more closely familiar, you cannot speak about anything but competition. If it doesn't relate to competition, you're just not in a positive place there, right? EU, it's quite different. I mean, the EU actually has a whole range of opportunities in different areas to talk about things that, yes, competition is one area, but then there's other things that can come. I think in places like Taiwan, for instance, you're starting to see, I mean, they're in a very different space around this. And you know, so they have a kind of digital minister that is specifically looking at these types of things. And then prioritization, I think this is really important, like which regulations are being prioritized and why. And I think this is important because one of the big aspects about this is the fact that at present, even though they're in a very incipient stage, one of the reasons there's a race to regulate is because AI regulation is going to be prioritized in many policy regimes over sustainability regulation. And part of that is because there has been over the last 5 years an increasing incorporation within sustainability regulation or environmental regulation of really clear workers' rights and decent work for workers. And this is one thing that I try to bring up with the Chinese case, is that they are now moving towards, in China with rare earth mining, about saying you have to have certain standards, right? And if US companies in particular want to do data mining here and want to do rare earth mining, then they have to meet certain standards around work. But these are being increasingly potentially superseded by the fact of, like, well, we have AI regulations. So it's going to be very interesting politically to see that. Look at the next. So I think then we can look at this, like, what kinds of principles are at stake? Are they capitalist or social economy principles? And in what combination? What type of economic skills are being presented and why, and what kind of work? And how are we understanding some of the return on value around this? If we want to go to the next slide, Alessandro. So I think some of the also questions around power is trade unions and policymaking, AI and collective bargaining, and the rights of precarious workers. So those are all kind of understood. I want to focus on AI and collective bargaining for a second, because one of the interesting things is, can you collectively bargain with an algorithm? And that has come up, you know, for instance, in terms of Uber drivers, when they're kicked off platforms, which they see unfairly. And who do they actually collective bargain with? Who do their unions are asking, who do we collectively bargain with? Because the managers say, we have no control over this. And so how do they engage in that? And then some of the priorities that we talked about, some of the broader environmental and political impacts, competing regulatory regimes, and workers' rights across policy regimes. So how do we understand these are being aligned? How do we understand how they're being understood? And which workers are being understood? So I think in a certain sense, one of the things we're going to be looking at here increasingly in terms of this is that what is the difference and how do they define skilled versus unskilled work in AI? So I just want to quickly identify the human subject of AI regulation at work, and some of this I've already touched on. So I think it's important to say that many AI regulations have focused on workers as often citizens and consumers. And this is often around transparency. This is around non-discrimination of themselves in terms of demographics, and this is often in terms of data protection. What is now somewhat coming to the fore, but not fully there, and this is why something like an observatory would be so important, is that you're getting in more kind of pockets and spaces, questions around surveillance, questions around automation, questions around work intensification, and questions around digital control. And in a sense, it's very interesting because regulators are very comfortable borrowing frameworks that are very much focused on citizens and consumers. They have much less precedent for actually discussing this in terms of worker regulations. And it's going to be interesting to see, and I can tell just for opportunity cost reasons, from a very boring economist thing, they often use the frameworks that exist, right? And it's going to be interesting to see what happens when they have to begin moving towards, or if they're willing to, away from the data subject as consumer or citizen and towards it around very specific work subjects. If you want to go to the next slide, Alessandro. So this is kind of also some things that are really important to recognize. The one is the rise of the prosumer. And I do want to take a moment to stress this, and I'm sorry but what is really key about this is the fact that people are producing data at the same time as they're consuming data. And pretty much the entire industry relies on prosumers. Some of that is informal, like ourselves. It's why Facebook wants us to use it so much. And some of it is more formal. I mean, and there's an entire, for instance, Syrian refugees in Bulgaria, their job is essentially to continually take posties and selfies of themselves in order to produce data that can be used for face recognition, right? We also are looking at data work, and this is where things like the quantified self comes in, but also work intensification technologies. And I think it's also really important, again, to recognize that there is what is often called a ghost world of work behind all this. I mean, just for us to use a phone and social media platforms requires not only serious AI algorithms, but an army of data labelers that makes this possible. And then organizations. So, I think we're going to be looking at the ways in which AI is going to be used for monitoring workers, and this is for assessing performance, this is for smart presenteeism, and this is for well-being in AI. So an example in India that we may hear, or I'm not sure not, is that they make sanitation workers, many of whom are predominantly from the lower class, where essentially a GPS watch with a camera on at all times, and it tracks their movements, it tracks what they're doing. If they turn it off, they get fined. And they can actually then use this as a portfolio for judging their overall performance as workers and whether they can continue working. So if we want to go to the next thing. So I think some emerging things are AI and industrial relations. And again, one thing to say is also the wider use of AI and its impact on workers. So a really key example of this is even when it's used for supposedly progressive purposes. So in Barcelona, they've used incredible AI to improve public transportation. And it's incredible, except now this is also potentially given Spain the ability to say, well, if you've got such good public transportation, then why do you have a right to work at home, even if you're disabled? And so this is something also that is going to be very interesting in terms of regulation, in terms of like when data and AI is used for making even positive social impacts, how does this impact then worker negotiations rights and the relationship between employers and employees? So I just want to talk about some new possibilities for AI regulation at work. So one, and this is very forward thinking. So maybe it's good before lunch to have something positive or optimistic, maybe not. One is regulating AI to promote decent work. And this is really important, is that, there is increasingly the ability to use machine learning methods in an efficient and non-data intensive way for identifying underlying values, power relations, and outcomes that actually impact diverse groups of workers across a wide range of existing and emerging labor markets. So right now, most of this is being used to monitor workers, but there's also ways in which you can really use this to inform really better information about how different workers are being treated. And this could also be then linked to the creation of new worker-friendly regulatory frameworks and checklists for organizations that they're already in certain areas are being asked to use, but in a different context, right? So you could say, have you actually done this to make sure that you're meeting equality in your practices, in your decision-making, et cetera? And it's important to say that we actually have a lot of the algorithm technology to do that. It's just about repurposing it, and reframing it, and creating the proper policy toolkits around that. A second one would be, if you want to go to the next slide, sorry, Alessandro, smart accountability at work. And this is actually something that is starting to be used, but hasn't been as publicized much, is using AI to monitor performance of employers and managers in balance with employees to ensure greater accountability for protecting their employee rights. And some of this has been used exactly because, you know, when they used AI to begin understanding response times, which was one of the first things that AI was used for, it was very clear to saying, well, can we actually monitor then the response times of how quickly you respond to us? And you know, I mean, while a lot of this is informal data, you might not be surprised to find that white males get responded to much quicker than any other demographic. So there is a sense of like, we could actually create policy frameworks to use smart accountability techniques and use results for informing employees of workplace cultures, so people have an understanding of that, as well as policymakers for enforcing existing workers' rights legislations. And I think that's especially important in places like Brazil, where things are very much at an enforcement level. If you want to look at a third, this is more forward-looking, regulating AI for a new economy. So how could AI foster more democratic, inclusive, and egalitarian forms of work? This is something that has become really important because AI has been used for mutual aid regimes, especially around things like food provision in the face of the pandemic. And it's being used increasingly for the social economy. So in this respect, we could encourage the use of AI for the promotion of social economy and social value creation, encompassing a whole range of alternative organizations, including cooperatives, as well as new perspectives such as degrowth development, and even in a certain way, post-work societies. And what we mean by that is not that there wouldn't be employees, but actually really saying what are, you know, what would be things like the proper relationship of use of AI for universal basic income, and how does that impact how people work and labor. And then I think the final one is just, I want to thank everyone, and I hope this was interesting. I know I had to go through a lot of information quickly, so I apologize, but I'm very open for questions.
Thank you very much, Peter. I appreciate that. So really interesting epistemological points. Yeah. And I think it's interesting because you're starting to touch upon some of the key questions of our age, and including things like asking questions about human selection bias. There's a lot of discussion around, of course, discrimination, as there should be in terms of algorithmic management, and you're arguing that there are a range of soft regulators that are not often highlighted. And so in an observatory like the one we are discussing, where we're looking at where we're looking at the high level interventions and the attempts at excuse me, looking at a technology that of course is entering in a narrow sense a lot of different spheres, will have implications for the ways that not just citizens are can expect rights, but also of course consumers and workers, and what are the differences across those levels of experiences of harm. And that's something also I've picked up on, I'll pick up on a little bit later as well. The issue is that of course we have changed our schedule a little bit, and now technically we'll have lunch. I think if people are okay with this, we can open the floor for a few comments or questions for just a few minutes, and then we'll break for lunch until 2 o'clock. So we've got quite a period of time for lunch, but I would like to open up the floor for any interventions or questions. Attard, please.
Yeah, thank you very much. And thanks, Peter, for this very interesting presentation and overview. I wanted to pick your brain specifically on this political economy aspect, because that's also something I feel is very important for our work here. And in particular, 2 questions. First, the fact that AI regulation has started out as a way of trying to regulate from a product safety point of view, somehow influences the way we're looking at AI regulation. If it had started out as a way of protecting workers, it would have been much more of a human rights perspective. Then now it's more like risk management, product safety, etc. Is there something that you kind of see also in other places happening, or is that your, let's say, is that your concern more broadly speaking? The other related point to that is we heard a lot from Bo as well in terms of the Chinese situation, the fact that different countries seem to specialize in different parts of the AI development, let's say, space, if you want. And that somehow seems to influence the type of thinking around regulation. Just to give you one example, China seems to be very interested in, in diffusing technology. So they have, I mean, also when you look at other statistics that we have produced in our research, they seem to be very interested in kind of making sure that these tools are scaled at or put out at scale. The US seems to be much stronger in comparison in terms of the production and the actual deep research around AI. Has that any implications in the way of how Chinese policymakers think about these issues than American ones, in your opinion? Thank you.
So I think I'll answer those in turn because they're both very excellent questions. The first point is absolutely. I mean, who the data subject is perceived to be has dramatically influenced in many ways the types of regulatory frameworks that are being proposed and why. I think part of this is the fact that there is a dominant discourse, if you will, that AI is replacing work as opposed to creating work. And I think this human dimension, we talked about this previously, is that I think it's really important to think that people hear words like transhuman and they focus on the technology aspect. It's like, no, it's transhuman because there's a human aspect. And I really think that you're right, that because this has not been framed as, wow, what are we doing? Creating millions and millions of jobs, many of which are in the informal economy or not easily regulated, right? That this has not been a human rights issue. But I think that one of the ways in which it is moving in that direction is through the politics of the political economy. And this is because a lot of the work that is being done around this is by vulnerable populations. And some of these vulnerable populations, if I can be a bit provocative, and if I am, my apologies, corporations got greedy and they started using things that are inherently regulated. And the real question was when they started using non-white workers in detention camps. And when that happened, that all of a sudden becomes a UN issue. And all of a sudden, it's not that we're just using Kenyan workers in an informal economy. You're using something in a public-private camp, and we need to see the records on that. And when that starts to happen, that's when it starts. But it's a slow process. And I think this is why an observatory like this is important, because what ends up happening is that they become more judicial as opposed to policy oriented. It's kind of like, this is a bad case of this. And what legal precedents do we have or need to create, as opposed to do we need to reframe who the data subject is, or at least expand it? Absolutely, in terms of the second question. Now, one aspect that, again, if it's a bit provocative, I know we don't have time to talk about this, but a big part of AI is weapons. And in the US, the political economy is very much linked to weapons makers. And this is particularly around the fact that they have, fairly or unfairly in terms of competitive advantage, a black box budget. It's literally called that. The only other country that has a black box budget like this, perhaps not surprisingly, is Chile, because it's a holdover from Pinochet for military expenditures. And they do huge amounts of investment in autonomous weaponry. And actually, one of the biggest things that is coming up from a political economy perspective on this is that in Africa in particular, they want to use drones for agricultural surveillance, and African countries, even those that are aligned, are saying, this is absolutely not why you're using this. You're using it to test your new weapons. But that's there. So that is a big part of it, right? And it also makes it kind of hard because a lot of things are classified, maybe for good, maybe for bad reasons, but it makes it very difficult then to trace out who's doing what, why, and what kind of things. Now, what you have seen in this case is the fact that certain things come to light that were surprising. So I don't know if people remember this, and the ILO actually covered this in a way, that Google workers went on strike when they found out that their algorithms development was being used for weaponry. And they made the connection pretty quick. And that all of a sudden brought to light of like, why is Google doing this? And how are they doing this? And that was a very interesting question. Now, as to China, absolutely. It's about upscaling and diffusion, and also about making things cheaper. And one of the things that has been coming out around this is that they want to use essentially their citizens as prosumers for this, and they want to sell that. So you probably heard about the good credit regime that is happening, piloting in 2 regions in central China. Well, what is not being, and for those who don't know, people have a digital credit score, and it can be used for a whole range of things. So what is not talked about that is the fact that that is completely driven by actually US tech companies, because they needed the data, and the US regulators wouldn't let them get it from citizens in the United States. So China said, well, if we do it here, can we get some of those profits? And they said, absolutely. So here then becomes really interesting, because this is a fairly inscriptive authoritarian policy, but it's also one that's being driven because it's essentially these citizens then become data workers, and they're making huge profits. So yes, I mean, this really does make massive, because in many ways they're looking at it in terms of innovation, product development, and how do they construct data collection.
Thank you very much. Are there any other questions or points that would like to be raised? I don't think we have any in the chat, have we? Okay, and did you have something you wanted to say? Okay. Okay, we'll break for lunch, and we will return here at 2 o'clock. Thank you very much to everyone, for the speakers and for the audience for being here today. Thanks. Great, Peter. Thank you. Fabulous. Okay, good stuff. Yeah. Would you like to chair this one? You don't want to do it? I have done, you're right. There we go. There we go. Okay. Good afternoon, everyone. Welcome back to our discussion for the proposal for an international labor organization policy observatory that looks at work in the digital economy. And we are very fortunate to have with us our speaker who will address issues around regulation and artificial intelligence and the Canadian case. And so I will introduce Blair Attard-Frost. So you're a PhD candidate at the University of Toronto's Faculty of Information, researching the governance and ethics of artificial intelligence. So absolutely appropriate for today. And specifically, you're interested in the social construction of intelligence and AI, the political economy, ecology, and ethics of AI value chains, and the design and delivery of AI governance services. So absolutely appropriate for our discussions today, Blair. And if I could open the floor for you to I should say, the portal for you to speak for us in this hybrid format, and then we will open the floor for questions, and we look forward to hearing from you. So thank you very much. Blair, if you want to go ahead, and do you have slides you'd like to?
Yeah, I'll share them with you right now.
Okay,
here.
And thank you for joining us.
Yeah, thank you very much. Can you all see the slides okay? Are my slides showing okay? Just want to make sure before I get started. Okay, thank you. Okay, great. Thank you so much, Phoebe, and thank you, Eckhart, and thank you to the rest of the project team for organizing this workshop. I'm really excited to be here and to be speaking with you all today. So as Phoebe mentioned, my name is Blair. I'm a PhD candidate at the University of Toronto's Faculty of Information. And today I'm going to be speaking about AI governance and worker protections in the Canadian context. So I'll give you a bit of an overview of what I'll be going through here today. First, I'll give you a kind of lay of the land of what kinds of AI governance initiatives we have going on here in Canada. And by AI governance initiatives, I mean kind of broadly any kind of policy, standard, strategic plan, program, piece of legislation that attempts to kind of control the design, development, or use of artificial intelligence technologies. After that, I'll be speaking about some key policies and strategies within that landscape. So some of the bigger, you might think of them as kind of like flagship policies or strategies that we have here in Canada, giving you some information about those. And then finally, I'll be talking about challenges and opportunities for worker protection against the backdrop of that larger landscape and those key policies and strategies. So this is a kind of overview of Canada's AI governance landscape, and these numbers are preliminary findings from an in-progress study that I'm co-authoring with kind of Donoghue of McGill University. So what we have here is a distribution of governance areas. You might also think of them as policy areas across 87 AI governance initiatives we've been surveying. And these come from Canada's federal government, as well as the 3 provincial governments of Ontario, Quebec, and Alberta. And they're not mutually exclusive, so some of these governance areas overlap with one another, but this is just to give you a sense of the spread of what kinds of topics that the people involved in AI governance here in Canada are most interested in. So you'll notice across the 6 years we've been surveying, the yellow bar, which represents industry and innovation, is quite high. So these kinds of initiatives are generally interested in things like how to harness AI for economic growth or economic development, or issues pertaining to industrial strategy or intellectual property related to AI systems or technologies, or commercialization or adoption within particular sectors or industries of AI technologies. There's also quite a bit of attention to AI governance initiatives that look at technology production and use, which is the red bar. So these kinds of initiatives specify requirements, ethical statements for the design, development, use of AI systems. You can also see the blue bars, AI research and AI education and training receive quite a bit of attention across each year. And Canada puts a lot of attention, a lot of money into the AI knowledge ecosystem and research ecosystem here in Canada. As we go down the list with data governance and digital infrastructure, there's relatively less attention in these areas. So these have to do with kind of more conventional issues of like data stewardship, data use, data retention, data privacy, things like that, and digital governance, issues of building computing environments for AI, social and workforce issues, so looking at the social and workforce impacts of AI technologies, which I'll speak a bit more about later on in the presentation. And there's quite a bit of attention to public administration too. So these kinds of initiatives look specifically at best practices or policies for adopting AI within the context of delivering public services. So I'll dive a little bit more into some specific AI governance initiatives now. So the first one that I'd like to talk about is the Pan-Canadian AI strategy. So this was the first national AI strategy to be launched by any country, and it dates all the way back to 2017. It was commissioned by our Innovation, Science, and Economic Development Agency, and it was launched by the Canadian Institute for Advanced Research after being commissioned to them. And it initially had a budget of $125 million in its first phase that began in 2017. And the phase 1 programs included 3 national AI institutes. So these look at a variety of issues, primarily AI research, but also in recent years have kind of expanded out to kind of like industry partnerships and like working with industry to do training and cultivate communities of practice with industry as well. There's 3 of them. They're all geographically situated in different parts of the country. So we have the Vector Institute here in Toronto. Over in Montreal, there's Mila, and out in Edmonton, Alberta, there's Amy. There's also an AI Research Chairs program, which was launched. So these are researchers who are looking at kind of different issues in either the primary science of AI or kind of applied research on different uses of AI technology. And AI Futures Policy Labs. So this was kind of a cross-country set of policy labs that CFAR conducted to kind of look at what kinds of AI policy issues that Canada was going to have to contend with. Solution networks, which were the design of specific AI solutions for socially beneficial purposes, as well as training activities. More recently, earlier this year, phase 2 of the Pan-Canadian AI strategy began, and it represents a pretty significant ramp up of the strategy, and almost quadrupling of the budget out to $440 million. And this includes a renewal of those existing programs, the National AI Institutes and Research Chairs in particular, as well as some of the training programs. There's also been introduction of some new focal points and new programs as well. So you can see from this clip I've taken from their website on the right here that they've introduced these key strategic priorities in phase 2. And these kind of represent a greater focus on targeted economic development than we had in phase 1. So you can see there's some emphasis on specifically the healthcare sector, for example, or AI and energy and the environment. Commercialization has historically been a big issue for the AI ecosystem here in Canada. So CFAR is also putting a lot of attention towards that as a strategic priority now. And in addition to that, there's also more attention to computing infrastructure. So there's something called the Pan-Canadian Compute Environment, which is aiming to, under the leadership of CFAR, build out a computing environment for Canadian researchers to be able to design AI systems with. Another kind of key AI governance initiative we have going on in Canada is Bill C-27. So this is also called the Digital Charter Implementation Act. And it was originally tabled as a different bill back in 2020. Then following the federal election we had last year, it was reworked and retabled as Bill C-27 this year, where they added kind of new artificial intelligence component to it. The bill has 3 main functions, which kind of reflect the fact that it's sort of 3 pieces of legislation bundled into one, as you can kind of see from this clip I've taken from the heading of the legislation. The 3 main functions are to enact new protection measures for consumer privacy. So these are things like what can companies do with consumer data? What are de-identification or security or privacy requirements if they transfer their customer data to a third party, for example, right? Or what can they do to use their data for different purposes within their own organization. Another function of this bill is to create a new data protection tribunal that's intended to enforce those new protection measures for consumer privacy. And then finally, that new kind of AI Act that I mentioned that was appended on to the reworked version of this legislation specifies general responsibilities for persons and companies using AI systems to mitigate risk and harms associated with those systems. So using kind of an analog from the EU, you might think of Bill C-27, the first 2 functions of it, those first 2 acts, as kind of Canada's localization of GDPR, so specifying kind of general requirements for data protection, as well as the enforcement of data protection through penalties and a tribunal structure and other kinds of administrative structures within the Canadian context. And you might think of the third piece of that as kind of Canada's early localization of the EU's AI Act. So it kind of rolls a few different functions into one. This next initiative is the Directive on Automated Decision-Making. So this is a pretty significant one for the federal government. It was put into force by the Treasury Board of Canada Secretariat in 2019. And it only applies to a select group of federal institutions. And what it does for these institutions that are within the scope of this directive is it specifies a series of operational requirements for the design and use of automated decision-making systems in their kind of public service practices. One major thing it does to kind of enact that is it's accompanied by this algorithmic impact assessment tool. And on the right, you can kind of see how the directive corresponds to these levels of impact that are specified by the tool. So anyone that's developing or implementing a automated decision-making system within the federal government has to complete an algorithmic impact assessment. And through that assessment, there's a determination of the risk of that system. And system risk is divided into multiple categories based on the tool. And then depending on what the system risk is determined to be through the algorithmic impact assessment, there's various mitigation measures that might be required before putting the system into production and use. I also want to talk about a couple of notable Ontario initiatives. So here within the province of Ontario, we have artificial intelligence guidance. So this was launched by Ontario's Digital Service in 2021 following a public consultation process. And it specifies 6 general principles for ethical use of AI, as well as 8 best practices for AI transparency in Ontario's public sector. I won't get into too much detail about what those principles and best practices are right now, but I'll be making my slides publicly available later. And there's a link in there in case you're interested in exploring. They're kind of general principles and practices like what you might expect for artificial intelligence guidance at this point, things like making your system human-centric or having a human in the loop or making it transparent or explainable, right? Another initiative that I'd like to talk about in a bit more detail, since it pertains to the topic of today's workshop, is the written policy on electronic monitoring of employees. So this was added to Ontario's Employment Standards Act earlier this year. And what it does is it requires employers with 25 or more employees to maintain a written policy describing how and why they electronically monitor employees. So crucially, this doesn't mandate any worker protections or cover AI technology specifically. All it does is it says that employers need to keep a written record of how they're surveilling their employees, right? And in fact, within this written policy, they specify clearly that it doesn't, quote, affect or limit an employer's ability to use information through the electronic monitoring of its employees in any way it sees fit. So this could be kind of the prelude to a broader regulatory initiative in Ontario, kind of using this written policy and using these written records that employers are keeping to specify certain prohibitions or restrictions, but we don't know that for sure. For now, there's no worker protections associated with it or kind of attention to worker rights. It's just employers have to keep a record of this. And that brings us to some challenges for worker protections here in Canada. So Canada currently has no policy or strategy with a distinct focus on protecting workers from harmful practices of AI development and use. Where workforce policy and strategy does exist, it usually focuses on issues related to that yellow bar you might remember from my first slide about industry and innovation, right? So a lot of the workforce initiatives are very concerned with kind of skills and talent development, issues of economic development, or hypothetical labor displacement scenarios that usually come under the banner of future work. So thinking about like how workplaces might be disrupted by the introduction of automation, what kinds of wraparound supports and policies might be needed to help workers, which, as we've seen in more recent years, haven't largely panned out the way that many people had initially envisioned they might. What's kind of lost in this focus on taking AI-related workforce policy issues in service to issues of economic development is there's not really much of a focus on worker rights or workplace safety in a lot of our AI-related workforce policy and industrial strategy. There's also no prohibitions or restrictions targeted at high-risk AI applications like automated employment decision-making or employee surveillance. So as we saw in the context of Ontario, we have a written policy that employers have to keep a record of what kinds of applications, what kinds of tools they might be using to surveil employees electronically, but there's no prohibitions and restrictions at the moment on what they can and cannot do. And there's also no targeted regulations for particularly vulnerable workers within the AI value chain, like data workers or content moderators. So there's a few opportunities because of those challenges to introduce better worker protections in the Canadian context. I'm going to go through 3 main ones. The first would be to revamp AI policy and industrial strategy in Canada. Right now, there's a very significant focus on consumers and innovation, which is fine. It's necessary. Things like Bill C-27, being able to protect the privacy of consumers and what companies can and can't do with their data. We need some kind of policy like that, right? We also need some kind of policy which will help kind of set an agenda, industrial agenda for how AI can be used to create economic benefit. But what we need in addition to that, which we don't have in these kinds of policies and strategies right now, is a focus on how AI systems and their development is impacting workers and worker safety. And these are pretty key issues, I would argue, for industrial strategy. Workers are a key part of industrial processes. There's many challenges to worker safety that are introduced by AI systems, and these types of policy and strategies have a pretty significant opportunity right now to put greater emphasis on workers. Another opportunity kind of related to this would be to introduce application-specific policies. So either through legislation similar to PLC 27's AI and Data Act, or even through kind of like internal policies such as the Directive on Automated Decision-Making. Application-specific policies like the EU's AI Act, for example, can be adapted to the Canadian context to institute worker protections by, for example, prohibiting and restricting the use of particular types of systems like automated hiring tools or facial recognition in the workplace that we know to be kind of inherently high-risk applications for workers. The third opportunity I'll suggest is a little bit more of a broad one, and that comes from the idea of targeting the kind of systems of ethical reasoning that underlie a lot of policy and governance initiatives. I think there's a real opportunity here looking at worker protections to rethink AI ethics as a value chain ethics. So kind of instead of thinking about AI ethics in terms of primarily technical or computational issues related to data algorithms, socio-technical design of systems, to rethink AI ethics in terms of like a full spectrum of resourcing activities that are required to create and operate AI systems, right? So if we were to take that kind of approach, we might think about particularly vulnerable workers like data workers and content moderators within the AI value chain, as well as issues like data collected from the electronic monitoring of employees, right? Where does that fit within an employer's value chain, and therefore what like prohibitions and restrictions should be put on it? Thank you very much for listening today. I'd also like to thank the University of Toronto's Faculty of Information, the Social Sciences and Humanities Research Council of Canada for supporting the research that this presentation is based on. As I mentioned, I'll be making my slides publicly available on social media and my website. I've included some further reading on these topics here if you're interested, so be sure to check the slides out if you'd like to learn more. Thanks again, and I'll take any questions now from anyone who might be interested.
Great, thank you very much. So excellent. We really appreciate this great presentation looking at the Canada case. And I'm going to take this one off so that I don't. Okay, so I'd like to open the floor for questions and interventions from any of you who would like to put forward any questions. I don't see any so far in the chat. Attard, please.
Yeah, thank you very much, Blair. Great presentation. The one question I would have was with respect to one of the first slides that you presented about the different initiatives taken in different sectors, in particular on the one on public administration. I wanted to ask you whether you can tell us a bit more about to what extent public procurement policies are being used strategically by different administrative bodies to push maybe the regulatory envelope as well. I mean, as you know, certainly that public procurement policies often are used for standard setting purposes as well. And I was wondering whether there's anything in that direction that you see in Canada happening. Thank you.
Thank you. That's a great question. So I think at the federal level, if you recall the Directive on Automated Decision-Making, what that's, I think, ideally supposed to be used for is as kind of an intervention in public procurement processes, in addition to any kind of development or use of any kind of internal AI systems within federal agencies. It's only been applied to 4, I think, automated decision-making systems that have been adopted by the federal government so far. But they've all been kind of co-created in collaboration with external suppliers. And one kind of piece, so there's that algorithmic impact assessment as well as the main directive, but one kind of piece of this that I didn't bring up is there's also kind of a suppliers list attached to that policy ecosystem. And the suppliers list specifies a group of kind of like pre-authorized vendors who can be involved in transacting with the federal government up to, there's different levels of vendors, and each one has like a particular budgetary amount that's assigned to it based on that level. So it is being used to intervene in those kinds of procurement processes to some extent by kind of mandating suppliers, like if you want to build a system for the federal government, you have to follow these rules. The suppliers all have to fill out that algorithmic impact assessment themselves. And then I think it's been quite a while since I kind of looked at it from a procurement point of view, but I think the way it works is supplier fills up the algorithmic impact assessment, I think in collaboration with whatever agency that they want to build it for. And then the algorithmic impact assessment essentially functions as an ethical intervention in that procurement process to determine what kinds of mitigation measures might need to be undertaken for that system before actually putting it into production within the government. Other than the federal government, I don't know of any interventions we specifically have around procurement in provincial governments. In Ontario, there's ethical guidelines for the use of AI systems within the public service here in Ontario, but those are more kind of a series of best practices. They might be adapted into kind of similar like mandate to directive or internal regulations similar to the federal level in the future. But for right now, they're essentially just a set of best practices that could ostensibly be applied to procurement decision-making, but yeah, that's not their primary purpose at the moment.
Excellent. Thank you very much. And we have a Q&A question as well there. And Peter, you'd like to go ahead and ask your question?
Sorry, can you hear me?
Yeah.
No, it was a fantastic presentation and very informative. I had a question about just a kind of factual question because I don't know the Canadian context overly well. You mentioned in Ontario that they're, doing things that could potentially set a troubling precedent. Could you maybe talk a bit more about what the actual legal frameworks of when something is done at a regional level, how that actually can and could, I guess, impact things at a national level? And I think that also is interesting because when you're dealing with surveillance, there's a variety of parts about it. So, you're dealing with it actually in Ontario, but then we don't know where this is actually being analyzed, for instance, and maybe that has a different set of regulations. So I'm just, I'd be interested in that because as far as my understanding initially, and again, this might have changed, that a lot of the data analysis, like serious high level stuff, is often shipped over to Toronto, for instance. So I was just kind of interested in that because I don't know the Canadian case particularly well.
Yeah, that's a great question. I guess first I'll address this kind of issue of like how likely is a provincial initiative like this in Ontario, how likely is it to be translated to like the federal context, right? One issue we have with kind of tech policy in Canada in general, and this has kind of panned out in the domain of AI policy as well, is there's a lot of decentralization through different levels of government. I think this is like a broader reflection of Canada's like federal system of government, where provinces engage in kind of a lot of decision making on their own. They have pretty broad jurisdiction in areas of tech policy, especially that's separate from the federal government. But there is a lot of knowledge sharing and sharing of best practices that kind of goes on behind the curtain between different levels of government. So it's very possible. I know there's a lot of interest, for example, in Ontario of adapting the federal directive on automated decision-making to specific internal policies of specific provincial agencies. And actually in the city of London, which is a city here in Southern Ontario, they actually adapted the directive on automated decision-making to AI development and use within their own municipal government. So there is like a lot of appetite for that kind of, taking initiatives from one level of government as a model and adapting it to a more localized context in Canada. There's as far as like employee surveillance laws and employment standards go at the federal level, I'm not too familiar with what exactly that part of the government federally is interested in, like if they're kind of looking at their own specific adaptation of what we're doing here in Ontario, what that might look like. Regarding the second part of your question regarding like data analysis being done at different points in the country, could you maybe just elaborate like a little bit more on, like, I'm just not too sure what the nature of that question is.
So just very quickly, because I know there's other questions, and it's just something maybe to consider, is that there is increasing regulation at the point of surveillance with workers, right? But there's less right now oversight in terms of actually like, well, the data is being collected there and the systems are in place there, but the data has to be analyzed somewhere. And that is often outsourced to actual other companies, to other firms, and to other agencies, depending on the context, that are not necessarily in these particular areas. And I think I was interested in that because when it's at a national level, that usually doesn't matter, so to speak, right? But if it's at a provincial level and they're collecting it in one province, but it's being analyzed at another province, it's very interesting to me in terms of jurisdiction and potentially competing regulatory regimes.
Yeah, that's a great question. I kind of see what you're saying now. It's one thing I kind of will say with that, again, regarding like some troubling precedents we have for this here. So at the federal level, which would cover, of course, the provincial level, Bill C-27, which regulates consumer privacy and transfer of consumer data, explicitly leaves out an exemption for kind of employers or companies like own internal data about its operations. So it only covers kind of consumers, customers of the company, and not workers or employees of the company. So one precedent that's being set by its lack of attention for workers is that there is no kind of legislation for that kind of data transfer, data analysis, reporting it to like other provinces within the country or to other nations entirely at the moment, right? Conceivably, there could be if like a greater framework for employees were included in that legislation alongside consumers, but at the moment, it's very much consumer focused.
Thank you very much. And we have actually a question in the Q&A for our international audience. So Kei-Sin Hung asks, great work, Blair. Could you share a bit on how currently harms and risks are being defined and regulated and potentially later standard setting devices, and who is defining these in Canada? Also possible certification processes, which are in the AIDA, so the AIDA Act. Can you also see the Q&A? I can send it over to you.
Oh, yeah, I can. I just haven't checked it here yet.
So the question is, how are hazards, harms, and risks being defined and then also regulated? Okay, you got that. Thanks a lot.
Yeah, thank you. Thank you. Thank you for the question. Regarding harms and risks being defined, specifically in the AIDA Act, they're not being defined right now. So at present, the AIDA Act doesn't really specify what a harm is. In fact, it kind of leaves it to a future. There's going to be a commissioner that's appointed. So part of this act calls for a commissioner to be appointed, as well as, it's been a while since I've read it, but there's a whole kind of ecosystem of decision makers that essentially proposes to set up. And I think the main one is a commissioner amongst these, who will later define some of the key terms in the act. And harm is one of those key terms, which the act says we're going to leave it to define through like this kind of series of expert judgments later on. It uses terms also like high impact system, I believe is the term that comes up through it a lot, or high risk system it might be. But again, that's a term that it doesn't specifically define. It just kind of specifies a set of requirements for high risk or high impact systems. I forget what the exact terminology is, but without defining, what the criteria for a high risk versus low risk system are. So right now we're kind of taking this very characteristically Canadian approach, I think, to defining them, which is we're going to do some consultations, we're going to do some targeted engagements, we're going to set up a committee, we're going to set up a commission, and we're going to figure out through that network of experts how best to define it, right? So that's simultaneously a troubling precedent, but as well as kind of room for opportunity as long as kind of that consultation process is done in a very public facing way to determine what the public more broadly thinks would be a harmful system or a risky system. Whether or not that will be done, I'm not quite sure yet. Possible certification processes in the AIDA Act. I mean, it certainly leaves room, like any kind of piece of AI legislation does, for some kind of certification processes to be set up. But the difficulty for certification, the AIDA specifically right now, is just how vague it is in defining some of these terms, right? Like it's very difficult to set up any kind of certification program or have some kind of company that can, kind of provide like an audit of a company's compliance with the AIDA when it's not really specifying, what even constitutes a high risk or high impact system or a harm at this point, right? So it's still a very, I would say, like underdeveloped piece of legislation, but it'll hopefully get to the point eventually where those kinds of certification processes, auditing regimes, like markets for those kinds of practices are able to be set up. But there's still a lot of work to be done before it gets to that point.
Thank you very much, Blair. Good stuff. Do we have other questions or points that people wanted to raise? Got a bit more time. How about in the... Oh, please, go ahead, please. Thank you.
Hi, thanks for the informative presentation. I was intrigued by this automated decision-making, like algorithmic impact assessment. I wanted to know a little more about this, like who does that? Is it an independent organization or is it kind of a self-assessment tool? And who all are the people targeted? And then what is the outcome of this assessment? Like, do you categorize the risk, or what's the impact of this impact assessment? Also on a political level. Thank you.
Thank you. That's a good question. So the outcome of the impact assessment is kind of like you guessed, like an assessment of risk. So a particular risk level is given to the system based on the results of the assessment. The assessment involves a lot of questions. So it's directed towards the supplier as well as the agency that are intending to implement the system. And what it essentially asks is a series of questions related to what's the system intended to do, who's it going to, like what kinds of data is it going to be used to process, what kinds of decisions is it going to make, what kinds of citizens, clients, they would call them, of the agency might be impacted by them, what's the nature of the impacts, the potential risks, is it kind of social risks, environmental risks, risks to particular communities, things like that. So there's a lot of data that has to be provided by supplier in conducting these impact assessments, as well as by the agency that wants to introduce the system. And I believe that kind of gets fed into the Treasury Board Secretariat, who oversee this directive, and then the kind of assessment of risk level is made, and depending on the risk level, if it's determined that production of the system can go ahead, there's a particular set of requirements and mitigation measures that the supplier and the agency who's kind of like co-creating that system with the supplier would then have to follow. Hopefully that helps.
Thank you very much. So we have 3 more minutes until our next speaker. So if there are other points or any questions for Blair. Let me just look in the question and answer. Is there anything in question and answer? No, right? We don't see anything. Nope. Okay. Well, in that case, I'd like to say once again to you, Blair, thank you very much for taking the time to be with us today and for your excellent talk on the Canada situation around regulation and AI. Thank you. Thanks for being here with us. So Attard will be chairing Alex Engler, who I see is with us here already. So over to you, Attard.
Yeah, thank you, Phoebe, and thanks again for Blair for his presentation. So I suggest we start now already. I mean, it was 2 minutes before, but I guess most people who want to be here, they are already here in the room anyway. So let me welcome Alex Engler, who is a fellow in governance studies at the Brookings Institution, where he studies the implication of artificial intelligence and emerging data technologies on society and governance. Engler also teaches classes on data science and visualization at Georgetown's McCourt School of Public Policy, where he's an adjunct professor and affiliated scholar. Alex, we are very pleased to have you with us today and very much looking forward to your presentation. As per usual, we have in total 45 minutes for you. So if you can leave a few minutes at the end for Q&A, it would be great. So thanks, over to you.
Great. Thanks so much for the warm introduction. I'm going to share some slides, if that's all right. Can everyone hear me and also see the slides?
Yes, all good. Thank you.
Great. So I'm going to talk about regulating AI in education and labor in the US context. A quick intro. Mention that I study this work at Brookings. I come from a data science background, so as an applied data scientist in policy institutions, governments, and think tanks, working in social policy for a long time. So I also work on some of this in tax policy and housing and healthcare provisioning and so on. And the other thing I want to mention is I'm working pretty extensively with the EU on the EU AI Act through the Center for European Policy Studies. So to the extent that I can make some contrasts, I'd be happy to do that. To the extent that questions at the end also want me to touch on what's happening with the EU AI Act, I'd be happy to do that as well. And the thing that's maybe an important contrast here is the US approach is now about as distinct as conceivably possible from the EU approach. And I'll try to draw out that distinction a little bit as I talk about this. So what the US is most useful for in this situation is understanding the scope of what I call algorithmic creep. This is the degree to which algorithms have slowly started replacing or being involved in processes in education and labor. The list is quite long. I would say this is a relatively high level list. And I'm going to talk about a series of these. But you have a number of ways in which algorithms are fully replacing people and completely automating things. You know, early stages of AI hiring, right, where the first tranche of candidates is removed automatically, is very, very common now, especially by large employers in the US. I would say maybe as many as half of all four-year colleges are now setting tuition with artificial intelligence. We have big growth in the digital credential space, in the workplace surveillance space. The US really our first value as a country is that you can tell the degree of use of algorithms with few or little protections. The other thing that's useful about this is you get a clear sense of how distinct these are. This is a range of algorithmic uses that's quite broad, and within each of these, I could split out many, many individual uses. So just an example, within job search, recruiting, and hiring, we can talk about the algorithms on LinkedIn that help you find a job or help a recruiter find you. We can talk about an automatic filtering system that looks at several requirements, like do you have a college degree, and then includes or doesn't include you in that. There could then be a predictive step where an algorithm pulls out some data, maybe actually an algorithm pulls out data from your resume or cover letter, and then uses that to predict how potentially good of an employee you would be, right? A supervised model based on past performance. And then even past that, you might see, in some cases, automated interviews or partially automated interviews. And that's all within one of these categories. So this degree of algorithmic creep in the US is enormous, and it's worth keeping in mind that because there's so many different applications, it's incredibly hard to write down consistent rules and approaches for all of them. And that is why the US is not going to try to do that. This brings us to the AI Bill of Rights, or really the blueprint for an AI Bill of Rights. This was just released about a year and a half in the making from the Biden administration, led by the Office of Science and Technology Policy, as well as from the Domestic Policy Council. And this does a few things that are useful, and I want to give it credit for what it does do that's genuinely valuable. It does detail a broad US approach to algorithmic harms and AI violations of civil rights. It sort of presents a very broad, it's very long, very detailed, a broad contextualization of why AI is causing harms broadly, not so much in products or services. I'm sorry, not so much in physical products, not so much in digital platforms as much. It's really aimed at AI, what I call like AI human services. This is, education, labor, housing, financial services access, healthcare provisioning, typically areas where government has had pre-existing regulatory roles, but now there's sort of this algorithmic proliferation in all of these spaces. And in articulating this broad contextualization of AI harms, actually just something the Trump administration and former administrations haven't done quite so formally. So at least we have a statement that says this is a significant problem. It's a significant problem for the US federal government. It does articulate principles. Again, I think we're all a bit exhausted of AI ethics principles, but given that there weren't any from the sort of US federal government in the past that were quite so clear, it's useful that these exist now, and you can see the 5 here. Safe and effective, which does reflect quite a bit of fraud and ineffective AI systems in the US. Notice and explanation, making sure people know that they're dealing with an AI system and have a mechanism for redress. Algorithmic discrimination, which of course is a big issue in hiring, especially in other areas of employment. Data privacy, I appreciate that they're including data privacy as a first order concern of algorithms, certainly tied together. And human alternatives. Can you get a human to look at your application or your process if you think the algorithm is misbehaving, flawed, errant, or otherwise? Okay, so great. So principles, it's good that we did that since we hadn't really so much before. And then what you see in this document is reference to many, many federal agency and some state and local interventions that are adapting current law and making changes to adjust to algorithms. And this is what I mean when I say about as different as an approach as possible from the EU. This is my long piece. The AI Bill of Rights makes progress in algorithmic protections. I encourage you to read that if you want a deeper dive. Essentially, the broad takeaway is the US is going with sectorally specific and really even application specific AI governance. This means you shouldn't expect a broad central document that says, here's how we're going to create, rules for every AI system in every regulated space. I just don't think it's going to happen at all at this point. Rather, you're going to see individual application level regulatory adaptations, mostly by federal agencies. It's good to know that this is the way the US has been trending anyway. I think the blueprint for the AI Bill of Rights makes it abundantly clear that that is the path that the US is taking, with some possible legislative exceptions, though it doesn't seem like there's going to be a centralized push there. You could argue that there are changes in the proposed Data Privacy Act that I can talk about if that's of interest, but mostly this is the path forward. There are real advantages of this. this was a considered choice. You could just say, well, the US is really struggling to legislate. Congress is working very slowly, if at all, and thus the US is forced to do that. That is kind of true, and I don't want to diminish the fact that it would be very hard to legislate in the space in the near future, because there's other priorities, and it's taken the US so long, for instance, just to get to an agreement on data privacy, and this would certainly come after that. But there are real advantages to this approach, even aside from that significant limitation. A really good example is that sectorally specific or application specific approaches enable really targeted interventions. There's a great program from Housing and Urban Development that's looking at automated appraisal algorithms. These are algorithms that estimate property valuation. Property valuation is incredibly important for how much wealth people have, since a lot of American wealth is tied up in property. And that's not just an algorithmic question. It is both an algorithmic question, and it's also a question of individual property appraisal professionals. It is a question about the entire field. It is a question about banking and financial services practices. And they're accounting for this problem altogether with a significant focus on the automated systems, but not assuming that they exist on their own or in a vacuum. And that's an advantage of this. Housing and Urban Development can address this problem systemically and propose rules, including rules on automated valuation, property appraisal systems. That's a real advantage. I also think you're more likely to get good work if you have an agency-led approach. What I mean by that is federal agencies are going to tackle problems for which they have invested interests and where their stakeholders are pushing them to invest. That's certainly true in the Housing and Urban Development case. Lots of US nonprofits and advocacy organizations, activists want to see progress on this. And so when fair housing activists push HUD, they react, and you get a genuine investment in working on this problem, tying algorithms and non-algorithmic approaches together. That's really valuable. And I think overall, you're going to get much better work on this application-specific challenge by going through that process. This also helps sidestep the insane number of challenges that occur when you try to write centralized AI guidance for every problem you can imagine. And this is a very real problem in the European Union. The European Union still, to this moment, does not have a set agreement for what an AI system is. And that, not only is that a problem for really understanding what the current proposed legislation would do, it's also a problem for writing more specific parts, right? So I'm working with the EU on what's called the AI value chain. So how do you regulate when multiple organizations together contribute to building an AI system? And this challenge, which is probably resolvable, gets even harder because you don't have this upstream AI definition. And the reason the definition is so hard is because you're trying to say, well, how is every field using algorithms, every field the government cares about using algorithms? And that turns out to be a nearly impossible task to answer. Similarly, writing down all the potential high-risk requirements, what to do for high-risk AI, across healthcare provisioning and worker surveillance and monitoring and educational access. Some of these systems are just different. They do different things. They exhibit different harms. And so the AI Bill of Rights, the whole US approach is sidestepping that set of problems. And that is, frankly, an enormous advantage, right? We can just have federal agencies do this. Of course, this also comes with very real disadvantages, and we're going to see that disadvantage on full display in the education and workforce space. This means there are gaps. There is no central guidance that says you must create rules and standards for this list of AI challenges, right? And while some agencies have really started in earnest, and I think there is significant progress, educational labor is not one of those. And so we don't see nearly as much progress as I think a lot of activists in the US would. Part of this is the Trump administration was not particularly interested in this, and so it took a long hiatus. But arguably part of this is from agencies being a little understaffed in the transition from the Trump administration to the Biden administration. But even if you're being generous with those, progress has been quite slow. So here again is that list of major high impact areas in education labor where you're seeing really structural transformations, as in algorithms are now doing a significant or even sometimes the majority of these tasks, right? A significant portion up into maybe a majority of these tasks. And it's growing, and I think we'll see a majority in the not too distant future in many of these, and who you would then need to convince to take this seriously. And it's Department of Education and Department of Labor are big here, the Equal Employment Opportunity Commission for hiring, and states in a lot of the educational applications. And so again, here's the downside: you have to convince different agencies within different capacities to invest interventions to make progress on each of these issues. Okay, let's talk about a couple of them. I'm not going to go into incredible depth, but I'll have some resources on more, and happy to come back to any of them. One that you might not know about, but may show you the future here. I would say most, as many as half or more now of colleges are using algorithms to set individual prices for college tuition. They're not literally setting college tuition, they're setting how much tuition aid or scholarship support you get, but functionally it's the same thing, right? If I give someone 10,000 in scholarship reduction or aid, I'm essentially just setting the price of tuition. And broadly, this includes many public institutions. And broadly, this is raising the cost of college. It's also setting the cost of college closer to students' ability to pay, which is, or I should say willingness to pay. That is how much they're willing to accept the cost when they enroll, which is not necessarily the same thing as their ability to pay or their ability to get financial aid or their ability to succeed in that school at that level of financial support. So I'm fairly convinced, looking at the literature, that this is raising the cost of college for students, and also likely reducing, hurting student outcomes, both in terms of their academic success and their likelihood of graduation. Department of Education could set standards on this. States could ask their public universities not to do this or require that they don't do this, but nothing has been done. So here's the downside, right? No federal law, no centralized guidance, and thus, so far, no action. I expect to see more of this. I expect this trend to continue without standards. I think essentially, because so many colleges are doing it, essentially all of them will have to, unless there's some centralized guidance that prevents it. So you get in higher education, in one of the foundations of economic mobility, you get almost an entire market of targeted pricing, which is a pretty terrible outcome, frankly. AI for proctoring and grading. This is common, progressively more common in K-12 education, but also in higher ed. The proctoring example here is, imagine you are taking a test, but you are doing this remotely, and software will ask you to turn your computer in a circle in the room that you're in, and it will scan the room, and then it will watch you as you take the test, and it will try to determine if you are cheating, if you're using notes, or if someone's helping you. That doesn't work. This dramatically overstates the capacity of current AI systems. Computer vision just can't do that. It's not even close, right? The complexity of understanding a situation as to whether someone is using an aid goes far beyond the current understanding of AI systems that can do things like identify what's in a photo, but don't understand the context or what's happening in it. Another example is for grading, which we see on open-ended written tests and responses to students. Again, AI systems basically fundamentally lack the a capacity to do this from an understanding perspective. There's two potential things that could happen here. We are seeing in the AI Bill of Rights, the Department of, in the announcement, the Department of Education announced that it would create guidance on educational technology tools to come in early 2023. That would be a space here where we can see a guidance around things like AI proctoring and grading systems, as well as personalized learning or algorithmic personalized learning in classrooms. And hopefully we will see that, but just to drive this point across, whatever ed does will be the standard for the foreseeable future in the US. it's not clear that, and I wouldn't expect more than that. So sort of a lot comes down to where the agency lands early next year. The Federal Trade Commission is also occasionally sort of threatened to enforce its mandate over fraudulent market claims. I think it would be great if the FTC could be convinced to go after some of these companies that are just engaging in wild AI hype and speculation. But while they have sort of threatened at that, we have not actually seen enforcement actions yet. So they could say, hey, you're making claims with AI that go beyond its capacity. You need to really prove that it can do this and sue them. But that hasn't happened yet. Another big trend in this space, this is the only half step away from algorithms that I'll do, but I do want to talk about the explosion of digital credentials. Digital educational credentials, which don't overthink this, it is just a digital version of a paper credential instead of or in addition to a college degree, right? You would also get a digital, piece of data that's verifiable, that proves that you have a college degree. These are getting much more common, not really that often for college degrees, but for any educational credential. So you may have heard of digital badges or micro credentials. You can get skills-based mastery. You can take a programming course or master in architecture software and get a digital badge. These are really exploding in the US, over 1 million a year issued now. And the reason it's important to keep an eye on this trend, and this will significantly affect everything that comes after it. Because there's an explosion at the skill and educational credential level of this data, this will fuel all these algorithmic uses that we're about to talk about and enable much more specific, much more targeted algorithms. And I would just expect that the more you see broad digitalization of education data, the more you see algorithms in hiring and employment and so on. So what are these used in? These are used in course recommendations. An algorithm can say, okay, you have these 2 related skills, something that would improve your career outcomes is this 3rd skill. Here's our course recommendation. Do that. You can think of that on an e-learning platform or a MOOC platform. These are also very commonly used in candidate search, things like used in LinkedIn for a recruiter to help find candidates, and also in hiring in the actual funnel process of reducing a number of applicants. In some ways, these might be good. Having data that enables more specific searches for job candidates is in fact a good thing. A lot of applicant tracking systems and hiring algorithms currently use very broad measures. They might say, we're going to filter only to college graduates, which is somewhat common. And that leaves out everyone who doesn't have a college degree, even if they have the pertinent skills for a job. So you could argue that, and proponents will argue that digital credentials will enable better algorithmic uses in hiring, and thus you will see more specific job hiring and candidate search algorithms, and thus sort of a better, tighter labor market where jobs are better attached to skills. I think that's reasonable. I think that's plausible, though it's that may be a little ways away. But I certainly expect these to continue, and thus the algorithmic uses to expand. So there is an intervention at the data level, and it's worth realizing. I know this is about regulating AI, but many interventions are also important. Often policy interventions are also pertinent, also at the at that sort of data level. And a big one here is interoperability. If this market is left on its own, it's not clear if learners will be able to move their digital credentials around, right? If they will have full control over them and if they can move them between different services, or if they'll be locked into specific platforms. And in a lot of other areas of data and algorithms, we have seen like platform lock-in, where the providers of the data try to keep users within their own digital ecosystem. This is still an evolving market. There is some signs that vendors of the digital credentials, the issuers, will support interoperability, but if they don't, I think it's important that states and especially universities, and especially public universities, choose interoperable formats that lets learners move their data around. And also, if this really goes badly, you could try to legislate interoperability in digital credentials, which I think has a reasonable argument. And in some ways, the US is regretting not having done that with electronic medical records. Happy to come back to this. This is one of those issues you may not have heard about, but it's sort of underlying a lot of these hiring and employment trends, especially towards skill-based learning, and especially in course recommendations, educational pathway recommendations. And it's worth making sure we're considering the data environment that underlies the algorithmic emergence. Okay, very, very common example that I'm sure you all heard of: job search, recruiting, and hiring. There are many problems here. Let's just stick with discrimination. There is some progress here on discrimination specifically. The Equal Employment Opportunity Commission has released technical guidance on algorithmic hiring and how current law, especially the Americans with Disability Act, affects people hiring and discrimination in AI hiring against people with disabilities. It has not adapted or interpreted the broader set of civil rights laws on hiring protections, but it did release a meaningful document that really says even individual discrimination, right? If your AI hiring process prevents even one person with a disability from getting through your hiring process, then that is illegal, right? It's not about group fairness. It's not about saying most people with disability must get through, or an equal proportion must get through. It's saying that if your system prevents people with disabilities from getting through the hiring process, that is a violation of the Americans with Disability Act. And that is actually a really, I think, a strong and good interpretation, and is very specific to hiring. It's specific to the Americans with Disability Act. It's specific to the EEOC. And hopefully we'll see people be able to enforce that. It's not completely clear we will be able to see enforcement, but it is a strong interpretation for people with disabilities, and I think a good one that you may not have gotten from a broader, AI standard that affects many services. So I think there's some progress there, and that's encouraging. I am hopeful that the EEOC, which has been relatively active on this and in fact started this process before the AI Bill of Rights, will continue to adapt their guidance, especially in discrimination against other groups, so racial minorities, women, etc. New York City has a law that passed that will require audits for bias in AI hiring systems. I mention this because it's really worth watching to see where the audit standards fall. Currently, we have no idea what exactly those audits will look like. I wrote a paper that talks about what it could look like, but New York City has some choices to make in terms of what exactly those audits do. But if you wanted to see a legal implementation that requires bias audits in a specific system, New York City has to do that very soon. I believe the law actually comes into effect in January. Okay. I'm going to just do one more. AI and workplace task allocation. A growing number of applications either demand a certain pace of work, or monitor the number of tasks or speed of tasks within a certain time period. So an example is an Amazon warehouse. You have a certain number of tasks per hour, and you are being algorithmically monitored to keep up with that pace. A lot of gig economy jobs, including delivery, right? Not only Lyft and Uber, but also things like Instacart or Grubhub, all monitor delivery speed. And these create health risks, right? They create a demanding pace of work that can either be dangerous in the case of a driver or biker delivering groceries, but also repetitive stress injuries. Both of these things could also, there are current protections for this. Here's another example where we could see adaptation, but really haven't yet. Under current law, you can't automatically dock someone's pay for not sort of being up to speed. That's technically currently in law. It's not clear if that's being enforced, but there is sort of a prevention of, okay, you didn't make this number of tasks, you automatically don't get your hourly wage, right? There is that was funded by the Department of Labor, an equitable AI toolkit. This is also non-binding guidance. We're seeing a lot of non-binding guidance coming out of agencies on how systems like this can be adapted for people with disabilities. Specifically, it's not broader than that, though that is important in these spaces. And the other two, I think, things to watch for in this space. One, there is a big debate, an ongoing rulemaking process from the Department of Labor on reclassification of the worker-contractor distinction under the Fair Labor Standards Act. This is broader than just workplace task allocation. Probably affects as many as 20 or so million contractors in the United States. And it's the Biden administration is seeking to move this distinction closer to err on the side of workers. Essentially, you're more likely to be classified as a worker than a contractor in that you get significantly more protections under US law in the favor under the Fair Labor Standards Act and others. And that, while it is not really specific to this, will affect a lot of gig workers and workers who are under these algorithmic task allocation systems, and probably significantly increase their protections. And then you can imagine, stemming from that, I expect the Department of Labor to create some standards around how these can be used. But again, dependent on the agency to do that, and when it's a priority for them. We could also see standards for task allocation under OSHA, the Occupational Safety and Health Administration, which is under DOL. And I think, given the growing rate of coverage around health impacts here, I think we might see that. So I'm happy to talk about these more in detail, but this is, my broad point here is when you have this significant proliferation of algorithms across the span of education labor, and I didn't even talk about all these, you end up needing relatively specific interventions from agencies, some of which can be adapted from current regulation, some of which can't and probably requires other legal interventions. And this, while you can get tailored interventions on all of these from agencies and maybe adaptations in law, it's going to take a long time. So you could argue it's good that the US has started that EEOC guidance on AI hiring for people with discriminations is in effect now. And that is more than I can say about the EU AI Act, right? Which is maybe a year or two away from really being, probably a full year at least away from being in effect. So maybe that means in some ways the US has already gotten started, and that's a good thing. On the other hand, you have these huge gaps that really need coverage across the spectrum of education labor algorithms. And it's going to be sort of an ongoing battle between activists and nonprofits to get the agencies to pay attention to these problems, which sort of leaves you with my takeaway that there is sort of an inconsistent amount of progress on these issues. I have written about this a ton. You can find all sorts of reports on these topics in AI and social policy at berkeley.edu/experts/Alex-Engler. And also you can feel free to reach out to me, and I'm happy to talk about any of these issues more with you individually. Thanks for having me. Happy to take questions at this point. And again, I'll mention that I am also working pretty deeply on the EU AI Act. So if there are questions about that, and how it affects this space, I'd be happy to try to incorporate that into my answers. Thanks again.
Thank you very much, Alex. Very great presentation. And I can already see next to me, Phoebe is keen on asking you some questions on the EU AI Act, because that's essentially her take. But I wanted to open up to the room here, and maybe also to our chat, to see if there are any questions. Yeah, Daniel, you have a question, please.
Yeah, thank you very much for the presentation. My name is Daniel Saman. I work as an economist in the ILO research department. I was wondering if you could say a little bit more on the planned auditing of these recruiting systems, and to what extent they, in this auditing, you can determine if there's discrimination or not. I'm asking because I guess it's impossible to really go through the algorithms, so you cannot really verify the algorithms. So I would assume that you would audit the outcomes. But then, I mean, even for humans, it's very difficult to, if you have human decision makers, it's difficult to distinguish whether this employee has not been hired because of objective factors that don't make him or her qualified for this job, or whether there's some discrimination or discriminatory bias in it. So I think it's a very important topic, and I've been I work on this, but it's difficult, I guess. And I was wondering if you could say a few more words on where we stand there, how this could work. Thanks.
Yeah. So I've thought about this a ton. So I have no idea what New York City is going to do. They just haven't released specifics around what we can expect audits to actually look like. What I can tell you is what I think it should do. There are 3 broad buckets that a meaningful AI audit should do for discrimination in hiring. Some of this applies more broadly, but really specific to this space. You have process considerations, data and dependency considerations, and then model considerations. The process considerations include, are the auditors independent? That is it not the company itself and not an institution beholden to the company? Does that auditor have access to, as you mentioned, not only the data, but the model, and probably the code doesn't hurt either. Ideally, it would be all 3 of those things: data, direct access to the model object, which is the actual digital representation that's doing the statistics, right? Which absolutely I think is necessary, and the code, which is helpful, though sort of secondary to the data and the model. You also have to think about things like, is it a representative analysis? If you think about AI hiring, a single company or vendor that has an AI hiring system might produce hundreds or thousands of these models. So the idea of doing an audit, you're probably not going to look at every single one of their models. Their models could be specific to type of job at a specific instance for a specific employer, right? So there's one model per geographic location of a Walmart for a salesperson. That's a lot of models. It's a hypothetical example, but I think that matches broadly what's happening in the field. So how do you audit all of those? You probably have to do a representative sample. So what is a representative sample of a list of models? Still kind of an open question. On the modeling dependencies, you should be thinking and evaluating the data collection process, the training, the representativeness of the training data, as well as a dependency analysis. A lot of AI models now are not built just at the point of sale or the point of use. They're built maybe a combination of one model that was bought or leased and another that was made in an open source context. So are there potential issues coming from those upstream models? And then the last is the model review itself, as you mentioned, and that includes looking at candidate rankings, its performance on historical data, its performance on various subgroups, right? Obviously, it's sort of the core thing we're looking for is performance on subgroups, especially those protected characteristics. And I think you could also imagine looking at hypothetical data that is beyond the data that's actually going through it, generating synthetic data and seeing how it does in other circumstances. You could go on for a while on what an audit should be. I think those are some of the core requirements. It'll be interesting to see what New York City does. And I think the good news is that to get to specific standards that are meaningful, you kind of have to start doing the audits, right? It's going to be hard to do this totally in sort of a theoretical imaginary framework. Someone's got to go in there and start doing this, and then we can read the papers and analyses that come out and start comparing best practices and pushing towards standards. So I think actually in some ways, it's hard to know what an audit is before you start doing them. And once we have them, we'll be able to iterate on the process. And so I think that's the true value of the New York City bill.
Peter, you had a question as well.
Yes, Alex. This is a kind of broader question. It's something you mentioned. Can you hear me?
Yeah.
Excellent. So you mentioned the fact that there is going to be, in many ways, a decentralized approach that's still federal, but it's going to be around different agencies targeting specific issues. Now, it's been a while since I've worked in DC around things. So now you're going to see how old I am, but it's been since 2003. But one thing that I was struck with is that there's kind of interestingly formal and informal competitive processes there, where informally people at different agencies often move between each other and they talk about what they're doing, and there's a sense of competition in terms of being innovative.
Yeah.
Formally, particularly democratic administrations such as the Obama administration very much put in a place where they wanted them to compete in many ways to show, who was the agency that was the most active around certain things.
Absolutely.
And I'm wondering if there's a certain aspect of that around this. Now, I know around certain things, you've talked about tax. That has been something they have tried to do since the 80s, really. And it hasn't really been effective. But I'm wondering if you think in something like AI, you kind of see that they're trying to create this culture of innovative competition.
Yeah, absolutely. And I think if, a polite and nice way to view the AI Bill of Rights is that it's intended to drive that sort of competition, or sometimes we use the phrase like policy entrepreneurship, which is the idea that if you set a centralized high-level set of principles and the Biden administration says, this is very important to us, then, hey, if you're working at an agency and you want to do work that's going to get noticed, maybe you'll be the one who develops the AI standards for whatever, right? I do think there is some of that. I do think that level of, individual motivation will probably lead to better standards. To total level with you, I think the US process will lead to better standards when they actually exist than the EU AI Act approach, which is going to be very broad. And, sometimes people will just have to set standards because they're required to by law, even if they're not motivated in the problem. And you might see less effective regulations come from that. The difference, again, is coverage. The EU AI Act will cover the things that are it's legally mandated to cover, whereas you may continue to see these gaps. So I think that's actually probably right. I think certainly now there is still enough kind of hype and pressure around AI that you're seeing individuals who can get some credit and some news coverage for doing a good job on regulating in the space, and that's probably a good thing. At the same time, sometimes all these news cycles get overshadowed by whatever Elon Musk said about Twitter, right? So it's not necessarily the only thing you want to rely on. And I worry about missing some of these key applications without a little more centralized guidance. But hopefully that's what we see. Yeah.
Can I ask one more quick question?
Yeah, please.
My question about this, Alex, is something that we haven't really touched on, but I think is really important in the US context. And Eckert asked a question earlier that I thought was touching on this, is that how has the US gotten buy-in? Because I know some from a lot of the tech companies, because I know some of the issues that was previous is that a lot of the AI is around essentially military application. And there has been a lot of barricading in terms of saying, well, we don't have to necessarily create these standards around classified projects. And then there's been other things about saying, well, if you're working with a company like Google and they're doing this, well, they do. So I'm just genuinely interested because I know you're kind of immersed in the context that when you're in a context like the US where the military is such a big industry and such a big, lobby in terms of this, and there's certainly one that has strong connections to the Biden administration in many ways. How has this played out when there are legitimate or illegitimate or whatever concerns about, classified material and these types of issues?
Couple quick thoughts. The most relevant thing to my expertise which is sort of in the AI Bill of Rights, is that we saw almost no action on law enforcement. This is a little outside the scope of what I came to talk about today, but another big gap here is that the AI Bill of Rights got no buy-in, as far as I can tell, from law enforcement agencies. There are like 13 big law enforcement agencies. There are like many thousands of federal law enforcement officers. I think there might be 100,000 federal law enforcement officers. And the AI Bill of Rights basically referenced no action by any of them to do anything on AI standards. And there was no one at the launch event who was saying, hey, we're here from law enforcement, we're happy to raise the bar on AI standards. So while in education and labor, you can probably imagine activists pushing agencies, stakeholders pushing agencies being invested in the problem and then adapting, and law enforcement, that dynamic might not work. And thus it may not lead to any oversight or standards at all, which so far seems to be the case. I mentioned law enforcement and sidestep a little bit your question on security for two reasons. One, AI Bill of Rights wasn't really aimed at that. It wasn't really supposed to do anything on there, so I'm not surprised to see it be absent. And And secondly, this is just a little too far outside my area of expertise. I will say that there was just a big overhaul in the Department of Defense on AI. They got rid of something called the JAIC, the Joint AI Center, and they replaced it with something called the CDAO, which is now the sort of DoD's approach to data and AI dissemination. That's relatively new, still working out some core things. Yeah, still trying to get tech companies to work with them. You know, I think in the long run, the fact that there's a huge amount of money will mean that they'll figure it out, right? I mean, Google doesn't do it, someone else ends up taking those contracts, and those companies in some ways are under even less public scrutiny. So I'm not even sure that worked out the way anyone intended it to. Sorry, I can't say more. It's really a bit outside of my realm of expertise.
Thank you. We have one last question from Blair, and then we need to wrap up the session.
Hey, Alex, thanks so much. That was a great talk. You mentioned it's not clear we'll be able to see enforcement of the AI Bill of Rights, and you talked a little bit in response to Peter's question about some of the obstacles around applying it to law enforcement agencies. But I'm hoping you could maybe talk a little bit more about, more generally, like what kinds of obstacles you see to enforcement, but also kind of like procedural or political obstacles you foresee in kind of translating this kind of executive-led approach into actual practice within government agencies, as well as into like legislation, laws, regulations.
Yeah. Maybe the thing I was disappointed about most about the AI Bill of Rights was that it didn't take this problem sufficiently seriously. And I'm hoping there's some more ongoing work, but we didn't see a lot here. The idea being, even if agencies are really invested in a problem and they're convinced that they need to do something about hiring in rent or AI in for rent price setting, or AI in education, or AI in labor, as we talked about, they might run into very real barriers to doing that. One example, do they have the talent necessary? Do they literally have data scientists or regulatory specialized data scientists who can go do this work and go do audits? That's not currently clear. On that front, there's some good news. The US has a pilot for hiring data scientists. They have a new hiring process that's being tested on hiring data scientists called the Subject Matter Expertise Quality Assessment, or SMEQA, S-M-E-Q-A. And that's actually basically there to make it easier to hire data scientists and technologists. And I'm hoping it's a good process. I'm hoping it spreads. So, okay, there's an example. We have a systemic problem. Do agencies have the capacity to do AI oversight? And some progress. An example where you're not seeing progress, a lot of the times to do meaningful data sort of algorithmic oversight, you need something called like administrative subpoena authority, the ability to go to a company and say, hey, you need to give us your model and data so we can evaluate whether or not you're meeting legal requirements. Some agencies have that. The Federal Trade Commission can do that. Others absolutely don't, right? You can go and say, hey, give us your data, and the company can say no, and it really prevents you from enforcing, to some extent, the law if you don't have any way to easily get that data. And maybe you can go through a lawsuit in some circumstances, but that's sort of the long way around and can be really challenging. So I would say that's an example where a lot of agencies don't. And I'll mention one other, which is a mismatch problem. And the EEOC is a great example of this. The EEOC cannot actually target vendors of algorithmic hiring systems. They can only enforce their laws on employers. So you could have a vendor that you are very sure is selling a structurally and sort of by definition, very, very discriminatory system that's obvious on its face is discriminatory. And it's very, very difficult for the EEOC to do anything directly about the vendor. They have to only go through employers. And that here is a bit of a mismatch. And I'm wondering if we'll see that problem happen more. You can imagine lots of circumstances where a central provider of algorithms is really the problem, but you're only able to go after their clients, right, who are using that algorithm. And because often there are a small number of vendors driving a much larger space, I wonder if that also be a systemic problem, and I haven't seen a good solution to that either. So that's when I think about sort of the process considerations. That's what I think about. I wished that the AI Bill of Rights had thought a little bit more about creating guidance and processes for helping agencies that run into that. Maybe that'll come next, but I haven't seen it.
Excellent. Thank you very much, Alex, for this. This was really great. Great to have you with us. And, please stay if you have time, because we already have our next speaker lined up for giving us an overview of the Indian case. So great welcome here, Apar Gupta from the international, let me see, from the Internet Freedom Foundation. So Apar, great to have you with us this afternoon. Hope it's not too late for you. We are very much looking forward to your intervention. As for the previous speakers, you have 45 minutes in total. So if you can leave us, let's say 50 minutes for Q&A, that would be great. So thank you very much, and over to you.
Thank you so much for having me here. I hope I'm audible. I'll continue. So there are 4 basic parts to my presentation here. And when we talk about artificial intelligence, especially in contexts which emerge from the global south, particularly in India, experience quite often comes from communities who have been engaged in labor practices who are not part of the digitization process. This is due to the nature of our societies having very deep disparities in which there may be a concentration and availability and accessibility of digital tools to a certain segment of population, which is upwardly mobile, based in the metropolitan cities, English speaking, and also having economic facility. But the large working class population, the blue collar workers, are usually without smartphones or access to technology by itself. Here, first, I would like to talk about teleconnectivity and smartphone access, because that itself predetermines the participation of the labor force to the benefits of artificial intelligence, where there have been certain policies which have been adopted by the Indian government towards expanding it. In fact, even yesterday, the Freedom House report, where marked several parameters globally for internet freedom, noted that India has made progress on 2 points only with respect to internet access. However, at the same point of time, it remains in terms of an overall rating of economic, political, as well as online freedoms being only partially free. And this is a much more complex understanding, which exposes how the benefits of artificial intelligence, both as participants and creators, especially for laborers, especially for people who are engaged in what is called as the expanding gig economy, may only be minimal at best. So firstly, I'd like to make some reference to statistics. The Indian Telecom Services Performance Indicators report is a report which is issued by the Telecom Regulatory Authority of India. It is issued every month, and it notes the number of internet connections which are primarily used by people both in urban and rural, which are the 2 divisions they adopt in this report, through smartphones or mobile devices. And this figure has, while grown in recent years, over a period of, let's say, 6 to 7 years, from 60 million to now almost 800 million. It has stagnated at that range, and it has also shown contraction over certain periods of time. I can provide further information and analysis on this as is conducted by us at the Internet Freedom Foundation subsequent to these comments. So these large figures by themselves do indicate that teleconnectivity and access to internet is not covering the entire population in India, but there are further subdivisions within it. So this is captured in a separate survey, which is called the National Family Health Survey, which recorded that the percentage of men and women who had ever used the internet, from a sample survey size of about 3 lakh households across 17 Indian states and 5 union territories. The survey revealed that while internet penetration in the country is rising, a persistent digital divide still remains due to factors such as gender gaps and the rural-urban divide. As of 2019, there are about 5,97,600 inhabited villages. And out of that, about 569,897 are covered by mobile services. So the first level of disability in access is the absence of a telecom network by itself. And this is something important, because even if you have a smartphone, even you have the ability to pay in these areas, you cannot connect to the internet because it does not have the underlying network infrastructure. And this is a story I think will be shared with many countries across the global south. This will not only be in India, which has shown tremendous economic progress. And furthermore, if you look at coverage and the usage within these statistics of about 800 million, about 96% are using it through mobile phones. This is also in this survey itself. Now, if you look at it, the internet connections are also ranging very, very differently in terms of population sizes, in terms of the number of people who have it, and averages within Indian states, where there's a higher tele density in terms of users in urban centers. So while the data does show that on the whole access to digital infrastructure is increasing, there's a significant digital disparity which still remains. So even if these remaining villages are connected to the internet, the uptake on the availability of the network infrastructure does not automatically mean that a person who inhabits this village will be immediately be able to purchase a smartphone and connect to the internet. And here, this is why these imbalances are very, very visible. For instance, I come from the capital city of Delhi, where the tele-density rate is about 247 for about 100 people, which means that for every one person, there are almost more than 2 connections, internet connections. One may be a landline, which has a wired broadband, and the other is a mobile connection. I would like to now quickly skip towards the gender disparities which also exist. In terms of gender disparities, if you notice that the report indicates that in 8 states and 2 union territories, Bihar 20.6%, Andhra Pradesh 21%, Tripura 22%, West Bengal 25.5%, etc., etc., are the numbers of women who have ever accessed the internet. So on a whole, less than 40% women have accessed the internet as compared to men. And comparatively, in the same states, more than 40% men have easily accessed the internet, where in fact the population of men and women is almost equal, where men may be about 53 men for about 47 women, but even then the men are accessing the internet more than women. This manifests itself in the context of AI as a gender-based disparity, because as much more sophisticated AI-based models are built on the basis of user behavior and collecting raw data on the basis of user behavior and putting machine learning through building different kind of algorithms. It will then reflect the gender biases of behavioral attitudes of men rather than women. And this will come more from rural settings rather than from urban settings. And one clear manifestation of AI and how it impacts workers and people who are in the labor force has been our experience specifically on digital contact tracing. Digital contact tracing was introduced on 2nd of April 2020 by the union government through a contact tracing application called Arogya Setu. Arogya Setu in Hindi means a path to health. And initially it was just a contact tracing application, but it also then became a digital e-pass feature, which has been seen in other countries abroad as well. And it was criticized quite often on basis of its data protection frameworks. But what I want to focus on more specifically is that Arogya Setu, which required a smartphone for its operation, after periods of lockdown, was also made mandatory. Firstly, in certain government offices, for the ability of an employee to join back at service. For instance, employees of the State Broadcasting Corporation, Prasar Bharati, and even the Central Armed Police Forces mandated it for their employees, thereby pushing a cost which could not be accounted from their daily wages. And this becomes also important for us to consider that AI-based technologies, if they are made mandatory on the basis that the AI-based technology offers a higher degree of efficiency in social function or public planning, it may result to the intended beneficiary as an additional cost if the beneficiary does not have the economic ability to purchase a device and participate in the benefits of the AI by itself. Of course, it is questionable if digital contact tracing worked in it in the first place itself. Now, in addition to government employees, certain private companies in the gig economy also made Arogya Setu mandatory for their workers. As lockdown restrictions were eased and business operations resumed, other employees in the gig economy, as well as traditional economy, made use of the app compulsory for workers. In fact, I would like to specifically indicate that under the National Disaster Management Act, a standing order was made that even for industrial manufacture, which are the factories that may be engaged in manual labor, the employer could be prosecuted under law for certain crimes if their employees did not have Arogya Setu on a smartphone. Thereby, it would exclude a large amount of the workforce, which essentially is contract labor, which works on a day-to-day basis, which is not employed on a monthly basis, may not have other labor protections, may have it notionally under law, but may not have it operationally as a practice by itself due to weak rule of law systems or labor authorities themselves not being that strong. Now, also, I think what is important to understand is that if you look at research, the benefit of AI quite often comes through when a person is a participant. And here some research has been done by Tandem Research and Center for Internet and Society, which demonstrated, especially during the pandemic, that financial relief, protective equipment, and healthcare coverage to gig workers, which are engaged in, for instance, instant deliveries or are also servicing transportation through ride-hailing applications needed to be met rather than just investments in AI, because quite often businesses prioritize investments in AI over investments towards the safety of the employee itself. So I think these are important realizations as much as we look towards the broader regulatory goals, and we are dazzled by the promise of a future AI-based framework to go back to the basics, where access to the internet, availability of smartphones, the persisting digital divide, all puts to question the promise of AI as of today, as much as it may be presenting a very valuable form of technology advancement for the future with social benefits, which is not in doubt. One more thing I'd like to now step towards, which is the third point, is the growth of the gig economy in India and how AI is at being present used. Quite often, already companies in India, especially technology companies, have employed large numbers of their workforce through what are called as partner agreements. So they are not considered as regular employees and thereby evade regular benefits which come and labor protections which come with standard employment, whereby minimum wages are mandated. And it is argued that because the service provider, the person who's engaged in the manual labor is actually a partner, is not an employee, they are earning not on the basis of a fixed salary, but on the basis of certain incentives, which are then determined on their efficiency and other parameters, which are set and are gathered transparently. However, the parameters quite often are defined unilaterally by the companies through these partner agreements, which are then drafted very vaguely. And then the applications which are there and on smartphones, which are provided by these companies, gather the data with respect to if it's a function relating to ride hailing or taxi services, how soon a person responds, at what time do they respond to certain requests, what is their conduct, what is the rating the people who are hailing this taxi service provide, etc., etc. A lot of these parameters, which are presenting unique data points, are not transparently disclosed to what are termed as the employees/partners and feed into the employee profile and determine their entitlements in terms of additional bonuses, which are very important for them. So there is a lack of transparency is what I would like to indicate in the data collection practices. And platforms quite often also employ indirect methods such as gamification or worker ratings by displaying a weekly scoreboard of top performers as a way to increase intra-working competitiveness and encourage them to stay online for longer periods. This has a deleterious effect on their long-term health and sustainability, where workers are supposed to be available at all points of time, irrespective of their working hours, and take requests from customers. Thereby, essentially, it's a race to the bottom, where machine-based efficiency is essentially being seen as a value towards being posed towards greater labor efficiency. And our entire understanding and development of labor practices over a period of time have been the 9 to 5. It's a recognition that human beings are not machines by itself. A report on working conditions in internet ventures by the Fair Work Project, which is based out of the University of Oxford, has ranked Zomato, Swiggy, Uber the lowest, scoring 1 out of 10 points on a 10-point scale based on pay, conditions, contracts, management, and representation. So I would like, this is a question I put to myself quite often. What does it mean to be a gig worker in India when your large amounts of personal data are put into a system and you lack the power of any oversight with respect to how that data is used, how those systems behave, and how your monthly salary is actually determined, which is not even termed as a salary. Further, there have been instances of harassment of workers, lack of preventing them from unionizing by itself. And if you look to build the models, the AI models, more and more data collection is encouraged. And here I'd like to refer to the terms of service of some platforms. Zomato riders, which provide food delivery services, places within their terms that you can't log off from the apps, and you have to have said that logging off the app leads to phone calls and messages from the team warning them to log back in or losing their payment incentives. So if you switch off the app, if you are tending to family, friends, you can take a break in terms of a conventional employment. You can't do that for Zomato. It's gathering your data at all points in time. And secondly, Dunzo's, which is an instant delivery application in which you can place an order, and within 10 to 15 minutes, you can get your groceries through a hyper local delivery model, or vegetables, or any kind of household materials. Says in its delivery partner agreement that besides monitoring and sharing a worker's geolocation data, which is GPS data, during the provision of services, it will also, and I quote, monitor, track, and share your geolocation information obtained by the platform and delivery partner device for safety, security, technical, marketing, and commercial purposes. So a large expropriation of personal data at present is being done through express statements and technical models of gig workers in India. This puts to a question, very naturally, which may emerge, is that does India have a data protection law? And here, India does not have a data protection law. It does not have a data protection framework. It does not have a data protection authority. Hence, there is an absence of a statutory, there's a statutory duty on an employer, a statutory right to an employee, and a regulatory agency to enforce it. Thereby, within this existing vacuum, the power imbalances within a worker and an employer are further increased. Now, even if a data protection law comes to pass in India, there is anxiety and concern, especially in the labor movement, that it will not tend to the needs of the employees, because the draft version of a personal data protection bill has in the past stated within clause 13 that that processing of personal data by employers is permitted without the consent of the employees for certain purposes such as verifying attendance or for assessing employee performance. For such purposes, the consent of the employee is not necessary for the processing of their data in case doing so, quote, would involve a disproportionate effort, end of quote, on part of the employer. So in my own opinion, such an overbroad carve-out being granted statutorily in a legislative proposal, which is no longer there, it's been withdrawn, but this was a proposal being granted to employers is a clear threat to the dignity of labor as well as to individual privacy. And this will manifest quite obviously in the context of any AI-based framework. It would furthermore, the exemption on processing sensitive personal data, which is also there, includes financial data, health data, official identifiers such as a national ID, sex life, sexual orientation, biometric data, genetic data, transgender status, caste or tribe, which is very important in India, and religious or political beliefs or affiliations. This may lead to several changes in existing practices in terms of behavioral modification, it will essentially mean that an employee by itself will be under the perpetual surveillance of our employer. And I think this is a relevant thing to understand and consider more broadly from South Asia. It is not as if things have only been negative and concerning in India. It is not as if the government of India has not made an effort towards providing and utilizing technology towards the benefit of employees and the large labor force. So there is a national database which has been created for unorganized workers. It is called the E-SHRAM E-Shram portal. So on 26th August 2021, the Labour Minister, Mr. Bhupendra Yadav, launched the E-Shram portal. The portal helps unorganized workers to register under the National Database of Unorganized Workers. Who may be these workers? They include construction workers, migrant workers, street vendors, domestic workers, people who are engaged in delivery services, agricultural workers, etc., etc. Each worker registered on the portal is provided with a unique 12-digit universal account number. And the government says that about 38 crore workers are expected to be registered on the portal. The initial benefits of registration include insurance coverage of about 1 lakh, and in case of any disability, about 2 lakhs. And the benefits include also that the database can provide some amount of social security which gig workers lack. Now, this poses a very foundational question to me, that whether under existing frameworks of labor law, the government is recognizing that gig workers are not part of labor protections per se, and thereby, rather than extending labor protections to the gig economy, it is providing additional entitlements as a social security net, thereby shifting the burden from employers to itself. And I don't have a clear answer on this, but it is something which is relevant for us to consider. The E-Shram portal, I would like to indicate, has been welcomed by workers' organizations and trade unions, saying this is a welcome step, especially in light of the exodus of migrant workers which took place when there was a lockdown announced in most Indian cities. As a background, when the lockdown was announced in India, there was a huge migration of unorganized construction and daily wage laborers from Indian cities such as Delhi, Mumbai, Bengaluru, back to their villages, given that the initial impression which was carried was that COVID is an urban disease. Thereby, to escape the disease as well as the loss of employment, they went back to their villages by itself. So, in a sense, the pandemic has been incredibly tough for laborers and the unorganized workforce. Even recent statistics which are coming through in terms of the overview. There is a rise in indebtedness. There's a contraction of rural consumption in FMCG goods, which is consumables such as soap, such as sugar. So it points to a larger question mark that as we look towards advanced technologies such as AI, the much more foundational question which I put to myself quite often is not a loss of employment, which is quite often posed in the context of AI, right? What will happen to our factories when everything is automated? For us in India, maybe the loss of employment much more immediately in the present as well as the short term may be due to a contraction of economic opportunity by itself. It may not be due to the ability of private firms or large corporations implementing AI practices on the industrial floor, within the factories by itself, given that the labor wages in India are quite depressed already. So with these initial comments, I hope I have provided a much more rooted perspective from India. I can understand it may be a little different from other participants. It may not be based in principles of AI accountability or transparency, but I hope it has served some value. I look forward to any questions or comments.
Thank you very much, Apar. Indeed, that's extremely important perspective on India. So I'm looking in the room whether we have any questions here. Uma, please.
I just have a question to you about the contract tracing that you talked about, especially the Arogya Setu, and it being made mandatory in state broadcasting services, that is the Prasar Bharati. What is it that was made mandatory? The fact of using the contract tracing soon after the COVID? And could you actually give us a bit more details around that?
Thank you. That's a very specific question. I'll just look it up from my notes and provide you answer. So Arogya Setu by itself was promised to be voluntary by itself. So the mandatory requirement by itself would have been for the employees who were required to come back to office and install it on their smartphones. So I think in 2020, it was made mandatory for staffers to install it in their smartphones, and it would then show their positivity or negativity status by itself. And that's been covered in the press as well. It's public.
I am aware that it has been covered in the press, but I wasn't sure how you were linking it to the AI. Thank you.
In the chat, but maybe I take the advantage that I'm here chairing this panel, and I wanted to ask you something about the possible regulatory dynamics in India, because from what I understand, this is mostly determined by industry interest. I mean, essentially the non-regulation is mostly determined by industry interest. The question is, obviously, these companies compete themselves or for their platform workers, and the question with them becomes as to what extent there might actually be some regulatory dynamics and some lobbying, if you want, inside among these companies to undercut their competitors. Why, for instance, linking or forcing platform workers to stay within their platform and not being able to move around. So I don't know if you can say a bit more about the political economy dynamics around these different regulatory dynamics that might or might not unfold in India. Thank you.
My experience comes from this. Anecdotally, we organized a session with gig workers after masking their identity. This was an online webinar we had conducted, where they had said that it's not only that companies prevent gig workers from working from one company in another company, which would be a much more regular expectation, right? It was not their statement that this happened. Their statement, in fact, was that because they were unionizing and protesting, and I think these were gig workers who are women who are working to provide beauty services at home for women in urban centers such as Delhi and Gurgaon. They were saying that because they were trying to unionize, because they were not happy with the working conditions and the payments, they were blacklisted by that company. So they were deplatformed from that company. But also informally, they were saying that they were threatened that their information would be shared with other companies as well. So they were under fear. I don't have any confirmation about any of this. Secondly, I think there is some focus here also on AI and the overall regulatory dynamics. So let me just comment on that. I don't think so. There is a clear regulator on AI in India, but there are some policy documents. There's a set of policy documents, firstly, which have been made by the Central Planning Agency, which assists and provides advice to the federal government, the union government in India, which is called Niti Aayog. And it has come out with a paper which is called AI for All. And to my knowledge, it is then making specific papers for different categories of activities such as agriculture or etc. etc. So it's called the AI for All. And the second set of papers which have been published, policies which have been published, are by the Ministry of Electronics and Information Technology. That is a ministry which is having the jurisdiction and mandate of looking at digital technologies by itself. So there's an absence of regulation by itself. And I think India is looking towards AI more in terms of the promise that it offers, and the principal vehicle for the policy development quite often is happening is that both in the public sector as well as in the private sector, it can result in significant advances for the public sector in terms of the historic inability of the Indian government to cater towards the large number of people who have not been touched by social security in its various different forms, to improve that. And in terms of private industry, achieving certain economic goals by the creation of more unicorns, by touching a component of about $1 trillion in a total economic target of about $5 trillion, so about 20% of the Indian economy. So those are very large motivations which animate the policy discussions by itself.
Thank you. Yeah, we have a question over there. Please.
Hi, Apar. I'm sure you're aware of this Karnataka government going against Uber and allowing the auto wallahs to do away with the Uber regulation. But at this, how do you see the difference between the central government policies and the take by the state government? Because they have taken a more stronger stand instead of the central government. How do you see, this? And I assume that you have a legal background. How do you see that this approach is effective, or what's your opinion about that whole fiasco?
So as a person who believes in the division between the federal and the central government and the state government, based on a much more federal framework, the powers with respect to transport are clearly vested, motor vehicles is clearly vested with state governments. Of course, we have a central enactment, which is based on consultation, which was updated recently, the Motor Vehicles Act, but it required state concurrence. I believe that local solutions by itself may be inefficient and may present difficulty to platforms in terms of rolling out uniform policies nationally. But then again, I think there is legitimate ground for state governments to know the actual reality in terms of local planning, employment demands. At the same point in time, I think both there are certain elements of public interest which represent large stakeholder groups beyond the companies and the government as well. Yeah, firstly and primarily, it should be on the basis of surveying the local service providers, which are not only going to be the much more organized taxi unions, which are not on these ride-hailing applications, but also other market participants who have been providing for a large number of years cab ride services through being Uber riders or being Ola riders by itself. So a ban may be may impact their daily livelihood in a way, the investments they have made in terms of purchasing cars. Also, to a much more minor degree, this other stakeholder which needs to be considered is the ride-hailing public by itself. As much as the state should focus more resources towards public transport, our experience in India has been, especially in cities, even for people genuinely from the middle class, that the public transport systems are not able to cater to demands for mobility. So I think a ban by itself may be a harsh measure. It requires also regular revisiting. Any policy measure should not be permanent of any such nature. I think state governments are fully entitled to exercise powers to regulate cab-hailing platforms, especially because they offload a lot of the duties which come by operating a business in a certain model where they have not traditionally invested resources towards, for instance, creation of parking lots, right? They've offloaded all of the cost onto public infrastructure, where the car is eventually then parked on the road rather than it's parked in a parking lot, right? It's based on a weak rule of law system. It's based on offloading a lot of the cost onto public infrastructure and recouping the profit purely towards the platform by itself. So I think there is a need for greater coordination, which maybe can be done by the central government, but state policies will show some degree of deviation.
Thank you. We have some few minutes left. You want to hear on the... I don't see any question in the chat. I mean, I would actually have one more question for you, a bit more specifically on data policies, not so much on AI regulation. I mean, you're obviously aware of this whole discussion about data colonialism and the fact that a lot of big multinational companies enter countries like India also to harvest data, if you want, and use them for their own purposes. Is there any discussion in India to what extent this will be restricted or limited, or are there already attempts to limit that? Can you give us a bit more on this particular point? Thank you.
The sentiment of nationalism as a social value by itself is very much present in India and has shown an increase in terms of its political articulation. In terms of technology, this is sometimes called digital sovereignty, where India should have its own platforms, either based through what are called as public digital goods or through private enterprise through what is called as India Tech or is centered in India. However, at certain points, even private enterprise in India may have investments through structures which may make it have a founder who may be Indian, but the company itself may be registered in, may be registered offshore and may have investments from global private equity firms. So to a large extent, this is a political argument. Is it a legitimate argument by itself, and what risks does it pose? What benefits does it pose? Has been the topic of active study and debate. It visits itself in regulation, given the absence of a data protection law. Firstly, in the proposal of the Personal Data Protection Bill, where there was a specific need within the law for what is called as data localization, which is that data of Indian users should reside in India. This is in contrast to the data equivalency standard, where under the GDPR, the data of a European can be exported outside Europe if it has an adequate data protection law and there's an equivalency of protection which is also offered by that law of that foreign country to the data which is exported. The divergence here is that India, under this proposal, was examining and was seriously considered, and I think it still has favor, is to localize the data within India itself. Secondly, beyond this proposal, in terms of payments data specifically, the Reserve Bank of India indeed has issued some directions that data with respect to financial data with respect to payment transactions has to remain in India. It has also led to actual enforcement action where MasterCard could not issue more, take on more customers. It has localized its servers in India, and also other entities which are engaged in the in what is called as the fintech economy. Now, in terms of legitimacy, sensitive personal data has been comparatively studied by Professor Graham Greenleaf, who has also stated that certain forms of data may in larger social or national interest, especially if it has security implications, which are clearly articulated in evidence, may actually be placed within a country. However, these objective standards and whether it actually results in benefit or just leads to a growth in costs may lead to a contraction of innovation in terms of availability of global services, because every firm may not be able to localize its data on an Indian server, may also result in barriers not only to trade, but also in barriers to the global internet as we understand it today, right? So it may lead to a higher degree of, I'm sorry to use this phrase because it is used within technology policy debates, but it may lead to a greater degree of balkanization of the free and open internet, which has a promise of free flow of information. So, but at the same point in time, there is a very legitimate argument to be made that global Silicon Valley companies, which possibly, especially social media companies, which have possibly the largest number of users in India, do not adopt the same human rights standards or content moderation practices as they adopt it in foreign jurisdictions, where they view India more as a market and less as a country.
Thank you very much. Thanks, Apar, for this these great insights. So given that we reached the end of the time, Uma had one last question, but really quick because we already...
I don't have a question, rather I want to reply to your question about what's happening in India. There's quite a bit of debate around the regulation of AI. There is a status paper that has been drafted by the ministry, and there's quite a bit of discussion and debate within the country. Similarly, over the data, the discussion and debate is quite intense, and there's also a special expert commission that is looking into the question of data rights, the question about data flows versus data sovereignty, and there's also issues around who has the user right, whether one of the proposals that has been put up is also community user right over the data. So the debate is quite intense, and there's quite a lot of things there happening. Thank you.
Thank you, Uma, for this complimentary information. Great to have you with us, Apar, this afternoon, evening, and I hand it over now to Phoebe to share the remaining panel in this great workshop. Thanks a lot, and hope that you can stay with us for a few more minutes, Apar. Thank you.
Okay, fantastic. Thank you very much. So we have one more expert speaker, which is fantastic. And we will then have some more talks based on the world of work implications from our project team as we've restructured today's program. So make sure you stick around. And of course, we're going to engage, of course, with our audience, with our international audience, as well as those in the room. And we look forward to having a chance to do that in the next 2 hours. So 2 actually, and then 2 hours exactly. Okay. So I have with us now Dr. Aude Cefaliello. So she is working for the ETUI, which is the European Trade Union Institute of the Commission. She joined the ETUI in October 2020. Aude has a law degree from the University of Glasgow and the Université d'Auvergne in France, which I'm saying this incorrectly, I'm sure. So Aude finished first her master's in employment law at the University the Masters of Employment Law also at the university. This is my second chance to say it properly. d'Auvergne. Am I saying this right? d'Auvergne. Yeah, my French is so terrible. d'Auvergne. Thank you. In 2014. And on this occasion, Aude, you wrote your master's thesis on psychosocial risks by comparing the French, British, and European legal systems. So Aude is a specialist in areas that, of course, have already been touched upon today. So artificial intelligence and occupational safety and health. And Aude looks at also psychosocial risks. And there is a dearth of this research area, particularly when looking at digitalization and OSH. Aude is also an expert in working conditions, comparative labor law, and strategic litigation. We're very fortunate to have you with us today. And Aude, if you would like to share your screen and speak for your allotted period of time within 45 minutes, and then we will open the floor for questions. Thanks again for being with us.
Well, first of all, can you hear me well? Yes. Yes, I see some nodding, so I will take it as a yes. Thank you very much for inviting me. I think I'm the fortunate one to be here tonight or today to share my thoughts on AI and also to contribute to this really ambitious workshop. So without further ado, I will try to share my screen. I will also try to, of course, limit myself to half an hour because I think it would be very interesting to have time for debate. Wait. Does it start? Can you hear me? Everything froze a bit.
Yeah.
We can hear you, but we can't see your screen yet.
Yeah, I think everything froze a bit, but that's fine. I can start by presenting basically what I'm going to do while my computer is catching up, apparently at the end of the day also for, technical material. So I will try to provide an overview of basically what has been the approach around AI and the digital transition in general within the European Union. And then I will focus on the AI Act and look at the overlaps with some of the labor law legislation, because I think that will raise interesting questions and debates. What do you see? Because on my side, it's completely collapsing right now.
We just see that it says you've started screen sharing, but there's no, there you go. Yeah, good.
Great, loading. I'm very sorry for that. Yes, so it works now.
Yep, absolutely perfect, thanks.
Great. Sorry for this. I think it's because I'm going to, raise a lot of concerns about digitalization. So it was a bit of a karma, preventive karma coming up right now. So first of all, artificial intelligence game changer in the EU market, because I think it's really important to emphasize that the debate that we have now about the AI Act, about the machinery regulation, about the Data Act and all of this, this debate and this discussion started years ago. And actually, if we look at the first basically communication element, we can see this appearing already in 2014, right? With guidelines on regulating robotic. Then it moved to really AI in 2018. And then basically the speed increased a bit with indeed in 2019, communication on building trust about human-centric AI. This is also when this term of like ethical guidelines started to emerge. Then we had a white paper on artificial intelligence being published in 2020. And for example, one of the many initiatives resulted in the proposed regulation on artificial intelligence that was published in April 2021. But all of that to say that, once again, it's over time there have been an evolution. And so it's also over time that we have had the opportunity to start talking about it and also talking about the foreseeable risks. So this is not completely a new issue, even though this is an undergoing legal initiative. Also, which is really important, I think, that we need to keep in the back of our mind is the fact that the choice of promoting AI is an, of course, economical one and is seen as a business opportunity. So the sources is actually like the European Union, the Commission one, and this is literally saying that this is for boosting the excellence in AI, and they share the amount, the budget that they are going to invest for promoting AI. And the Commission plans to invest 1 billion per year in AI. And in addition to all of that, there will be like a volume of like 20 billions over the course of the digital decades. So once again, a huge amount of money that is going to be allocated to the development of AI. What they aim with this is that it will be a game changer, that with that allowing Europe to amplify its ambition and become a global leader when it comes to AI. This is the aim. This is really the race about regulation of how do we put on the market as fast as possible AI and how are we the most innovative one. This is the aim. Then we'll see what will be the impact on the work, but this is the one at the moment. So in the context of this global, once again, ambition, there are many acts. This also we need to keep in back of our mind. There is the EU cybersecurity strategy, there is the Digital Service Act, the Digital Market Act. So there are many. Today I'm going to focus only on the AI Act, but this is one piece only in the puzzle of initiative and legislation. What also I find really interesting is also on this webpage, they say that they try to get to build trustworthy AI that will create a safe and innovation-friendly environment for users, developers, and deployers. I would be curious to see if it will be the same for the end users when this is implemented at the workplace. But this is what we are going to discuss in the coming minutes or half an hour. Because what we have seen, so this is basically, that was more the global ambition. What we have seen for a couple of years now, and here I have to thank also all the amazing work done by, well, academics, but also EU OSHA, that have been investigating the risk that the digital transition will lead or might lead to. So actually already in 2018, they published a foresight report on the new and emerging occupational health and safety risk associated with digitalization. And I know, I mean, this is not only about OSH, but this is still important, I think, in the world of work. They say, and they emphasize already 4 years ago, that technology that are diffusing much faster than in the past. And many people are talking about the fourth industrial revolution. This is a huge topic of research for labor lawyers, but not only, for everybody involved in the world of work. And this is for sure is going to change where we work, how we work, who we work, we will work with, and how people will perceive work. So this is not only a market opportunity, it will profoundly change the way we operate at the workplace. And that's really important because they are already identified and this is important, 4 years ago, so that elements were accessible already when we started to discuss about AI and legal initiatives, we already see that there will be challenges, of course, opportunities as well, but with the development of digitization, of ICT and ETs, but also as well, of course, that include algorithmic management. And how it's going to impact it is going to impact it on work equipment, for example, and the tool we used. So the way that workers might be exposed to physical risk, maybe sometime being safer, being less exposed when it comes to, for example, intelligent machines, but algorithm management might lead, and I will come back on that later, also to risk identification. We are going to also have to face new kind of risk that will come with the human-machine interaction, and also when it comes to cognitive demands. So there is all these kind of elements that we will have to deal with, and we have to already deal with in some sectors. The lack of transparency of algorithm. I mean, we have discussed that not only for OSH, but also for like how work is organized. This is an important topic. What EU OSHA also identified is that this usage within the context of digitization that will also interfere and change how work is organized and managed. Not only about the flexibility, because here it can be an opportunity, but also the question of being constantly available, also to be like constantly sometimes monitor, the question of being available, of blurred between work and private life, the fact to have more digitalized management methods, once again, algorithmic management, the fact that it will maybe create more performance pressure, constant oversight, privacy invasion. I mean, we have had discussion about that once again for a long time. And the third point that they identified was the fact that it will influence employment status, but also hierarchies and relationship within the work setting. So we will see more, or the risk of more work casualization, online work platform. This is the perfect example. Loan work as well, but maybe also possibility for more collaborative employment and new collective bargaining models. So they try to be neutral by putting opportunities and challenges. Of course, maybe it's the OSH part here. I sometimes always see the negative aspect, but just to say that, once again, that has been put on the table and that should have been taken into consideration a long time ago. Because what we see as well, and here is not only EU OSHA, it's a lot of the research community who have been warning us about and also proving what will be the impact of AI on work and occupational health and safety altogether. So we have had evidence that algorithmic management is not only for platform work, this is going to be used in more conventional employment setting. This is impacting all sectors, a lot of sectors, way more work that we can see or maybe imagine right now. We can see it in warehouses, factories, marketing firm, to, of course, to direct, to discipline, and to evaluate workers. And I mean, maybe during the Q&A, we can discuss about like the kind of software that are already accessible. Then there is other studies that has identified some occupational risk factors that are directly linked with algorithmic management. So that comes with the constant monitoring, work intensification, lack of autonomy, the fact that there will be biases and discrimination caused by the algorithm. And on that, I mean, I have to say that Phoebe as well have done an amazing work about that. And she has been one of the first one, but it's not on the table. And then other researchers agreed on that. So yeah, she also, of course, said that all this discrimination and all that lead to stress and also to musculoskeletal disorders. So not only how it will impact the way works perform and feel work, but also their direct impact on their bodies and on their health. And the thing is, you can say, yeah, but I mean, it varies, right? AI, it's not always the extreme picture that we have. Well, the thing is, yes, maybe the degree of control varies, but there is still a direct relation between the degree of algorithmic control and the rise and exacerbation of risk that we have been noticing. And also AI, then to give you example of what it might, how it can appear then in the way work is organized, it will lead to inter-work competition, rating mechanisms, and the problem by the work intensification, we impose a rapid pace on the workers. Because this is what AI does if we don't have workers in mind. It imposes for productivity purposes a fast pace, and then that push workers either to not having breaks at all, or just not having safe behaviors anymore and putting themselves and other into danger. And once again, that has been reported by existing research. So we know the risk of using AI, which is not adequately designed for work with workers in mind. The thing is, so I'm sorry if this one is a bit complicated. I talked about AI, but this is only one aspect of the coin in how AI is impacting work. So there is indeed how employer is using AI for management purposes. Then there is also the technical aspect that I'm not going to go into today, but still exists, is more working using AI or alongside AI with more AI within machineries, cobots, for example. And here, what is really interesting at the EU level is that we have multiple initiatives at the same time. So we have the proposal for a regulation on machinery production, which is part of the new legal framework. And on top of that, we have the AI Act, where there is something more targeted toward algorithmic management. And the thing is, this technical regulation, first of all, of course, they are connecting one with another, but they also overlap with existing labor law, and in particular, OSH law. So, for example, the framework directive 89/391 EEC, and to some extent, a third proposal about the directive on platform work. I'm very sorry, this is a lot of ongoing initiatives. So if it's hard to follow, this is not only for you, that is for everyone. So I hope that helps. So what I'm going to try to show you now, it's basically how this overlap between trying to put something, a product regulation on the market, might interfere with the environment is going to be deployed, which is the work setting. So I'm going to focus on the AI Act now, and only on algorithmic management, because in 30 minutes I couldn't cover everything. And I think this is, what can raise a lot of debate. So there is this proposal for AI that apparently is based on EU values and fundamental rights, that is supposed to give people the confidence to embrace AI-based solution, while of course encouraging business to develop them. It's supposed to be good for society. And of course, all the rule for AI should be human-centric, so that people once again can trust the technology, and it's safe and compliant with the law, including the respect of fundamental rights. Just to say, the AI Act is an horizontal one. It applies for the entire society. It applies to work, and this is one of the main weaknesses, only because there is one kind of software which is intended to be used at work. But all the other provisions, they aim to also be applied to citizens, to customers, to everyone, right? So of course we take the labor law angle, but this is only one impact and one consequences of this act. So the proposed regulation on AI. Once again, also the fact that it's an horizontal regulation, it doesn't regulate AI as a technology, but rather how AI will be placed on the market and put into service, which is a bit different. Once again, we just try to see how in a safe way we can ensure that this is integrated well in society and to some extent at the workplace. So for this, the AI Act adopts a risk-based approach. So there is a difference between 4 degrees of AI, unacceptable risks, or the AI that represent an acceptable risk, sorry, the one that represent a high risk, limited risk, and minimal risk. And depending on in which category the AI software falls, then there is different rules. So if it's considered as an unacceptable risk, which is the case for real-time remote biometric identification of natural person in public space, for example, but this one is allowed in certain situations, but normally this is completely prohibited. Like when it's an acceptable risk, it's completely prohibited. Then when it's high risk, this is allowed, but if you follow some requirements and some assessments. So we recognize that there is a high potentiality that will cause a problem, but we think that if we frame it correctly, it will be fine. Then there is the software that represent limited risks. And in that case, so for example, AI systems that interact with humans, that are used to detect emotion, manipulate audio, image, or video, and these kind of things. Sorry. And here, basically for this one, for this limited risk, you just have a transparency obligation. So this is not a huge conformity assessment as we have with iRisk. It's lighter obligation. And then if this is minimal risk, this is simply allowed. So yeah, that's the 4 category. Then, so once again, the one that is interesting for us is the iRisk. And there are different obligations, not only for the provider of the high-risk system, but also for the user. There is a question of risk assessment to mitigate the risk that the system, when it's deployed, might create. There is a question or at least an attention paid to the quality of the data set that is being used. At least in theory. There is also provision about how do we keep the log of the activity and how do we ensure traceability, which is also an effort of transparency. There is also a detailed documentation providing normally all the information necessary to understand the system, not only to the authority that are going to provide the conformity assessment, but also for the user, and appropriate. Normally, there's supposed to be an appropriate human oversight to certain measures to minimize the risks. And of course, cybersecurity is a big provision within this for this high risk system. Why is it interesting for us? It's because all the AI that is going to be used for employment and or the management of workers are considered as high risk, which means that all the obligation that apply to all the provider of high risk apply also for the one creating or developing AI that is intended to be used either for the requirements, selection of natural person, so of workers, but also for all the recruitment, but also for the conduct of work. So when it's used for making decision, either the promotion or termination of the work contract, but also for the allocation of tasks, for the monitoring of the evaluation, and basically how, once again, we evaluate the worker and the performance at work. So this is why, once again, we are at the beginning of it. There are many research saying that this is only going to increase. So we need to pay high attention to this. So the problem is about the overlap. So I told you that in the AI Act, the employer can use some AI for different purposes at work. There is some provision applying to him as a user. So he can benefit from some information from the provider of the software. And he has also, as a user of the software, has some obligation about the keeping the log and this kind of things. The problem is, as soon as this AI is implemented at the workplace, there are other laws kicking in. Example, the OSH legal framework. So I'm sorry, because this is really technical for non-EU people. So I would be happy to have questions after. But what I want to say is that there is basically an overlap of the role depending on which law you are under. So for labor law, there is the employer having obligation towards also the workers. And here there will be an overlap, let's say the OSH obligation to assess the risk at the workplace that might arise from new technology. And there will be, the question is how it's going to interact with the information the employer will get from the provider, because this is not clear. So for example, the provider has to assess some risks that might arise when in the context of the intended purposes of the software. So normally the provider is supposed to already do a first batch of assessment. The question is, this assessment, how will this impact the risk assessment that the employer has to do to prevent psychosocial risk or cognitive overload of the workers in the way this technology will be implemented at the workplace? We don't know. Also, there is an obligation for the employer to consult the worker and the representative in Europe, especially when it comes to health and safety. When? On what workers are going to be, well, consulted? What will be the space for the discussion about AI? Will it be possible to discuss the pace, to discuss the parameters, to discuss customization of AI? How, what, you see what I mean? Right, this question of the double risk management, basically, this is not clarified as of now. There will be a clash in between these two, and we still don't know how they are going to really work in a coherent manner together. Even worse, there is a risk that depending on how the AI Act is setting some standards, that will limit the consultation of the workers at the workplace, that will actually limit the freedom and the rights of workers within the organization of work. And this is extremely worrying. So there is, sorry, it's already 20 minutes. I hope I'm not too fast. So once again, not only there will be clash, but there is also gaps in the AI Act. So I worked with my colleague Miriam Coleman on the fact that of a deep analysis on the AI Act, and we say that basically this AI Act is offering a false feeling of security. And basically our main argument is that the AI Act does not exist as a standalone piece of legislation and should be considered carefully in respect with existing labor legislation. A bit what I have said before, not only with OSH, but with all other like EU labor law, including discrimination law, for example. And due to the specificity of the work relationship, the imbalance of power that we are all aware of, I think, the provider should be aware of that and be partly responsible for the effect that the software that he's designing when it's intended to be used at the workplace will have on this relationship and on this power equation. So we need, it's okay to promote the AI on the market and all of this, but we need to be sure that when this is touching work, we provide strong counterpower to rebalance the dynamic at work. And here, basically, I have listed 5 main points where in the AI Act, we have problems and how we should address them. So for example, at the moment, is considered only as high risk AI that are intended to be used at the workplace, you know, and we then only, but the problem is it's quite limited. Imagine something which is not intended to be used, but then in the foreseeable, reasonable foreseeable misuse, this is. So this is the problem, a bit of the discrepancy between how this is thought and how this is used. So here there is something that we need to have a bit of a pragmatic approach, and we need to have a broader scope and broader understanding of what is understood as high risk. So the obligation that exists right now will at least maybe benefit and provide some protection to further software and AI that will be placed on the market. Also, when this is designed and this is possible, the provider should leave space for the social partners. When a provider knows that the software is intended to be used at the workplace, it cannot ignore the reality that it will take place in and it's going to be deployed in. So you need to basically, maybe it's with customization, leaving space so there are meaningful discussion at the workplace with workers and the workers' representative. This is really important. And of course, we need to find ways to have full transparency on how data is collected and processed. And we need to be sure so that the data that are used for the design of the AI is suitable for the workforce that is going to apply to, because there might be a gap here as well. So we need to be careful with this. Also, for the post-market surveillance, of course, once again, we need to leave space for workers' representative to bargain and to adjust how AI is deployed at the reality of the workplace. And one of the biggest problem I see with the AI Act at the moment, I'm sorry if it doesn't make sense without the provision, but this is a huge act of like hundreds of pages. There is one part is there is an over-reliance on provider self-assessment, but also on mechanisms if something goes wrong. So this is a huge issue because at the moment, if the end user of the AI, which is the worker, is faced with a problem, with a faulty, I don't know, a faulty application, or I don't know, existence, a faulty, you know what I mean? That if it goes wrong, something goes wrong with the AI, the worker will be the one facing it. But at the moment, what he has to do is report to the user, which is the employer, and the employer has to report to the provider. And then the provider has to report to the authority. What is the likelihood of that? None. So we need to be sure that workers and their representative has reporting mechanism, independent one to third-party authorities or agencies. This is really important as a concept of counter power. Sorry if I'm very enthusiastic about this. So Also, there are already some solutions that have been put in place. EOSHA has identified gaps, but also what are the actions that are needed? So it has been published in 2022. The question of design and including the workers in the phase of the design already. So, for example, the fact that to mitigate the risk, for example, of discrimination, we need to discuss, we need to have workers included when we do the risk assessment, when the provider is doing it, because this is already when it starts, it's not only when it's implemented at the workplace. So that the discussion and the taking into consideration, once again, the reality should start early. There is also a real discussion that has to happen when it comes to worker privacy and data protection and the concept of workers' consent, because at the moment, yes, we have the GDPR in Europe, but there is also a possibility to keep collecting data if the workers give consent. Once again, what is the reality of that in the context of imbalance of power? We need to question that at some point. How true is consent in this condition? And this here, when we talk about how data is going to be processed and how it's going to be used, that takes a complete new dimension. So this we need to be careful with. Also the concept of AI literacy, the right to having explanation and balance of power. So yeah, this kind of thing need to be addressed. And just one thing also why we need clarity. I will try to be brief here. So this is from McKinsey. We all know McKinsey, right? So they also have an understanding of the AI Act for businesses. And they offer to businesses advices on how it will change their approach to business. So really interesting. They indeed promote the implementation of routine of conformity assessment, establishing an AI governance system, and building an inventory of AI. Really good. They even say that the organization should convene a committee that ensures that AI is responsibly developed and deployed through the organization. That's promising. Problem is, I look at who is supposed to be in this committee according to McKinsey. That should involve legal professionals, tech professionals, data science. Where are the workers? And this is the problem at the moment because this is unclear. There is no mention of workers as end users in the AI Act. We can do all the good work we want as labor lawyer, trying to support the workers. If there is no clarification, this is the understanding that is going to be communicated on the other side. So this is why we need clear rules about how AI is going to be deployed at the workplace. And once again, this discussion has been happening for a while, and a lot of people have done amazing work about it. So once again, not only EOSHA, others, I'm going to present others after, but there is concept that we need to develop further, and we need to translate into legislative recommendation, the concept of adaptive, socially and emotionally intelligent robotic. This is key, the fact to have ethical framework for digitization as well. Prevention through design. All of this, we have been talking about that. Why nothing of this appear? Like this is, for me, I find it crazy. I mean, this discussion has been going on for a while. And here I want to say that I think there is something that I find really interesting that some colleagues are working on actually in Oxford. So this is Jeremiah Sprassel and his entire team in Oxford. They developed the idea with also other experts, actually like Phoebe is in charge of here. So of having a directive on AI. And one of the idea that he's putting on the table, or they are putting on the table, is again the risk-based approach. It's saying that rather than ensuring that AI managements are deployed and we just mitigate the risk, before deploying it, we assure that there is a fair reason for it, that there is a need for it. And it's only feasible if this follow the requirement. So it's not we just put it at the workplace and then we have coping mechanisms. If we thought through before and we have a clear justification of why we do what we do. Is it necessary? And how it is done? Is it done in an adequate way? So, I mean, I'm not going to read that because I hope maybe we can go back into that, into the question. But this is the question, and the key message is like, it's not because we can technically do something that we have to socially do it. Maybe we have to restrict ourselves, especially when it comes to workplaces and the risk of contributing to the imbalance of power. So I think that was a really interesting idea. And also to complete the question of having a human oversight, he is going into more in depth, and that actually echoes other research and ideas that have been put on the table by colleagues, is the question of having a human before, in, after, and above the loop. And this is thing that basically resonate with a lot, once again, of proposal from other colleagues. So before the loop is the right to information, consultation on the configuration of the algorithmic management system. And here, Antonio Aloisi and Valerio De Stefano have been talking about that for a really long time as well. After the loop, the right to know what decision has been done, how they're done, the right for individual to appeal, to request also to have written explanation, to talk to a human about it, and having the right to have it rectified if it was done in the wrong way. And also above the loop, the employer having the obligation to have an algorithmic management impact assessment. Here we can have discussion on how it resonates with the data risk assessment and the OSH risk assessment, but still it's really important. And once again, all the researcher has done that and said that, like Aida, for example, Ponce de Castillo at ETUI. It's my last slide, so I swear then we can start the debate. But I think what is really important to remember, I said that at the beginning, is that how we approach AI in Europe is a choice as of now. But regulating is a choice as well. And I think it's Antonio Aloisi and Valerio De Stefano in their recent book, Your Boss is an Algorithm, they phrase it in a really nice way. They said, innovation does not take place in an institutional, political, and socio-economic and cultural vacuum. It occurs in ingrained value sets and web of norms. And this is true. I mean, this is not disconnected from the rest, and we need to take that into consideration. And they also make the great point that regulation actually can help to provide also safety for the companies on how AI is going to be used at the workplace. And we shouldn't refrain to having regulation dedicated to employment rights. And once again, there are ideas, and we know that there are points now that need to be addressed when it comes to employer responsibility and liability, when it comes to privacy and data, when it comes to explainability, when it comes to surveillance. We know what we need to talk about. Why it's not there? Why we haven't had a parallel directive at the same time we had the AI Act? It's not too late, but we need to do that now. So the conclusion is, the way we will decide about how to regulate AI, it's once again a choice. And at no point the race for having economic opportunities and innovation can justify to leave workers unprotected. It cannot justify to just block and neglect what we have been building in terms of labor protection. And there is the need to respect what has been done and actually to be having a coherent approach here. So we need to match the technical regulation with social one, and we need to act now before the problem that we know will arise actually materialize. Thank you very much. Sorry for the long presentation. Now we can go back into the detail, and I'm looking forward to the questions.
No, thank you very much, Aude. So what we're going to do as well, because at 5 o'clock we have scheduled, obviously there was a restructuring of the schedule, but so the project team are going to be presenting some of our findings in terms of implications for the world of work. And you have already mentioned quite a few of those, which is really excellent. And with the other speakers as well. So what we'll do is the best thing about that is that we'll get a chance for discussion then on exactly some of the points that you've mentioned. So we've got 5 minutes now, and then given the case study just to follow this has to do exactly with these topics and picks up just on that, then we hopefully you'll be able to stick around and we can integrate you really carefully and closely into that discussion. But I know Peter has a point. Go ahead. And any other questions or?
Oh, no, I thought it was really interesting, and it's a very, I guess, and we can maybe pick this up in a discussion point or if people are interested, but I had two questions. The first is that it seems that, you know, the ETUI and the kind of ways in which you're thinking about this is very much in a kind of liberal mode of consultation and explainability and consent. Now, I think that that can be a very good framework, but I think one thing that can be missed about that is that it is a lot of labor for people. And we're already seeing with GDPR in a certain sense and with data protection that in a certain sense, the more you ask people for their consent about things, the more they get tired of being asked. And the more they don't want to respond to this, the more they don't want to engage. And if you know, having some of the research I've done with McKinsey and AI, because it's interesting you brought up, is that on the opposite side of that, they're reducing opportunity costs for employers to use this all the time, right? So on the one hand, you're kind of increasing opportunity cost and the amount of work for employees to engage with this. And on the other hand, you know, I mean, you're kind of, you're seeing a reduction of the amount, and you kind of brought this up in terms of how employers use AI. So I'm just wondering about that. And the second, if it could be more provocative, because I'd be interested in your viewing this, like I thought it was very good, but I wonder if this kind of human in command is fetishizing human management. And the reason I say that is because, you know, if you look at what other groups are doing outside, there's a whole range of things about how do we make actually AI decision-making more progressive? How do we make it actually more accountable, but also how do we kind of repurpose it? And part of the issue is that we don't want to fetishize the idea that like human management is better in a sense, because it's in many ways, the AI is just reproducing already existing human values that are at stake. So I'm wondering if we're at a risk here of, you know, focusing too much on minimizing AI and bringing back the human as manager in a sense that isn't maybe getting to the core of the issue, which is power relations between employees and employers.
Thank you very much for your remark. Just quickly then, if I can address them, I think about like the interest for people being consulted about the use of data will maybe reemerge with algorithmic management. I didn't care that much about, I don't know, cookies, about, I don't know, how I use certain software, because there is no implication. You collect data, maybe some GDPR. I mean, this is different. Here, we talk about something that really like influence how you get task allocated, how your career progression, if you can lose your job, like the impact of how this data we are talking about is going to be used is a bit different. So here I bet the interest of people will raise and will increase, and they want to have a word to say, but we can see if I'm wrong or not. But this is why it changes. And about the fetishizing the human in command, I don't, well, we have to remember what you said, it that AI once again is reproducing and it's learning from previous human decision. But there is one thing that AI is not doing, is the communication, is the actual human part. And I mean, there is research saying that there is only so much that AI can do, and the feeling, for example, of justice, or there is thing that they cannot reproduce. You know, there is thing that you need to communicate with the human. You cannot really completely remove the human from the organization. So I think it's not fetishizing it, is being sure that at some point we're still having work which is humanized. Which maybe I'm an idealistic person here, but this is, I think, how I see it. It's a tool. AI is a tool, but we cannot get rid of human management, even though we cannot like it and some managements are terrible. But AI won't solve that.
Attard is going to ask a question, and then we'll go to the next session, which again is very much linked with your presentation. So that will be a chance for more discussion too.
Yeah, thanks, Phoebe. Thanks, Aude, for this great presentation. I mean, I actually had a related point to what Peter was mentioning, but specifically one of the issues that you raised about why do we actually use AI in management. And I wanted to, you know, ask you specifically on this point. My impression is, and I have a bit of data to support that AI is not being used in management so much because companies want to survey workers and monitor them, but rather for compliance reasons. If you look at the current development of AI tools, most of them are focused, not most of them, but a large chunk of tools are focused on business process automation. So anything payroll management, issues related to auditing and compliance related issues, etc. So there's a lot of activity and a lot of tools being developed in this, you know, to kind of just catch up with red tape, if you want, and not so much. I mean, these tools exist as well, but not so much in terms of for specific management as it's properly understood. And the kind of piece of evidence I have for that is, if you look at the data from the European Company Survey, what's actually interesting is that if you compare companies depending on whether they are using some of these electronic tools or digital tools, and to what extent that they have unions and in their companies to deal with, those companies who have stronger unionization or stronger trade union representatives, they're actually typically the ones that are using more these tools. So the question is, are they using them to supervise and kind of compete against the trade unions, or are they using it in collaboration? Especially if you think about you have management co-determination systems where workers sit in the boards of companies. So I'm just wondering, to what extent can you explore a bit more these issues of what are we actually using these tools for? Is it really only for surveillance, or are there more issues than that? Thank you.
Thank you very much for your remark. So maybe I'm a bit alarmist because I only have half an hour, so I focus on the gaps. But of course, there is also use of AI that can be used for goods. It can also, there is example of AIs that are actually used for reduction of the exposure of workers, and AI offers a lot of possibilities and opportunities as well. So I think if it's used as well for, helping workers to actually like having feedback and reporting mechanisms, that's really good. And I have nothing against that. I think what I was trying to say is within the cases, and we have many examples as well of AI being used for monitoring and for surveillance and for discipline measures. For this one, we have to be explicitly careful. It doesn't mean that all of them are being used for that. I just focus on the one that puts people in more vulnerability, but it doesn't mean that the other side of the coin doesn't exist. So I don't know if it's addressing your question. I'm not saying that AI is completely bad. I'm just saying that we have to be extremely careful on foreseeable risks.
I think your points are good, and you're mentioning the use of various technologies for OSH prevention and for OSH protections, and that is there's a lot of scope for looking at that more carefully, because of course there's the purpose limitation point, and I think that's necessary to think through in terms of compliance, because clearly there's the idea of the Trojan horse kind of question. Are technologies being used for purposes other than they were set out for? And in fact, the AI Act tries to deal with some of that with its ex ante and ex post kind of delineations. And those are very clearly introducing some of the, I would say, major potential points of contention and tensions as the AI Act is being still negotiated. So what I'm going to do now, because this next session is explicitly right now on the AI Act, I don't think I'm going to say take a break, just because we're going to soldier on for one more hour, which is what we're doing. And then obviously we'll have all the chances, but if people need to pop out, that will be absolutely fine as well. And thank you so much, Aude. I'm really hoping that you're going to stay, because I want you to be part of this discussion. Because again, now we're moving into the section for the team, for the researchers who've been working on case studies. In my case, I've put myself, as it were, in the position of doing the EU AI Act, specifically on the European Union side of the discussion. So I'm going to share my screen so you can see the kinds of points I'm going to raise. You've already, so I'm not going to actually today give you a masterclass in how the AI Act has been negotiated over the last few years, but it is still under that process of negotiation. You have 3 bodies involved. The Commission writes the first draft, and this is the one that's being analyzed right now, and the only one we can really talk about. But what we can, as being, a document that's in stone, but the discussions are around that, and there are a whole range of amendments that have been tabled and discussed, and they've come from the different committees in the European Parliament, as well as the Council for the European Union. I actually don't have, when I'm trying to share my screen, Alessandro, I don't actually have my PowerPoint available, and I'm not really sure why. Do you have any idea why that might be? Because I have some slides which I think will be quite useful. Let's have a look. Alt tab, okay. I know I should, but I don't. Can you see it? Okay, there you go. Oh yeah, okay. I have too many things open. The only issue is now I need to, thank you. Thank you, Attard. Okay, I'm going to share the slides. Okay, so, and I also appreciate Alex's interventions earlier, because you've already started to illuminate some of the potentials for comparison. And it might happen that there are some kinds of replications. This is going to have potentially a Brussels effect. But technically there will be an obligation for products and services that have the intention of being set up in the digital single market to go through a period of certification and assessments. And they will be within something that within the AI Act is called sandboxes. Those will be set up in the various parts of the EU where tools will be assessed as to what extent they will pose risks for people who are involved in that process. And the big problems that are already emerging in discussions around this, it being again a European Union intervention, and the regulation is the first, as I said before, hard law attempt. Oh, I'm hoping, can everyone hear me? Yes. Sorry, I was gonna. Anyway, first hard law attempt at organizing some very strict regulation. But the question here, even though it's been made very early on that this is intended as a human-centered regulation, the question has to be, which humans are we in fact talking about? And I think it was good that Aude mentioned some of the work being done on humans in the loop, above the loop, around the loop. So you have the group at Oxford University, we have people at Newcastle University, and there's a lot of work in this space where these questions need to be asked. So what's missing from the human-centered policy approaches, which are proprietarian and dignitarian? This comes from the Yale Labor Law Journal. And the point here when looking at relations and questions around regulation around AI is that proprietarian and dignitarian. So if we want to look for something that can be a harms reduction thesis, which as Peter mentioned at the beginning in your keynote, if we are to talk about a typology, if we are going to think through the maybe even necessity for harms reduction, given we're talking about technology with unpredictability, this is the definitional, the definitiveness of this actual service and technology, is that it will have some element of unpredictability about it. Machine learning means that there are new questions being asked by a machine that do not immediately have human intervention. So once again, when we say human intervention, are we actually saying that we don't think AI will ever exist? And that is, of course, one plausible explanation for it. And there are people talking about this. And I think it's necessary to do that. And there's a necessity to talk from a technical level, as well as think through what kinds of policy approaches are, what is the ontology behind some of the approaches, and thinking through a harms reduction thesis. So proprietarian, so this has a reform methodology which sees data as property, and property it should be in the ownership of the data subject. And while I agree with this, it still puts there's a potential vulnerability around a data subject in the sense of their being individualized. So that's the first potential problem. And this, of course, is also part of the argument made in this piece that I think is very interesting and important. Then the dignitarian approach, the dignitarian reform approach. This means that a data subject has, of course, a right to self-articulation, and this is in a state of erosion, and there are challenges to autonomy. These can only be resolved by revisiting and reestablishing fundamental rights. Once again, the European Union's approach does clarify and makes a real effort to highlight fundamental rights, and that's there. The questions can come about in terms of whenever you have a harmonization effort, which is of course how these regulations are organized. Harmonization means that there is a whole range of other laws that must be also compliant, or there must be a possibility for compliance coming out of them. There's already questions coming out around the machinery directive, the discussions around AI, of course, as Aude also mentioned, AI as a service, rather than strictly speaking a product. Because if the activities are invisible, how do you highlight that as a harm, A, and B, how do you create some kind of liability? There's an invisibilized dimension that is inherent to algorithmic management. And this has been discussed in some of the literature. I think it's worth saying, especially when we talk about algorithmic management in the broader context, going beyond where we're talking about office spaces, we are talking about different industries, we're talking about manufacturing, we're also talking about knowledge work and so on. And then if we emphasize the world of work, the point here then is that we need to talk about a multiplicity of social relations. People do not exist in this kind of vacuum. They're not suspended in midair. individuals operate within an ecosystem in the world of work, and the relationship that a data subject has is not only bilaterally with the data protection officer, not bilaterally with the boss, quote unquote, whether or not the boss is observable, and not only with one other colleague, as it were. So that social ecology question, the social relations question, we are not talking about just individual data subjects. And even if we are, data subjects experience the world themselves, depending on which data subject category we are referring to differently, and also face different harms, depending on the context. Data sets are necessary for AI to exist. This is one of the reasons you always hear about data and privacy protection, but data sets are not data subjects. And I won't give you, because even within GDPR, the definition for the data subject is embedded within the discussions around how to understand identification, which in itself has its own potential issues. But within the GDPR, we see more mention specifically in this category. And within the AI Act, there are delineations around the different possibilities for harms. Now, as Aude has already mentioned, and as I think is well known to this audience, there are categories of risk. And because the legislation is intended to provide safety and so on, we have to think, what does risk mean? Occupational safety and health. So when we discuss this within the occupational safety and health arena, what we mean is there's risk for harm, and that has to do with, in typical OSH discussions, slips, trips, falls, fire hazards, and so on. When you get into the psychosocial realm and psychosocial domain, which of course is what is becoming increasingly what is at stake in the working environment for work and in the world of work, when we see, new kinds of relationships, new kinds of technologies entering the workplace that I referred to earlier, we have different kinds of data subjects. So the reason I've simply compared the consumer to worker, obviously we have citizen, obviously there are protected characteristics which are protected within regulation. This is the beginning of an argument where I'm starting to think through the risks that are faced, the hazards that emerge, and the harms that are potentially there are different depending on the data subject. Now, how can that be resolved? Well, we're starting to think that through. I have been part of the amendments phase for the AI Act, and am working on specifically the Race to Regulate project that Aude and I are writing something for that specifically with the Oxford group. So our interest and our intention is to say, right, so if we are going to talk about decent work, if we are going to look at the potential obstacles for decent work and so on, we have to emphasize these areas. I think it's fairly clear with rights at work, with fundamental rights in the EU AI Act, we can find some elements of that within the high risk categories and technologies that are being used with AI augmentation and in terms of services. If these are used in an employment context, then they should go through this period of certification. Again, I wanted to ask the question, so who are the humans in the loop, on the loop, and so on? Who is the human intervening? What kind of qualifications does that human have? At what stage will the human be required to intervene? Who sits within the sandboxes, because that's what they will be, as I've told you. Who is resident within those and employed within those sandboxes? Is there going to be specific certification schemes for also qualification for education that will be required, and so on? And again, who makes the final decision? Given the context of work, the workplace, and we talk about decent work in the world of work, we are talking about employees, we are talking about workers, we are talking about management. Decision-making processes do not exist in the same with the same capacity for the data subject as worker. Consent is not identical to choice, of course. Choice might be possible for a consumer. Is choice possible for a data subject who is a worker? And if you just to look at that in terms of this table that I'm developing, so the consumer has possibility for consent, yes, maybe, worker, yes, and then a question mark. So we need to think that through. So far, there's identical types, identical possibility, supposedly ingrained into the way that policy is being written, but is that actually present in terms of the social relations of data production and the social relations at work? I'm not going to, again, do a masterclass in terms of how the AI Act comes about, but it is worth telling you where we're up to in the process. So we're in between the draft report, the committee vote. We've got the bodies now discussing what they'd like to see changed. And because today we're talking about implications for the world of work, I'd like to mention what the proposals are, because that will have potentially quite significant impacts into thinking through what will it mean to have AI services in the world of work. Okay, so let's say, I'll just explain to you what precisely those are. Actually, I'll tell you also the approach that was selected, just to kind of let you know, and then we'll go straight into the world of work. There were a range of processes whereby the commission went through an impact assessment process. And the choice that was made obviously has to be balanced. So again, you have the digital single market and you also have human-centeredness. So in order to fit within the new legislative framework, the horizontal EU legislative instrument following a proportionate risk-based approach and codes of conduct for non-high-risk AI systems. What that means is that, of course, if the product falls within the service falls within the non-high-risk AI system, then you should write your own code of conduct, as it were. Now, there are a lot of question marks around this. And obviously, we know what the kinds of risks there could be for workers around this, or of course, potential benefits when we're discussing safety and health products and services themselves. But I think it's important that it's interesting to look at the choice that was selected, which probably has benefit over a sectoral or more ad hoc approach. Alex referred to the centralized approach, bearing in mind that there will be decentralized compliance. So it's decentralized at the compliant level. So you've got already part of the discussions are who's going to make these decisions, in which, are we going to have just one office doing all of this, all of the kind of compliance work, or will it be, a lot more decentralized? But as it happens now, or whether it'll be more centralized as it happens now within this process itself, the centralized dimension it has to do with the harmonization and also has to do with the risk categorizations. And the decentralization comes at the level of ensuring compliance. So anyway, I'm not going to go through what the risks are again, but I think let's just quickly go into the employment, management of workers, and access to self-employment. So all of these AI services are considered high risk and should go through this process. One of the questions that was alluded to also in Aude's talk is the intended for application. So this intention for, so does that fit identically within GDPR purpose, limitation, and data minimization? Obviously, these are the kinds of tensions, and Michael Veal has done quite a lot of work in this area as well to identify what some of the probably quite quick kind of ambivalences will emerge depending given the already existing quite strong data and privacy law existing within the EU. Okay, so I'm going to go quickly into this and then begin the next phase for the day of discussions. Anyway, so one of the proposals that the Council for EU has raised is a complete deletion of the Annex 1 on AI techniques and approaches. Now, here's the list of approaches: machine learning, supervised, unsupervised, and reinforcement learning. So some people are talking about this as a watering down, and there's also discussion around general purpose AI. Now, what this will mean in terms of rolling out of technologies and services in the workplace potentially could mean that any technology that is not in this list then could be considered low risk. Is that right? And how is that managed? And if we get rid of it altogether and we only have general purpose, what does that actually mean for the legitimacy at all of the EU AI Act, for its authenticity in terms of, or its practicability? Those are the discussions going on within the debating frame, within the European Parliament, in particular within the various committees, and of course within the Council for the EU. So that's one of the discussions. There's also a list of in terms of the list of high risk use cases, which is in Annex 3. This is changed, and the recommendation there is to delete all categories in insurance setting, biometric categorization, environmental protection, pollution control, and deepfake detections. Now, if these are no longer seen as high risk categories and the implications in the workplace. So there are already cases where in transportation services, facial recognition technologies have already been used. There have been headline news around what happens next, and what does it mean in terms of identification? What does that mean in terms of privacy, and so on? So the rights at work question within the decent work frame is clearly potentially challenged with this, right? So to eliminate this as a high risk technology means that does that mean then that it will simply be rolled out and does not need to go through any conformity assessments? And that could be very tricky and difficult to look at. Okay, so the main points of contention there potentially within decent work, we've got privacy, security, healthy working environments. We've already seen within algorithmic management, the quota system, the ranking system, the push system whereby working time is accelerated. And of course, if this is occurring in an increasing number of industries and sectors, what will that mean in terms of workers having the capacity for determining their own working schedules? So that's autonomy question and dignity question. Very quickly, we can see the possibilities for how this could, what kinds of risks could emerge. Okay, so we've got fundamental rights 3.5. So this is on the more positive side. So in the fundamental rights listing within the draft as it stands, so the obligations for ex ante testing. So this is where there's again that predictability, the prediction of what could happen in terms of the usage and the rolling out of the technology and AI service. So risk management, human oversight, facilitate the respect of the other fundamental rights by minimizing risk of erroneous or biased AI assisted decisions in critical areas, such as education and training, employment, important services, and so on. So in case of the infringements around this, effective redress for affected persons will be made possible by ensuring transparency and traceability of AI systems coupled with strong ex post controls. Okay, so this is seen as quite radical, quite different from the other types of approaches that we've got in our case studies so far. So the fundamental rights point, and we need to very carefully parcel that out. We're going to do that within our regulation tracker, where we're keeping up to date with, for example, in the amendments phases. So we're not doing this explicitly now in our tracker, because obviously we're in the proposal phase for this observatory, but I think it'll be really important to keep track of even maybe the discussions and where is the responsibility going to lie when that changes. So the Council for the EU, we have the Czech presidency right now. And, there are specific things we need to keep an eye on, because then that helps in terms of negotiating around the world of work and potentials for decent work. Okay. Then Article 54, this is when I picked up in the measures in support of innovation, because clearly we have innovation as part of our development categories. Got regulation, governance, and innovation as our categories for research and for the observatory. So in Article 54, the measures in support of innovation, this is interesting because it basically says very, very clearly the data that is used in sandboxes should not be handled and requires care, that any processing of personal data in the context of the sandbox do not lead to measures or decisions affecting the data subjects. Voila. So you have a decision-making explicitly addressed there, and also the use of data. And once again, all of us understand how harmonization works. You can't put something into the legal framework into the legal and the regulatory space that will lead to somehow instantaneously a kind of non-compliance in another one of the existing regulatory bodies, instruments, that is. Yep. So that's kind of important. That's really important to think about. Obviously, frameworks. So the OSH, we've got the OSH framework, we've got other directives, but something that Aude and I are trying to say is that, okay, so we need to keep an eye on what's happening with the AI Act. We need to think, do we need a new directive on this? Do we need something that more explicitly deals with workers? Because again, I think it's going to be quite difficult to create a set of policies that will provide the level of protections and so on against the worst cases in the risk trajectory. So does there need to be something more tailored, more specific? Will it be the case that we can simply say, well, the local labor law can be operationalized, but will that matter? Will that again come into some kind of contravention or ambivalence around the newly introduced AI Act? Okay, the final thing to say then, employees and workers as humans in the center. So again, these are some of the again, taking from the debates and discussions, because I am working with policy advisors in the Parliament, and these are some of the kind of critical areas that are going to mean that it's potentially going to take another year, and in order to get to that trilogue stage where it is actually hammered out. So at this phase, we have the kind of positions, and now we'll go into the next phase when the final reports are published, and then the final actual negotiations around the final AI Act. Okay, the decentralized approach, again, this I found really interesting when Alex mentioned it. I wanted to ask you, and hopefully we get to have a discussion about this. Again, who's involved? So who is the final deciding the decision maker. The scope, again, mentioned this already, which technologies are included in which risk categories. Will there be, there will be technically within the process as it works already. So there will be chances for there to be some kind of revision, but that there's a possibility of that being under also under the microscope for revision, but so far we still have the possibility for iterative changes and for additions for new types of technologies. That is, if that technology list stays at all, right? The AI systems and technologies. Okay, the definition, if a kind of technology again is excluded, will it be subject to conformity assessments at all? And then finally, the question of intention. So what we're trying to do, if we are taking a philosophy of policy and kind of more psychological dimension, which is important when looking at social relations as they apply in terms of the world of work and thinking through what decent work actually can mean. I think we need to take what may look like fuzzy concepts and actually deal with them now, because they will have implications for what happens in case law that will go to court. We have had a few cases already with algorithmic management. The very famous one with Barbulescu, with the use of personal communications at work. So these kinds of legal, I would say, issues that will quickly come to the fore. And this is why right now is very, very important time to be involved in these debates and discussions. Okay, that was really what I wanted to say, and looking forward to continuing the discussion with, again, our experts and with the team. I'm going to ask if any of the team wanted to come back with any other presentations based on your case studies. There's a possibility to do that now. And do you want to go ahead and as you like? Yes, why not? Of course. This is a chance for us to give a sense for where we'd like to go with, I'm going to stop sharing. Okay, where we'd like to go in terms of talking through the implications for the world of work in the policy and regulatory space. Okay, thanks a lot. Go ahead.
So we already heard from Alex Engler about the state of regulation in the US. So I'm just going to emphasize some points that maybe he missed or like didn't have time to talk about. So just a brief overview. There does seem to be some continuity in US policy from administration to administration in the broad strokes. Alex mentioned that, for instance, that the Trump administration wasn't very interested in AI generally, but you did see some actions out of the Trump administration that you have not seen out of the Biden administration, such as executive orders. But generally what we see is the continuity is wanting to think of AI as a public-private enterprise with really private leading the way. The US government is very worried about killing the golden goose. They've used Silicon Valley as one of their key players and are nervous about having too much regulation, similar to the case of Brazil. So you did have some movement from the Trump administration. You did have an executive order in February 2019 listing, the 5 key pillars of interest: research and development, infrastructure, governance, and workforce and international engagement. And I think those 3 that I've highlighted, research, development, infrastructure, and workforce, can play in a role and can have implications for workers. But for the most part, what we're seeing is, and this is continuing with the Biden administration, is the US government just is going to kind of be a piggy bank for private enterprise and public institutions to fund research into artificial intelligence. So when you get to regulation, you have what we might call a patchwork approach. And Alex kind of alluded to this, because power in the United States is distributed across, is federalist. You have a dual power system with the federal government and then the states having their own authority. You get this kind of patchwork system where some local governments are doing one thing, some state governments are doing something, the federal government is doing something, and so on. At the federal level, we have no comprehensive legislation on AI. We have Trump's executive order, and then in terms of congressional legislation, we have the National AI Initiative Act, but this is really just setting up task force to research, which is what you see mostly when any legislation is passed, even at the state level. A lot of times it's just focused on setting up task force to research, and the Algorithmic Accountability Act is still sitting kind of in Congress. So I'm not going to really go over the federal agency side because Alex covered that, but really that's where we're going to see most of the action come from, as he mentioned, with this kind of targeted approach through the federal agencies. The Federal Trade Commission is going to be a key player. The National Science Foundation and the White House Office of Science and Technology have been giving a lot of opinions and proposals. The EEOC, which Alex talked about, is going to be important. And then you have the Department of Commerce, which might be able to do something in terms of right now they're only really appointing experts to advise the president and commit to more research, but they may have avenues open to them. So if you're not familiar with the way the federal agencies work in the United States, essentially Congress throughout history has passed laws creating these agencies, and they direct the agencies to fulfill certain objectives. So all these agencies look back at their prescribed objectives by the Congress and go, given what we were prescribed to do, this is what we could do in terms of AI. Alex didn't really mention any specific state and local cases that I recall, but you are seeing some important ones. For instance, in New York, there's a law that's been passed that will go into effect in January to prevent automated decision-making tools to screen job applicants unless the technology has been audited already for bias. You're seeing California draft new rules around the use of algorithms for housing and the imposition of liabilities on companies or third-party agencies for using automated decision-making that has a discriminatory impact. So really, when we get to the issue of the world of work, what we see the United States approach appears to be is to kind of marry these two ideas of economic dynamism and efficiency with this kind of thin notion of social justice around anti-discrimination and that basically automated decision-making is and data privacy. So for now, what we see mostly is in the world of work is applicants are going to benefit from fair hiring processes, potentially fair dismissal processes. And Alex covered the new AI Bill of Rights, but as he emphasized, this is a non-binding white paper. And what's important to note is that because one thing I would add to his assessment of the success of the agency targeted approach is that the agency executives who leads the agency changes with every new administration. So it's risky. You might have one presidential White House that appoints very proactive agency leaders, but then you might in the subsequent administration have new agency leaders that aren't as interested in these issues or overturn what the previous agencies did. So there's always that risk. And that puts any advancements for workers in a kind of precarious situation. I just kind of built out this like overview of the regulatory approach because earlier I was thinking of comparing US and China. But I think that the main focus of the US is tackling discrimination and bias and this kind of social justice framework and issues of privacy. And the US still really lacks any kind of comprehensive privacy law or algorithmic law or law related to artificial intelligence. So workers are really just kind of waiting to see what these federal agencies do. And I think was Jamie wanted to, I mean, I can answer any questions, but if there aren't any, I think it was up to Jamie.
Great stuff. Okay, so we're in the final part of the day and we've given some tasters in terms of what we're thinking about when it comes to the world of work and to what the new areas of regulation within artificial intelligence specifically for today's discussion. So what this potentially could mean for the world of work. And of course, as I've said already, decent work. So I'm more than happy to open it up to the floor. I think we have a question coming from, let's see. Okay, so, okay. Are there any questions from the people in the room just now? Because what we can do now is actually open up the floor for discussion around any of the jurisdictions and the expert talks that have been given today. I know I have a lot I'd love to talk about with our speakers. Anything that the panel wanted to come back with as well? Eckhard, as my co-lead, Eckhard, of the project, I'm sure you have things. Oh, right. Okay, good. Okay, if there aren't further points or things that people wanted to raise, then again, thank you all for coming. Thank you very, very much for staying with us. And we really would like to hear back from the audience, from people who've come today. And of course, from the experts, we'd really like to hear what you think might be missing in terms of, next stages in terms of our proposal and what kinds of things you think really matter. We're getting already some communications in other channels giving us ideas of where to go next. And I think the comparative dimension is going to be really, really interesting, again, longitudinally, because we'd love to again, within the policy tracker and looking at what kinds of cases do emerge and how governments do engage with the kind of the wider civil society, with stakeholders, with representatives. Again, the point around data subjects, and we are talking about employees, we are talking about people who are at work. So what will that mean in terms of decent work in the world of work as we go forward in terms of this era of AI regulation? Go ahead.
Yeah, thank you, Phoebe, and thanks for all those who are still online with us here. I can see that the number has unfortunately declined. I mean, it's late in the day, even for those who are dialing in from North America. So great to have you all with us for the time here. I think it was extremely interesting, very intense exchange of information here with all our speakers the whole day. I mean, and I wanted to explicitly thank all of them for great presentations, for delivering us with an enormous amount of information that we now have to digest. I just wanted to quickly maybe summarize, because as I mentioned this morning in the opening, this is a technical workshop, so it is in a sense supposed to help us to come up with a first report, summarizing the ideas, summarizing what we heard this morning during the day, and then helping us, to, as an organization, kind of move forward in that debate. And I think it's important maybe to reflect on some of the points that we have heard so far. I guess the key point that I take from this is that regulation really evolves according to different dimensions. One of this is obviously the international regulatory framework. So it's not regulation doesn't evolve in a vacuum. It's being influenced by other jurisdictions. It exists within an existing regulatory framework with respect to pre-existing industry and workers' interests, and I think most importantly against the strategic national objectives. And I think that came out very clearly from, especially when confronting a bit the situation in the US and China and Europe. And for us, obviously, that means that what does it mean with what does these kind of regulatory dynamics mean for the evolution of this technology? How will they shape? How will they influence each other? And I think that was also my question earlier to Aude, in the sense that once we have these technologies in place, we see regulatory reactions to that, but that means that also the technology will change, shift under the influence of these technologies, and the question then becomes for us obviously how will this evolve, and most importantly, what will be the implications for the world of work to these changes. But I always have this one question I have to say, and I think that's something that we haven't heard today too much, which is how do people react to this? What is the human agency behind it? I mean, how people will use these technologies? And I think this is again for me an open question for after today's workshop, that we actually this human factor. We talk a lot about human in command, but I mean, we haven't really talked about the human factor so much in this area. So I think that we probably will need to reflect a bit ourselves on this and come back to this particular question, because it will mean that we need to understand, these interactions between technology, regulation, and the human factor, if you want to understand what we will see in the coming years coming out of this. So with that, I don't want to hold you back from your evening any longer. I know that you all have other obligations than just listening to these extremely interesting exchanges. I wish you all a very nice evening, very nice rest of the day for those of you dialing in from North America, and I hope that we stay in contact, stay in touch, and please feel free to reach out to us. I mentioned in the chat earlier this morning, if you have any suggestions, any information that you would like to share with us, please send it to us. There should be an email address on the website. Otherwise, we will probably set up a way for you to share information and relevant input that you think is helpful for us. So thanks a lot again, and hope to see you very soon again in these premises. All the best. Bye-bye.